What officer, madam? What officer, madam?
ಹೇಳಿ ಸರ್.
Madam, ಇದು ಲಿಸ್ಟ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಯಾವ್ದು ತಗೋಬಹುದು ಮ್ಯಾಮ್?
ಸರ್ ಅದು ಮೋಸ್ಟ್ಲಿ ಆಫ್ಟರ್ ಅಡ್ಮಿಷನ್ ಆದ್ಮೇಲೆ ತಗೋಬಹುದು.
ಆಫ್ಟರ್ ಅಡ್ಮಿಷನ್ ಅಲ್ಲ ಮ್ಯಾಮ್?
ಆದ್ಮೇಲೆ ತಗೋಬಹುದು. ಅದು ನಿನ್ನೆ ಅವ್ರ ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾಲ್ ಏನೋ ಹಾಕಿದ್ದಾರೆ ಸರ್, ಅದಕ್ಕೆ.
ಓ ಅಚ್ಚಾ ಅಚ್ಚಾ ಅಚ್ಚಾ. ಓಕೆ ಮ್ಯಾಮ್. ಸರಿ ಸರಿ ಮ್ಯಾಮ್. ಸರಿ ಮ್ಯಾಮ್. ಥ್ಯಾಂಕ್ ಯು.
ನೋಡೋಣ
ಥ್ಯಾಂಕ್
ಇರಿ
ಯು.
ಸರ್ ಒಂದ್ ನಿಮಿಷ, ಯಾಕಂದ್ರೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ಸ್ ಟೈಮಲ್ಲಿ ಏನಾದ್ರು ಇದಾಗತ್ತಾ ನೋಡೋಣ.
ಓಕೆ ಸರಿ ಮ್ಯಾಮ್. ಸರಿ. ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್. ಥ್ಯಾಂಕ್
ಮೆನ್ಷನ್
ಯು.
ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಸರ್.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್. ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್.
ಓಕೆ.
Changes will be outgoing and incoming. In this particular matter, the lordship had given a date of 21st, which date your lordship was not sitting, it has been put to after vacation.
Tesh,
For orders, the lordship heard the matter, the IA, and had posted it for order.
order signature with order pass. Generally,
ಅವತ್ತೆಲ್ಲ ತಗೊಂಡ್ರು orders ಅಲ್ಲಿ.
Gone before the,
Other bench 21st ಇದ್ದದ್ದು.
right,
orders
but
ಎಲ್ಲ
it was
ತಗೊಂಡಿದ್ದಾರೆ.
reserved for orders.
yes.
Reserved
we
for orders
never-
ಅಲ್ಲ.
Reserved for orders matters, we do not do like that.
This is not reserved, no?
Not reserved.
Then, what is the stage of the case now?
But your lordship had heard it on the IA.
What was the stage? Why it was, what was that IA?
The IA was, to,
ಆಮೇಲೆ ಫೈಲ್ ತಗೊಂಬನ್ನಿ ನೋಡಿ.
Malats,
Lordship, matter for-
2001 RFA Malats.
Give all the members.
Madam, two appeals arise to the same judgment for admission, madam, fresh matter. Your lordship may have it either tomorrow at least or on Friday, madam. Yeah, because there's a decree for possession that has been ordered.
Malats,
is one matter.
2021 RFA Malats. Been admitted yet, the respondents are trying to alienate the property, Malat can be had.
Lordship,
One
this is,
matter for
this
two-
is
But see,
disposed matter, my lordship. The matter is disposed for non-filing of paper book. Meanwhile, they filed a FDP. Now the commissioner report has been filed, my lordship.
You have filed application.
Yes, my lordship. No urgency.
fresh matter, my lord.
ತಗೊಂಡು first ತಗೊಂಡು.
but this one matter I request.
First ತಗೊಳ್ಳಿ. No arguments.
But
in that.
No, Malad, this to our family court decree, Malad, they are getting married and so tomorrow, Malad, this need is tomorrow, please.
During the pendency of the appeal, my possession is being interfered with.
ಈ
And,
ಕಡೆ
sir,
ಇರೋದು ಸ್ವಲ್ಪ
made a fresh application seeking temporary injunction.
Already
Fresh
sir,
matter.
application was.
So one, for stay of the decree was
Someone
filed,
press
that
it,
is to be
someone press it.
considered. my lord. Some urgency.
Your Honor, may I make a submission, Your Honor? Suit for special performance, Your Honor. For final hearing, last time date fix ಆಗಿತ್ತು sir.
Final hearing not possible. ಇಸ್ಕೊಂಡು ಆಮೇಲೆ after vacation ಬರಕ್ ಕಳಿಸ್ಕೊಡಿ.
That's all, sir.
Serial number 39, my lord.
Adjournments, page wise. Page 1, cell number 1 and 2. Page 2, cell number 3 to 5. Page 3, cell number 6 to 9. Page 4, cell number 10 to 13. Page 5, cell number 14 to 17. Page 6, cell number 18 to 20. Page 7, cell number 21 to 24. Page 8, cell number 25 to 25 and 26. Page 10, cell number 27 and 28. Page 11, cell number 29 to 31. Page 12, cell number 32 to 34. Page 13, cell number 35 to 40.
39, my lord. Kindly have it on Monday. One difficulty is that I have to trace that old sale tax laws. Monday I will have it.
Old?
Otherly, there is one of the question is sale tax. Therefore, I have to trace that old sale tax laws. That Monday kindly.
No, soon after vacation.
Alla, Monday it is not because execution is filed either. It was understood to be heard.
You
So,
have
I went through the entire file.
Execution next date is in December.
December.
Yes.
This is in December, list after vacation.
Very well, indeed. A date may be given, madam.
Date,
Any date.
2810.
28.
Great.
Page 14, cell number 41 to 46. Page 15, cell number 47 and 48. Page 16, cell number 49 to 53.
Lord, serial number 52, my lord, I appear for the appellants. Kindly, my lord, grant us some time.
Non-filing of memo, having served the copy and responded.
That they have received. That was posted for final hearing,
Was
right?
that to be served?
No, that they have collected, my lord, from the previous council.
Who is served?
No, no, the advocate, the additional advocate general, my lord, is appearing. He has collected it from the previous.
As requested by the appellant's council, list on after vacation.
Please.
Date,
2810.
Please.
28.
My lords, kindly, serial number 50, my lords.
Huh.
My learned friend, I appear for the respondent. The appellant counsel has informed that the learned senior counsel whom they have engaged was unwell and is recovering from dengue. So he requested for an adjournment. He had informed me, he said he'll be present, but I think he's not
Yeah,
here.
is appearing here?
From ALMT, my lords.
No,
For the, in the senior counsel, my lords.
This word come.
I think they have engaged Mr. Vikram Vuliol.
Not really. As requested, list on after vacation.
2310.
23.
Grateful, my lord.
Page 17, seal number 54 to 56. Page 18, seal number 57 to 60.
57. Our client has want to settle with the respondent. We are going to give proposal for settlement. Kindly fix the date after vacation, my lord, so that we can report the settlement if possible.
Adjournment on the ground that parties are trying for settlement.
Please, ma'am.
To report settlement, list on after 2 weeks.
2410.
Please, deeply obliged.
Page 19, seal number 61 to 66. Page 20, seal number 67. Page 21, seal number 68.
68, my lord. By mistake, I have not brought the file. After vacation, some date.
Who has proceeded?
Dabalig in ಹೇಳ್ತೀನಿ ನಾನು.
Responsible list on
411.
4. Yes.
Much obliged.
List number 2, ಆಮೇಲೆ orders ಎಲ್ಲ.
List number 2 ಯಾರು ಅವ್ರು ಇದ್ದಂಗಿಲ್ಲಲ್ಲ. ಯಾರು ವೀರೇಶ್ ಪೂಜಾರಿ ಇದಾರ? Yes,
So lastly, you, my lord.
whether they have served the copy on you, they have filed a memo.
There's no copy has been served on me, my lord.
Copy serve ಮಾಡ್ಬೇಕಲ್ಲ ಅವ್ರ ಮೇಲೆ. Whom do you represent?
My lords, for serial number 50, my lords, I just missed it by.
50. They have filed a memo for withdrawal. That is also
Please,
again,
Lord.
round, you can see that memo. It's clean office of
Lord,
section.
I'll request my learned brother to serve a copy on me, my lords, and then I'll
Office
assist the
of
court, my
section,
lord.
because the other day only we told when it was brought before us. Copy was not served. Can you appear at 2:30?
Because I was in Dharwad, I was assisting the division bench here, please, my lord. But my lord, I'll seek a copy of that, my lords, and I'll assist the court, my lords.
No, at 2:30.
I was in Dharwad, please, my lord. I was assisting the division bench here, my lord. I was not aware that they will move the matter, my lord. I apologize, my lord. Lord, if it is a simplified withdrawal.
Copy serve ಮಾಡಿಲ್ಲ ಅವ್ರ ಮೇಲೆ ಎಲ್ಲಿದೆ signature? Allowed counsel for response submits that copy of memo is not served on him. List tomorrow. ನಾಳೆ ಹಾಕ್ಕೊಳ್ಳಿ. Tomorrow?
Please, my lord.
List tomorrow. ನಾಳೆ ದಿನ.
Please. Please.
If I may mention serial number 50, my lords.
Serial number?
50. Apologies, my lords, I was still on the way. My lords, for the appellant.
Some
being-
took adjournment in this.
2310.
Oh,
Yeah, you represent Will Bolskolli.
sorry, my lords.
Yeah.
My lords, we are being led by Mr. Vikram Vuliol. Yes, my lords.
Saying he is not well. Yes.
Please, my lords. My lords, may I know the next date, my lords? Apologies.
2310.
23. Obliged, obliged.
List number 1 for orders, seal number 1. O Mahesh, AK Bhatt.
I appear for the appellant, my lord.
Notice to.
For R4 is the owner insured driver. 2 weeks time I kindly be granted, my lord,
Why have you
to
moved it? Who has moved it?
1 week, 1 week.
No, who has moved this matter? 2000. At request finally 1 week time is granted to do the needful in respect of respond number 4. Failing which appeal against respond number 4 shall stand dismissed. This 2018.
Seal number 2, Sachin BS.
Awaiting.
That's appearing for the appellants, my lords. But 2 weeks time will be granted.
Paper books you have to give, fine to. At request, 2 weeks time is granted to find the book. But 2019 matter, why you want 2 weeks? When the matter was admitted?
Lords,
30.
13/8/20.
Oh, now
Lords,
4
2 weeks,
years are over.
Lords, 2 weeks, my lords, I will file necessary paper books.
Finally, 2 weeks time is granted to find the paper books, finding which the appeal shall stand dismissed. List on 2 weeks of the date.
2810.
Why notice is not ordered in this?
Lords, notice is ordered, my lords, awaiting.
Awaiting.
Please.
We have also even furnished belatedly, that's what.
My lords, it is for the second time, my lords, we have paid the.
Seal number 3, Shankar Narayan Bhatt.
For the.
KR Ramesh.
Appear for respond in this matter.
1 week time, my lord, of filed necessary application.
Sole
for
appellant was
appellant.
died. Appear reported.
When he died,
Defendant appeal, my lord, the date of death is not known.
Recently is
appellant himself has died.
Please, my lord.
Date of
kindly
death.
1 week time, my lord, filed the application.
Previous date, my lord, on 25/7/2024. 2 weeks time may be granted.
25/7? are bringing the LRs.
Please.
They have been informed by the learned counsel for respond that appellant expired when are you aware when she
Date
died?
was not known to the respondent. No, death was confirmed.
No, whether it has already abated.
No, ಆಗಿರುತ್ತೆ.
ಇಲ್ವಾ?
Abet ಆಗಿಲ್ಲ.
It requires 2 weeks time is granted to them. Yes.
Still number 4, Mohammed Mujassim, T. Sheshki.
My lord, appearing for appellant in this matter, my lordship.
Court fee has to be paid.
My lord, it is with respect to court fee, my lordship. Last time I have submitted that we have paid under 24B, my lordship, where our suit is for declaration and injunction, my lord.
Respondent. Oh. Yeah, Ramesh is not appearing.
Alla, T. Sheshkiri Rao.
I represent
correct.
respondent in this matter. Contest
got it.
with regard to the court fee, there is an issue with regard to the court fee. It is between the appellant and the,
They have to assist us.
Yeah.
He says, last time also,
he claims that he has already paid.
he claims that his, suit falls under section 24B of the Court Fees Act. What do you know?
Yes,
And
sir.
he says that it is a suit for declaration and injunction and he take the benefit of 24B.
Sir, whether that submission is correct. 24B. What were the issues?
My lord, kindly see, my lordship, page number
Lawful
30 of-
possession is held in negative. Plaintiffs who alleged interference, whether they are asking for a suit is barred by limitation. What was your defense?
My lord, kindly see, my lord, page number 30, my lord.
Lakshman, he is not the owner, not proved the ownership, nor in possession of the property. Para number.
My lord, my submission is that, my lordship, whatever the
You
court
had
fee.
already
Page number 19 of the impugned judgment. Page number 19 of the impugned judgment, para number 21. Court holds that he has not proved the will and not in possession of the property. Page number 19 of the impugned judgment, para number 21. He admits that he was out of possession as on the date of filing of the suit itself. Still, he files a suit for declaration and injunction.
He has specifically admitted that
Yes.
first defendant was in possession of the portion of the scheduled property as on the date of the suit.
And he wants an order of injunction against the defendant number one, who is the contesting respondent.
Was the court fee payable? He claimed under the. ಅಲ್ಲ ಅದು 24B, but 24B apply ಆಗುತ್ತಾ ಅಂತ.
Even PW2 also admits that I have constructed a house and I am residing there. And he has based the suit on the basis of a will. He did not examine any attesting witness to prove the will. None of the documents produced by him would establish that he is in possession of the property. On the other hand, he is the owner of the property, not even Kata also. And he, by making an application under Order 41 Rule 5, he wants a stay at the hands of this honorable court. Suit has been dismissed. There is nothing to be stayed here.
So they claim that they have, her husband had purchased it from one Saurabh. Yes.
Yes, yes. An earlier suit was also filed by him and that ended in dismissal.
My lord, now the dispute is with respect to court fee, my lordship. They are going on the merits of the matter, my lord. They are, court is considering whether the court fees is paid is correct or not. That's what, my lordship, not on the merits of the case, my lord.
Suit itself is not maintainable.
That is to merits to be argued at the time of argument, my lordship. Whether
In other-
maintainable or not. Court fees is the consideration, my lordship. Whether court fee has been paid properly or not, that's what, my lord.
It is only a frivolous suit which has been filed. Second round of litigation.
So you claim that he had sold the property to one so
Yes,
Hemalata, and from Hemalata you have purchased, defend number one.
yes, he has sold the property. It is not
19
available. It is only a
1970.
frivolous suit.
They have not sought any declaration about these sale deeds, this, 1973 sale deed and 19,
He has not sought for. He has not sought for.
so this is.
Simple suit for declaration and injunction. He has left everything aside.
Identity of the property was in dispute?
Property was in dispute. Identity of the property.
It is also under dispute and also out of possession and also not proved the will.
57 ಅಲ್ಲ. According to our court note, ad valorem court fee ಕೊಡ್ಬೇಕು ಅಂತ 1,14,000.
Total 1,76,195. Now they have paid rupees 1,119,000. 1,90,000.
Petition slip ಕೊಟ್ಟಿದ್ದಾರೆ ನಮಗೆ. ಅಪೀಲ್ ಜೊತೆಲಿ ಇರ್ಬೇಕು ಮೇಡಮ್.
ಇಲ್ಲ ಅವ್ರಿಗೆ what is payable ಕೊಡ್ಬೇಕು.
He has not made available the valuation slip to us in order to bring it to the notice of the Assam.
My lord, we have served the entire appeal memorandum, my lordship.
Yes, it is here.
Valuation. Correct ಹೇಳಿಲ್ಲ ಅದು. Suit is for declaration and consequential injunction. Valuation is at page 59 shows that suit is valid under section 24B of the Act. As per the decree, property measures so and so 1,200 square feet.
My lord, office have calculated in the appeal memo, my lord.
Therefore, the total value of the plain share property comes to 39,69,000. Our registry says even if it is, calculated under section 24B, also still there is deficit.
My lord, my lordship, kindly see the,
57,100.
my lord, kindly see the appeal memo, first page, my lordship, backside on the presentation, they have calculated, my lord, how the amount is to be calculated.
Properties. You have valued the property at 1,200. Valuation.
No issues, my lordship. It is not in dispute, my lord. My lord, it is not in dispute, my lord. The amount they have calculated is 39,69,000, my lordship. We are not disputing in that part, my lord. Kindly.
But as per the registries now, even if learned counsel for the appellant submits that the suit was valued under section 24B and 24B of the Court Fees Act, and the court fee is paid accordingly. Where is your valuation slip?
My lord, my valuation slip is at page number 59, my lord. My lord, kindly see, my lord, office also have direct calculated on the appeal memo first page, my lord. That
You have
total.
calculated it at 1,200 per
Correct,
square
correct,
feet.
correct, my lord.
73.5 into 45, according to the registries note, it exceeds this.
No, that is one, my
More than
lordship.
about 10,000 rupees in
Sir,
the
one
vicinity.
nimsha, my lordship, I will clarify.
Calculation is incorrect. This.
My lord, calculation is correct, my lordship.
Yes, madam.
My lord, kindly see the appeal file.
73.5 into 45.
It is a 3,300, my lordship.
Into 1,200.
It comes to the 39,69,000, my lord.
1,200.
It comes to 69,69,000, my lord.
59 lakhs.
69,000. 39,69,000,
You
my
have
lord.
to pay the half of it.
That's what, my lord. It is on 19 lakhs, my lord. That is what we have paid, my lord. But the court office is directing on
19 lakh. 19 lakh.
correct, my lordship. That's what office is kindly
No,
see the first
how much?
appeal, my lord.
According to them, you have to pay 1,19,000, other 10%.
My lord, kindly see the appeal. They have calculation of the office, my lordship, on the first page, backside, my lord. Presentation backside, my lordship.
As per the, as per the decree, even calculated under section 24B, based on the dimension of the property and the value quoted in the decree. There is a still deficit in the court fee. Counsel submission is rejected.
My lord, one submission, my lord. Kindly say, my lordship, what is by submission is, my lord.
We
office-
calculated here.
My lord,
What
that
is
is,
calculated
my lord,
again?
not the 10%, my lord. That's for court fee as it is a 19 lakhs on 19 lakhs. Kindly see, my lord. I'll see schedule.
Rejected. Yes, your submission is rejected. Yes.
My lord, kindly see, my lordship, as per
Next
that,
time
not
is
10% of the court fee, my lordship. Kindly see the,
Next cut, mute ಮಾಡಿ
my lord, it is
Till
coming
number
to, my lord, 20 lakhs amount itself is.
Till number 5, Nagaraj RC.
Appellate float. Today, ಇವತ್ತೇ ಕೊಡ್ತೀವಿ. For the second time ಅಷ್ಟೇ.
For the respondent number 7.
The correct address float.
Then a statement of objection for us. Paper books also not filed.
ಕೊಡ್ತೀನಿ ಅದನ್ನ. ಒಂದು 2 weeks ಅಲ್ಲಿ
Request finally. Second time, 2 weeks time is granted to the.
That day, staying same address.
10A to C. It is IA notice.
IA notice.
Could be.
The respondent number 10, Malajama died, expired.
I want to pay section 24 shall stand rejected. 2 weeks I have to pay the process fee.
Till number 6, Venkatramana MK, Rajeshwara PN.
Today I received the IA. They wanted to withdraw the amount
Based
which
on
I made
the
deposit in compliance of the
1 of
interim order of. My lord, it is.
Now counsel for the appellant submits that he has received the copy of IA 1.
Just now I have received. I have
That is the only objection. Only the IA.
Yes,
copy,
ma'am.
not sir.
I will non-compliant.
Office objection should comply. Yes.
My lord, I have to file the objection. Just now I came to know. It is a company matter. That's why. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ರಿಕವರಿ ಆಫ್ ಇದು ವರ್ಕ್ ಮಾಡಿದೀವಿ. Both the I have decree has been passed to my lord.
ಮತ್ತೆ copy ತಗೊಂಡು
ಅಲ್ಲಲ್ಲ ಅವ್ರು 2 ವರ್ಷ ಹಿಂದೆ ಹಾಕಿದ್ರು, ಇವತ್ತು ಕೊಟ್ಟರು. ನನಗೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು ಸ್ವಾಮಿ. And I have complained. I came to know I complained office objection. In the meantime, ಅದು ಪುನಃ ರಿಫ್ಲೆಕ್ಟ್ ಅಲ್ಲಲ್ಲ, ನಂದು ರಿಫ್ಲೆಕ್ಟ್ ಆಗ್ತಿದೆ ಯಾಕೆ ಅಂತ ಅರ್ಥ.
compliance of office objection. Valuation.
ಎಲ್ಲ ಹಾಕೇನು ಸ್ವಾಮಿ, ಎಲ್ಲ ಹಾಕಿ ಓವರ್ ಆಗಿ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಪಾಸ್ ಇಂಟೀರಿಯಂ ಆರ್ಡರ್.
Go and check there.
Yes.
There's a office objection. That is one is IA 1 of 2022 office objection. No, ಇನ್ನೊಂದೇನು?
ಒಂದು ಡಿಸ್ಪೋಸಲ್ ಆಯ್ತಲ್ಲ. ಸ್ಕ್ರೂಟಿನಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
ಎಲ್ಲ ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ಮೇಲೆ ಸ್ಕ್ರೂಟಿನಿ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. ಅಪೀಲ್ ಅಡ್ಮಿಟೆಡ್ ಅಂತ ಇದೆ.
IA number 1 is delay. My lord, I will clarify.
ಅಲ್ಲ ರೀ ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ
ಅಲ್ಲ ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿದೆ, IA 2 ಎಲ್ಲ ಆಗಿದೆ.
Para to be stated correctly. Non-compliance of office objection. Thereafter, it is coming for the first time.
No, earlier, your lordship kindly see.
When it was admitted, 28/5/2021.
ಹೌದು. And thereafter, I made deposit in compliance of the interim order. IA number 1 is delay, IA number 2 is stay.
Is there any amendment subsequent to that?
No, nothing. Yes, I will make one clarification, my lord. Earlier, I filed the IA before the district court RA. Thereafter, RA has been rejected on the ground that is RFA not maintainable, not this court. Thereafter, I moved this honorable court RSA. RSA also rejected on the ground RFA is maintainable. Hence, I am before this thing. There was a delay.
Is condoned, but at that
Condoned. Thereafter, interim order of stay also granted subject to condition. I complied.
non-compliance, ಅವಾಗ್ಲೂ ಇತ್ತದು.
ಅಲ್ಲ ಅದಾಗಿ ಕೋರ್ಟಿಗೆ brought to the notice of the court observed also.
TDF 167.
In delay petition, your lordship kindly see in delay petition.
Non-compliance of office objections 1 to 5, it was listed with those objection.
ಅಲ್ಲ ಹಾಗೆ ಹೋಗಿದಲ್ಲ, ಹಾಗೆ ಕೋರ್ಟಿಗೆ ಬಂದು ಇದಾಗಿರೋದು.
Stand 28/5 ಅದಾದ್ಮೇಲೆ ಬಂದಿಲ್ವಲ್ಲ.
ಹೌದು, ಅದಾದ್ಮೇಲೆ ಇದಾಗಿ ಇಲ್ಲಿ ಡಿಲೇ.
At the time of admission, these IAs were, these objections were not listed. ಏನೀಗ what is the office objection? Valuation para to be stated. ಅದು ಒಂದೇನಾ? ಅದೊಂದೇ. The records show that the appeal was admitted as long back as 2021. No such objections were raised at that time. And therefore, office objections overruled.
In the meanwhile, TCR may be called for. ಅಲ್ಲ,
one submission, my lord. Paper book has been filed.
ಅಲ್ಲ, paper book filed.
File counter to this application, then we'll call for TCS.
Please, my
If
lord.
at all it is ordered to be released, whether it is deposited here.
Deposit, this honorable court here, my London friend has deposited 17 lakhs.
Records can be called for.
ಅಲ್ಲ records ಬರ್ಲಿ, ನಾನು ಅಯ್ಯನ because COVID ಅವ್ರಿಗೆ ಏಜ್ ಆಗ್ಬಿಟ್ಟಿದೆ. He has the undertaken, my lord. He has
ಕೊಡ್ಬೇಕು
filed
ಬೇಡ, ನಾನು objection ಆಗ್ತದೆ.
17 lakhs.
Subject to my objection, my lord. Subject to my objection.
ಒಂದು objection file ಮಾಡ್ತೀನಿ ಅನ್ನೋದಾದ್ರೆ, you file it, will grant you 1 week time. Otherwise, you want to say that you orally want to oppose, then we'll hear you.
No, I will file in writing objection, my lord. Immediately after vacation, have it, my lord.
TCRs already called.
But not received. Reminder.
ಅದೆಲ್ಲ ನೀವು first you file objections to this.
Yes, ಆಗ್ತದೆ sir.
File 6 time to file counter to IA1. IA ಎಷ್ಟದು? That is
IA 1 of 20.
IA 1 of 2022. Oh, you have filed it in 2022.
Please, my lord.
ಇಲ್ಲಿವರೆಗೂ ಯಾಕೆ?
ಇಲ್ಲ, ಅದ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ 3 ಸಲ ಮೂವ್ ಮಾಡಿದೆ ಇಲ್ಲಿ ತಗೊಳ್ಳ.
Why had you not served the copy on him?
My lord, in fact, I have given to my clerk, my lord, because of he has left the office. ಇಲ್ಲ, ನಾನು ಆ ತರ ಮಾಡಲ್ಲ, ಅದಕ್ಕೆ I apologize, my lord.
ಅಲ್ಲ, I served the paper book prior to filing this.
2110.
21.
Please.
Bill number 7, Sunil KN, Mohan BK, PV Chandrasekhar.
For first respondents, my lords.
My lords, with respect to non-filing of paper books, my lords, this matter is with respect to rejection of the plaint. Paper book may not be necessary, my lords, if a date is.
Right. Plaint, written statement, IA objection statement, at least that you have to produce.
My lords, those records are before your lordship.
And it was admitted on 17/3/2022 and order was passed on that. After 2 years, you are saying paper books are not required.
My lords,
At request finally, 2 weeks time is granted to do the needful failing which the appeal shall stand dismissed. List on date here. Date here.
2810.
28.
Oblige, my lords.
Bill number 8, Bhanuprakash HV, O Mahesh.
I seek for a week time, my lord.
Just fine.
Furnished
2 weeks
you.
time. Who has moved it?
We have already moved.
Why did you move it?
We'll furnish today itself.
That has become, you could have paid the process in the office instead of moving.
The trial court also, they have been placed ex parte, my lord.
Which appeal against respondent number 1 and 2 shall stand dismissed. Yes,
Seal number 9, H.V. Devraju. Atisha
Has
Kibi.
been filed on yesterday, my lord, that
Paper books receive.
ರಿಟರ್ನ್ ಬಂದಿದೆ.
yesterday I have filed. my lord.
ನಾನು ಇವ್ರ ಪೇಪರ್ ಬುಕ್ಸ್ ಹಾಕಿದ್ದಾರೆ. then PCR sent to the trial court.
Yes, yes.
Release of the amount. ಇನ್ನೂ ಬಂದಿಲ್ವಾ ಅದು?
Await LCR.
List after the receipt of
After
TCR.
vacation.
After receipt of TCR, so ಬರ್ಲಿ ಬಂದ್ಮೇಲೆ list.
Seal number 10. Shankarji.
For appellant.
For respondent.
Matter is the compromise between parties. It's a suit for specific performance. It's a decreed in.
Parties are there?
Yes, yes.
What is that?
Participant before the court, my lord.
No, in this compromise, they have agreed to sell the property and share half each, 50% each. Appellant is defendant before the trial court. He is the owner of the property. Suit is decreed, man.
Suit for specific performance, my lord.
Decreed in part.
Against decree, appellant, the defendant before the trial.
Purpose was rejected, only referred
Decreed.
to as order.
Decreed, Swami.
Part.
There was a registered sale agreement.
The appellant, respondent has to pay 7 lakhs a year amount to the
There-
appellant.
8 lakhs.
The
eight
suit filed by the
including
plaintiff
one
is
lakh.
decreed in part.
Part.
Enhanced consideration ಕೊಟ್ಬಿಟ್ಟು ಸೇಲ್ ಇದ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
It's directed to execute the registered sale in first substantial property within 3 months on receiving an amount of fees 8 lakhs from the plaintiff.
ಬ್ಯಾಲೆನ್ಸ್ ನ ಜಾಸ್ತಿ ಮಾಡಿ ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್ ನಲ್ಲಿ ಮಾಡಿದಾರೆ ಸರ್. Enhanced.
Enhancement.
Now, this is settlement.
The appellant is, the defendant is appellant before this court. The stay was granted subject to deposit of 1.5 lakh, my lord. It's deposited, my lord.
This is settlement.
Settlement, my lord, both of them have agreed to sell this property to some third party and agreed to share each 50% each, my lord. Both shall cooperate with each other for sale of the property. Or at the first option, if they want to purchase, they have to pay half of the consideration to the other party. That is the agreement.
Appellant has no objection to return the original documents produced by the respondent before the trial court.
Trial court, original documents.
Title deeds are with the respondent or the
Respondent.
appellant.
Original documents with the respondent, my lord, because he has produced the same before the trial court, my lord.
Correct. Say, original document means so title deeds are agreement of sale.
Title, my lord.
He has said in para 8, appellant has no objection to return original documents produced by the respondent before the trial.
ಅವ್ರು ಏನ್ ಹಾಕಿದಾರೋ ಅವ್ರು ತಗೊಳ್ಳಿ ಅಂತ. Whatever documents is produced, let him return it. And along with the court fee have sought for it.
Respondent shall execute cancellation of registered agreement. That was a registered agreement.
Registered agreement. So in order to sell property third party, it has to be cancelled. And we also said it should be consenting party to the sale deed to be executed in favor of third party. So there shall not be any complications.
ಇದಿಷ್ಟೆಲ್ಲ ambiguous clauses ಇಟ್ಕೊಂಡು
All ambiguous, it's a very clear. And my lord, in order to sell the property.
So many things. Both of them can search a prospective purchaser or either of them can search a prospective purchaser.
We got
He should execute the.
Practically, if they want to sell the property, ಈಗ ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಕನ್ಸಿಡರೇಷನ್ ಹೇಳ್ತಾರೆ. ಹೈಯೆಸ್ಟ್ ಬಂದವರಿಗೆ ಅದು ಸೇಲ್ ಮಾಡ್ಬೋದು.
They are not, not possible, they should fix the.
ಅದು ಆಪ್ಷನ್ ಕೊಟ್ಕೊಂಡಿದೀವಿ ಸ್ವಾಮಿ. ಸಪೋಸ್ ನಿಮ್ಗೆ ಜಾಸ್ತಿ ಕನ್ಸಿಡರೇಷನ್
ಇಲ್ಲೇ ಮಾಡ್ಬಿಡ್ಬೋದಿತ್ತಲ್ಲ, ಏನಂತ ಆಪ್ಷನ್ ಅಂತ.
ಅಲ್ಲ, ಬಿಕಾಸ್ ಬೋತ್ ಆಫ್ ದೇಮ್ ವಾಂಟ್ ಟು ಸೆಲ್ ದ ಪ್ರಾಪರ್ಟಿ ಟು ಥರ್ಡ್ ಪಾರ್ಟಿ. ಯಾಕಂದ್ರೆ ಥರ್ಡ್ ಪಾರ್ಟಿ ಕ್ಲಿಯರೆನ್ಸ್ ಇಲ್ಲ, ಅವ್ರು ಯಾರು ತಗೊಳಲ್ವಲ್ಲ ಸ್ವಾಮಿ. ಸೊ ದೇ ಕ್ಯಾನ್ ಶೇರ್ ವಾಟ್ ಎವರ್ ದೇ ಗೆಟ್. And they should not hide the actual consideration. That is the reason why I have put so.
Stop. The event both party arrive at and fix the consideration amount for scheduled property. Either party can purchase the scheduled property.
It gives clarity, it's not ambiguous.
Their first option, and party who agrees to sell the property to another party is entitled to get the consideration amount after deducting half of his share.
Suppose kadme essentially ಯಾರೋ ಸಜೆಷನ್ ಕೊಟ್ರೆ ಇವರೇ ತಗೊಂಡ್ಬಿಡ್ಬೋದು, ಅರ್ಧ ಕೊಟ್ಬಿಟ್ಟು ಅದನ್ನ. That's the reason I have put it. ಮತ್ತೆ ಫರ್ದರ್ ಲಿಟಿಗೇಷನ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ. ದಟ್ಸ್ ಸೋ ಕ್ಲಾರಿಟಿ ಇನ್ ದಿಸ್.
Now first he has to execute a cancellation agreement.
ಅಗ್ರಿಮೆಂಟ್
ಅದಕ್ಕೇನು ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲ, ಎಷ್ಟು ದಿವಸದಲ್ಲಿ?
ಅವೆಲ್ಲಾನು 6 months ಅಂತ ಹೇಳಿ. Within 6 months they have to
next
complete all the process.
6 months ಅಂತ.
Para 17 my lord. Para 17.
17.
Para 17.
17.
Execute 6 months. Yes, sir. Ibru educated, ah?
Yes.
When is it open? ವಿನಾಯಕ್ ಬಿನಾಯಕ್, ಎರಡು ವಿನಾಯಕ್ ಬಿನಾಯಕ್ ಅಂತಾನೆ ಇದೆಯಲ್ಲ ಅಪೀಲ್ ಮೆಮೊದಲ್ಲಿ. ವಿನಾಯಕ್ ಬಿನಾಯಕ್ ಸನ್ ಆಫ್ ಬರ್ಮಾ ನಾಯಕ್ 51 years. ವಿನಾಯಕ್ ಬಿನಾಯಕ್ ಸನ್ ಆಫ್ ಬರ್ಮಾ ನಾಯಕ್ 53 years. ಅಪೀಲ್ ಮೆಮೊದಲ್ಲಿ.
ಅಲ್ಲ, ಅಪೀಲ್ ಅಲ್ಲಿ ಎರಡು ಅಡ್ರೆಸ್ ಇದೆ ಸ್ವಾಮಿ. ವಿನಾಯಕ್ ಪಿ ನಾಯಕ್.
ಸರಿ, ಸುನೀಲ್ ಕುಮಾರ್, ಅದೇ ಆಲ್ಸೋ ಆಟ್ ಅಂತ ಹಾಕಿದೆ.
ಆಲ್ಸೋ
ಸುನೀಲ್ ಕುಮಾರ್ ಸನ್ ಆಫ್ ಪುಟ್ಟೇಗೌಡ.
Putayagowda. He has given GP in favor of his own brother.
He is not the respondent here.
He has given GP, SPA, my lord. I have produced the SPA before this along with Wakalat Mill.
While filing the wakalat itself, he
Yes,
has
ma'am.
appeared through his attorney.
Yes, my lord.
ಏನ್ ಅವ್ರ ಹೆಸರೇನು?
ಇವರು ಸುನಿಲ್ ಕುಮಾರ್, ಇವರ ಹೆಸರು ಅನಿಲ್ ಕುಮಾರ್ ಅಂತ.
ಇದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದವ್ರು ಯಾರು? ಇದಕ್ಕೆ GP ಹೋಲ್ಡರ್ ಅಂತಾನೆ ಮಾಡಿದಾರ?
ಹೌದು ಸ್ವಾಮಿ, ಅವರೇ ಮಾಡಿ. ಓನ್ ಬ್ರದರ್ ಮೇಲೆ ಅಣ್ಣ ತಮ್ಮ.
ಸುನೀಲ್ ಕುಮಾರ್ ಸನ್ ಆಫ್ ಪುಟ್ಟೇಗೌಡ. ಇವ್ರು ಯಾರು? ಅನಿಲ್ ಕುಮಾರ್ ಸನ್ ಆಫ್ ಪುಟ್ಟೇಗೌಡನ? ಇದು ಓದ್ ತಿಳ್ಕೊಂಡಿದೀರಾ ಎಲ್ಲಾನು? ಈಗ ಓದ್ ಹೇಳಿದ್ರಲ್ಲ ಅವ್ರ ಪ್ರಾಪರ್ಟಿನ ಇಬ್ರು ಅಗ್ರಿ ಟು find a purchaser and sell it and then share the sale proceeds. Okay. ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಲ್ಲ? So you have to execute the cancellation deed. Right. So if at all it's not possible, both of you have to fix a consideration and then either of you can purchase it. Appellant.
And my lord, the deposit amount may be refunded to the appellant. We have deposited 1.5 lakh for a grant of stay. It may be refunded to the appellant.
Well, ಹಾಗೆ ಇದೆಯಾ? You have mentioned only about court fee.
Court fee ಹೇಳಿದೀನಿ, ಇದು refund ಇದೆ ಹೇಳಿದ್ದೀನಿ.
Appellant and Anil Kumar, that is power of attorney is for special power of attorney.
Yes, my lord.
The special power of attorney holder of the respondent, and both counsel are present. Parties are duly identified by the counsel. Idರಲ್ಲಿ to if any the matter is settled amicably ಅಂತ ಮಾಡಿ. For the parties on the compromise petition, parties admit voluntary execution of the compromise petition and terms of the same. The compromise petition reads as follows. ಅದನ್ನ ಪೂರ್ತಿ ಹಾಕೊಂಡ್ಬಿಡೋದು. ಅದಾದ್ಮೇಲೆ satisfied that the compromise is voluntary and admissible under law. Therefore, the same is recorded. In view of the compromise, the following order. The appeal is followed. The interim judgment and decree dated 28/11/2022 in OS number 82/27 of 2018 passed by the 19th additional city civil and session judge, Bangalore, into bracket CCH 18. is hereby set aside. The suit in OS number 8227 of 2018 Partition is decreed in terms of the compromise petition. Draw decree accordingly. The appellants refund the admissible court fee to the appellant and refund the amount deposited by the appellant, if any, and the admissible court fee to the appellant.
100% ಇದೆಯಲ್ಲ sir.
ಹೌದು.
What fee?
And 1.5 lakh deposit ಮಾಡಿದ್ವಿ for a grant of stay.
Amount deposited, if any, by the
Appellate. Much of it.
Line 11, Harsha Kumar Gowda, Ramesh PH.
I appear for respondent. Lord, the matter is settled between the parties, my lord. The respondent is on the way. The,
Pass over.
please.
Fast forward. Seal number 12, Madhusudan Yaman,
Press for 2 weeks.
first
Notice to R1 at request 2 weeks time is granted to the next.
Okay.
Seal number 13, Bhanu Prakash HV,
Correct address to R2.
We filed the memo for dispensation for R1, madam,
Clubbing MFA.
along with the clubbing memo. And also copy has been served to the Pradeep, madam. Honorable.
They have filed another appeal.
Yeah, ma'am. Yes, ma'am.
Who is responsible to owner of the vehicle?
Owner of the vehicle.
They have not disputed the liability.
They are
They
challenging
have
the,
filed that.
they are challenging the order, madam. Quantum of the award.
In the order, whether they dispute only quantum or
Only
liability.
quantum, your lordship.
Are you very sure?
Yes, your lordship.
Otherwise, let both, because he is not there, let both the appeals be listed together, then this can be considered.
They already served the copy, madam.
Respondent number. But his name is not shown. Whether court had directed? Well, he had appeared before the trial court. Appear ಆಗಿದ್ದಾರೆ. But the records show that under the interim award, the liability is fastened to respondent number 2, the insurer. Therefore, notice to respondent number 1, respondent number
1.
ನಿಮ್ಮ ಮೆಮೊನಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀರಾ?
ಹೌದು sir.
R1 ಇಲ್ಲಿ ತಪ್ಪು ಬರೆದಿದ್ದಾರೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಅಲ್ಲ, ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತಪ್ಪು ಬರೆದಿದ್ದಾರೆ. ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 is dispensed with as paid for. ಓ, ಇವರಿಗೆ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಅಂತ ಬಂದಿದೆಯಾ? It is submitted that this matter is connected to MFA number 7178 of
22, your lordship.
List both the matters to be ground. After
2310.
23.
Much of it.
Seal number 20, seal number 14, Krishna Kishores, Rudra Papi,
Number 2 to 4, my lord. I appearing for impleading applicant, my lord.
In the office subsection on the memo, second set to be filed.
2 weeks time grant. My lord, death intimation, my lord.
You have filed it, second set ಕೊಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ.
I'll file, my lord.
ಇಲ್ಲೇ ಬರ್ಕೊಡಿ ಒಂದು.
Please.
This set memo.
R1 is dead, my lord.
R1 died.
So the others are the LRs ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
application IA 1 of 24 and second set.
What is IA 1 of 2020?
Bringing LRs of deceased R1.
Bringing ಎಲ್ಲ settings to.
Who has filed that application? Ravi. Respond number
Filing,
2 to 4.
1 rule
The
10.
memo was filed by respond number 2 to 4. Application is filed by whom? Advocate for impeding applicant. ಯಾರು ಇನ್ನೊಬ್ರು ಯಾರು ಭಾಗ್ಯಮ್ಮ ಅಂತ ಅವ್ರು ಕೊಟ್ಟಿದಾರಲ್ಲ? Who has
Respondent number 1 was expired. Yeah, LRs of the mother ಅವ್ರಿಗೆ ಹಾಕಿದೀವಿ sir application.
Response 2 and 3 were minors.
ಈ ಭಾಗ್ಯಮ್ಮ ಸ್ವಾಮಿ ಭಾಗ್ಯಮ್ಮ
Mother of the
How she is related to them?
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಡಿಸೀಸ್ಡ್ ಮದರ್ ಸ್ವಾಮಿ.
mother son.
Mother of the deceased, 70 years old.
ಮಕ್ಕಳನ್ನ ಅವರೇ ಇಬ್ಬರು ಮಕ್ಕಳನ್ನ ಅವರೇ ನೋಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ.
8 years.
Correct. ಅಂದ್ರೆ this is not application under order 1 rule 10 ಅಲ್ಲ.
22 rule 9 ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು.
ಹಾಕ್ಬೇಕು.
Also. Abatement ಹಾಕ್ಬೇಕು. I will file
Ah.
1 week time.
ಎರಡಕ್ಕೂ ಸೇರಿ ಒಂದ್ ವಾರ ಕೊಡ್ತೀವಿ ಹಾಗಾದ್ರೆ ಅದನ್ನು ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಡಿ.
Please.
ಮತ್ತೆ ಇನ್ನೇನು ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ 1/2024 ಇದನ್ನ ನಾವು ಮೊದಲು ಆರ್ಡರ್ ಮಾಡಿ ಅದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ. ಕ್ಯಾನ್ ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್. It is as reported, respondent number 1 died. He was the minor guardian of respondent he was the guardian of minor respondent number 2 and 3. I number 1 of 2024 is filed by the grandmother of response to and order 1/10 CPC to come on record as guardian to but she should have filed application for appointment of a guardian under order 32 rule. Defendant is a 4 32(3). And therefore I one ಎಲ್ಲ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಆಗುತ್ತೆ ಇನ್ನು ಅದಕ್ಕೊಂದು ಮತ್ತೆ ಕರೆಕ್ಷನ್ ಇದನ್ನ ಮಾಡೋದು. Therefore reserving liberty to file appropriate application I 1 of 2024 is disposed of. The memo mail in the second set ಕೊಡಿ at least.
Please, bro.
2 weeks time is granted to comply the office objection on memo. Yes.
In the meantime, ಏನಾದ್ರು only quantum ಮೇಲೆ ಇದೆ ಸ್ವಾಮಿ, ಮಾತಾಡ್ತೀನಿ. Settlement ಆಗುತ್ತಲ್ಲ ರಿಪೋರ್ಟ್.
ಅಲ್ಲ ಅಷ್ಟರಲ್ಲಿ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ either you have to file application for a court guardian appointment
ಮಾಡಲಿ
or
ಸ್ವಾಮಿ.
they have to.
ಅಪ್ಲಿಕೇಶನ್ ಆದ್ಮೇಲೆ in the meantime ಆದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತೀನಿ. ರಿಪೋರ್ಟ್
Next week on date of, next week on date fix ಮಾಡಿದ್ರೆ.
Next week is not ಮುಗಿತಲ್ಲ ವರ್ಕಿಂಗ್ ಡೇ ಇಲ್ಲ.
Cell number 15,
ನೀವು ಹಾಕಿ ಬಸ್.
Mohiddin, Aram,
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಅವ್ರ ಅಷ್ಟರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ.
2110.
Next 21.
Cell number 15, awaiting.
R1 list after the service of respondent number 1 and 2 is completed.
Cell number 16, KP Bhuvan,
Here for appellant, my lord, today I will take steps against R1 and R2.
Plus 2 weeks time is granted to them.
cell number 17, Gurudev Gachinmat,
I may be permitted to file a necessary application for substitute service, my lords, to take out the.
Request 2 weeks time is granted. Finally, 2 weeks time is granted to do them in respect of R1. Failing which the appeal against R1 shall stand dismissed. Yes. 2 weeks you have to file application.
Obligation.
cell number 18, Ramachandra Reddy, Narayan K,
Last occasion, I had permitted to serve the notice on trial court advocate, madam. He has vacated his premises, office premises. So I came to know recently, I traced the new address of the council, madam. Will serve on.
Just to R2 and 3.
Howdo.
Non-filing of paper books.
The paper book does not arise, madam. I have not questioned the correctness of the judgment and the action purchaser, madam. Appellant is the action purchaser. Action purchase is not confirmed in his favor. Being agreed by the same, he is before the court. He has not challenged the preliminary decree, madam. As such,
He should file a paper book if it is ordered. He could have said that.
I will file necessary application, madam, in next date of hearing. Same is ready, but he is not present to file the same. Dispensation application, I'm going to file, madam.
They are evading the service. But at request 2 weeks time is granted to them. Yes, 2 weeks.
Time may be fixed, madam. Date may be given.
This time. After 2 weeks.
2810.
20. Yes.
cell number 19, Shamay Goda HV, Raghavendra Prasad M,
I appear for respondent number 1. Appearance for the appellant, my lordship. To do needful 4 weeks time may be granted for the filing of paper book, my
That's
lordship.
fine. So then 4 and 5, response 4 and 5 are not served. At request 2 weeks time is granted to the benefit. Yes. 2 weeks, you pay the process to respond number 4 and 5 also.
My lordship.
2 weeks time is granted, you pay the process to respond number 4 and 5 and file the paper. Yes.
cell number 20,
Much
Padmavati
obliged.
Suresh,
Waiting, service of notice in respect of respondent number 2.
You are for the appellant.
Appellant, yes, madam.
Service for number 2 is completed. Yaru respond number 2 is minor, why?
No, madam. Respond number 2 is my lord Sahana.
He is minor.
3 is minor,
representing
yes. Yes, madam.
Respond number 3 is 14 years, sir. Respond number 2 is 20 years.
ಹೌದು, ಹೌದು.
ಏನಾಗ್ಬೇಕು ಅವ್ರಿಗೆ ಅವರು?
I think my lord, she is the sister.
L appeal plaintiff number 3 represented by minor plaintiff number 2. Fine, Mr.
So number 21, Anirudh Chamunda, Susai Raj.
Address stated in.
Appellant wife in
Not
received the case paper, lot submission, not received the appeal copies, your lordship.
Pardon?
And not received the appeal copies, your lordship.
There is an office subsection also. What is that?
Office objection raised
Is
with
it
regard to the
counsel such-
variation in the address mentioned,
The appellant stated in the cost of the appeal and the order of the trial court.
trial court.
So she was respondent.
Variation ಇದೆ ಅಂತ. The appellant had filed a restitution of conjugal right before the family court. Even though he has appeared before 1 year back, he has suppressed and go on appearing and filing. In the meanwhile, by suppressing the real
Address is Lal Bagh.
Lal Bagh address, I don't know who is there residing there.
He can mention it in the appeal memo that it was wrongly shown as address of Shantanu.
yeah,
He can
it has
make an
to- yes.
endorsement in that,
Please, please.
which was wrongly shown at the body.
Right now I will, be, that objection may be overruled. Right now I will do it.
But learned counsel for the appellant is permitted to show both the address.
Please.
Both address shown in the appeal memo as well as in the cost title of the judgment. Without prejudice to his appellant's right, without prejudice to the appellant's contention in the main matter.
Please.
All right.
IA ಇದೆ, delay ಇದೆ, condition ಗೆ.
Delay condemnation, the copy serve ಮಾಡಿಲ್ಲ ಅಂತ
ಇದೆ
ಹೇಳ್ತಾರೆ.
ಕೊಟ್ಟಿದ್ದೀವಿ.
Not received.
Office has not.
Right
raised-
now I will punish.
Office has not raised such objection. Office has not raised such objection. Copy serve ಮಾಡಿಲ್ಲ. ಯಾವ್ದ್ರದ್ದು appeal notice after service of notice only have appeared.
Yes.
Then how can you raise that objection?
Your lordship, submission is that the respondent has been served with the copy, only the summons notice has come, your lordship.
But-
The respondent was not there, respondent mother was there, even postman has not served, refused.
Copies are furnished.
Yes.
If at all you lost it, you can request him and
Please, I will furnish anyhow.
now any interim order is granted here. This is against the decree of divorce.
Please, my lord. Restitution of conjugal rights ನಮ್ಮಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ. Still he is pursuing the matter. Mediation appear ಆಗಿದ್ದಾರೆ, maintenance ಕೊಟ್ಟಿದ್ದಾರೆ. Still order is subsistence. By suppressing this fact, he has filed a petition, not even disclosed before the trial court.
Cut down the delay.
Please,
211 days.
please.
You can request and see, without copies, our office will not issue notice. And
Oh,
such objection.
Lordship, I'm not the counsel on the trial court, your lordship. Just now, my client has given me the instructions.
Susai Raj yourself.
I'm not in the trial court advocate, your
You
lordship.
are the Susai Raj.
Yes, your lordship.
You need not be in trial court. You are submitting in the high court only, but our office has not raised any objection that the copies are not furnished. Copies are served on your party. If they do not give it to you, what the court can do?
The party told only that the postman has come and only,
Things.
He may say anything.
even I applied for the copies, your lordship. In the office, I will apply for the copies. The copy application is pending.
Correct. Pending a petition for restitution of conjugal rights, you filed a petition for divorce and got it. She was not served ex parte.
Expert.
All right.
Place
You filed
ex parte.
objection,
Even they let the evidence, your lordship. They not brought to the notice of to the family court.
ನನಗೆ ಹೆಂಗ್ ಗೊತ್ತು ಫೈಲ್ ಮಾಡಿದಾರೆ ಅಂತ ನನಗೆ ಹೆಂಗ್ ಗೊತ್ತು? That is my case.
Judgment says she was a.
Even now, before filing the appeal, they would have brought to the knowledge of this family court, your lordship. Even the appeal is pending, still they are not filed.
ಫೈಲ್ ಮಾಡಿರೋ ಅವ್ರು ಹೇಳ್ಬೇಕು ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ.
Judgment is an ex parte judgment. Now counsel for the appellant submits that pending petition for restitution of conjugal rights filed by the appellant respondent filed a petition for a decree of divorce, furnishing a wrong address. Considering the aforesaid facts and circumstances, interim stay of the impugned decree till next hearing date. You file objections.
Please.
I'll file my objection.
But
Number 22. Cyril Prasad case.
Appear for the appellant, my lord. My lord, the respondent herein, my lord, filed MFA number 1334 of 2024.
It is submitted that this matter is connected to MFA number so and so.
1334 of 2024.
The matters together one Bharat Kodi.
Yeah, Ganapati Bhatt is representing.
Other list,
I-
but list of that we can direct him to take notice and you can take notice in that appeal.
Same address. ಅಲ್ಲಿ ನಾನು ಅಲ್ಲಿ ಇನ್ನೊಂದ್ರಲ್ಲಿ notice ತಗೊಂಡಿದ್ದೀನಿ.
ತಗೊಂಡಾಗಿದೆಯಾ?
ಆಗಿದೆ. I have taken notice in other.
This both the matters together on after vacation?
Aye.
14th. Okay. Cell number 23. Muralidharayan, Shantraj case.
Awaiting TCS. List after the receipt of TCS 23.
Cell number 24. Mohammed Tahir.
I appear for the appellant's counsel. my
Of
lord.
notice of R2. Sir, RT is still not.
Please, the interim order of stay with regard to delivery of possession.
Hmm.
But on the same day or on previous day, third night, they have come and put lock on all the shops as well as the, this thing. Vyayam Shale.
Direction was to
Land grabbing court had passed the order to take possession. Initially, when the matter had come up, your lordships were pleased to observe taking of possession involves certain procedure. You can move the matter then.
yes, no.
3220.
Records, sir. Issue
Not to precipitate us.
Hearing response shall not precipitate the matter
ಅಷ್ಟೇ.
for taking possession. Whether this order was served on them, respond number 2 is still not
No,
served.
they did it on previous day, third night, third evening rather.
This order was passed on 4 days
It was passed on fourth,
and lock was put on 3rd night.
third.
Pin.
Your
Why
Then we presented this order, requested them to open the lock. They did not open the lock.
now respond number 2 is not yet served.
But with regard to interim prayer, I have made an application to break open the lock for this reason.
How can we pass the order in their?
Please, my lord, it can be for the reason, your lordship kindly see. Regulation 39.
Restore the possession of the subscheduled property.
Please, my lord, regulation 39 may kindly be seen, my lord,
Which regulation you are?
of the land grabbing special court regulation.
Lynn. They act land grabbing act. No, but anyway, now notice is not, why it is not being served? Commissioner City Municipal Council ಹರಿಹರ. ಯಾವತ್ತು ಹೋಗಿದೆ, ಯಾವತ್ತು process ಕೊಟ್ಟಿದ್ರಿ ನೀವು? ಯಾವತ್ತು issue ಮಾಡಿದ್ದಾರೆ notice ನೋಡಿ? Notice issued to R2 on 21/9. ಮತ್ತೆ ಇವಾಗ ಹೇಗೆ ಬರುತ್ತೆ? ನೀವು ಲೇಟ್ ಆಗಿ process fee ಕೊಟ್ಟು. Learned senior counsel, your advocate on record has one process fee. Belatedly it seems. Notice is issued only on 21/9.
2 days ago. 2 days, 2 days.
3 days, in 2 days back. What is? Side. Yes, sir. Number?
Regulation number 39.
Prohibition Act ಕೊಟ್ಟಿದ್ರಿ ನೀವು, ರೆಗ್ಯುಲೇಷನ್ ಇದರಲ್ಲಿ ಇದೆಯಾ? ಕಂಡೀಷನ್ ಸರ್ವಿಸ್ ಚೇರ್ಮನ್
483.
regulation.
Karnataka Land Grabbing Prohibition Special Court Regulation 2007.
37, yes.
ಅದರಲ್ಲಿ 39. The special court shall communicate its final decision or order in respect of the land to the authorities and also to the Tahsildar or the authorized officer to give effect to the decision. The Tahsildar or the authorized officer shall, on receipt of the order of the court, issue or arrange to issue a direction in Form 5, deputing any officer not below the rank of revenue inspector to take possession of the grabbed land on behalf of the court and deliver possession of the land to the person ordered by the court. A copy of the authorization issued by the Tahsildar or the authorized officer shall be served or arranged to be served on the person in possession or occupation of the land as the case may be. Where the person in possession or occupation of the grabbed land delivers possession thereto voluntarily, officer so deputed under subsection 2 shall record statement of the person to that effect and also record certificate in Form 6 and send the same to the court. Where the person in possession or occupation of the grabbed land fails to deliver possession of that land voluntarily, officer so record deputed under subregulation 2 may enter on the land and take possession thereof on behalf of the Tahsildar or authorized officer after removing any obstruction or unauthorized. First, they should serve a notice.
Who is the authorized officer here? Who is the
That
authorized?
they are not even intimated who has now the Panchanama says.
No, is there any, yes,
ಅಲ್ಲ ತಹಸೀಲ್ದಾರ್ ಇರ್ಬೇಕು.
have you followed it?
I will verify, Lord. I will seek instructions.
Another ACA seeks accommodation to take instruction. The IA number, on IA number instruction, whether from the from respond number 3, whether the procedure required under regulation number 39 was followed to take possession. List on date. Astrally service agino barutte after vacation.
2110.
Chartered.
They have put
So-
a
so
lock, my lord. Kindly have
14th.
it on 30th. Let them get the information from the Tahsildar.
No, R2 is also not served.
R2,
That's not direction of them. You are
R2 is
seeking
not
for
the,
IA.
R2 is not the person contesting, my lord. It's actually,
You see, in your IA has sought direction against respondent.
Two hours, one
Then
place.
why did you file it? List on soon after vacation.
1410.
14th.
kindly have it on 30th, my lord. I will take hand summons to respondent 2 also.
Respondent, but you only have given the process fee belatedly.
That will not entitle them to enter the property and put a lock.
It's not that now we are seeking that.
Therefore, I am requesting,
Started,
it may
sir.
kindly be posted on 30th. I will take hand summons also. Kindly direct hand summons.
Okay, okay. Yes.
Cell number 25.
Soon after reopening. Yes. Ron, this is not a school or anything like that. Yes.
Cell number 25.
Matter, I filed NOC Wakalat for the,
In which matter?
in 25,
25. For whom?
for the appellant. Respondent number 1 has passed away. I have filed applications to bring the LRs of,
So file. Shri Answer Learner Council or receive correspondence. Submits that he has filed wakalat for the appellants with of Shri Pratik Rath. And he has also filed IS interim applications to bring on record the LRs of respond number
1.
1. Registry shall verify and do the needful. List down.
Your lordships may kindly issue notice on that as well.
Otherwise, you do one thing. Then you come at 2:30, we'll collect it from the registry. We don't have.
Your lordship.
Correct.
IA number 1 of 24,
Sorry. But even notice to the respondents were also not issued, it seems.
notice is not issued on the main appeal as well.
So notice has.
Your lordships may kindly issue no,
Said. Respond number 2 is.
your lordships may issue notice on the main appeal.
Has filed wakalat wakalat for so and so with this. Okay. Registration verify and do the needful. Then will issue notice of IA number 1 to
6.
Allah, 1
1, 2,
Illa.
3.
1 to 3 are bringing LR, so.
Indeed.
22 then adu?
IA 1 of 22 is for condonation of delay on the main appeal. IA 2 of 22, Your Lordship, it appears that it's been dismissed for non-prosecution on 21/12/23. IA 2 of 22.
21? 12,
21/12/23. It appears that IA
Objection based on this application is not complied with. None appears in support of the application. In view of the above, application is dismissed. We are right.
Indeed. So IA 2 of 22 has been dismissed for non-prosecution.
IA 2 of 2020. Okay. The records show that on 21/12/2022, 23, this court has dismissed IA 2 of 2022. Therefore, registry shall not list the same again. There is delay in filing the appeal also, 1029
Indeed.
days.
It was an ex parte order, judgment.
Issue notice of IA number. ಎಲ್ಲಾನು ಹೋಗ್ಬೇಕಾಗುತ್ತೆ
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಹೋಗು.
IA 2 and 3 of 2024 and IA. Again, you have filed another application for TA.
I filed another application.
And 3 of 2022 and IA 4 of 2022.
To the 4 of 24, Your Lordship.
4 of 24 to respond number 2 and the proposed LRs of deceased respond number 1 list all.
11.
12.
May I make one further request? May I be permitted to serve the advocates who are appearing in FDP 66 of 22?
Where will be mentioned about FDP?
Your Lordships will find that at page number 91, running page 91, if Your Lordships find, I've produced.
Number 2. Oh, she was in some other country.
He was in Canada. And it was, service was taken on a different address. At page 91, I produced the LR application that they filed in FTP 66 of 22.
Only second respondent had not contested, second respondent had not.
The defendant number 1 also did not contest. I am for the defendant number 2.
You are for defendant number 2 alone.
Two alone.
File application for bringing LRs of respond number 1.
Respondent number 1 is the plaintiff, Your Lord.
Now in this appeal.
In this appeal, indeed.
Okay. Page number is what? Correct. 91. FDP 66 of 2022. Simultaneously, Learned Counsel for the appellant is permitted to serve a notice on our advocate necessary.
On the advocates appearing in FTP 66 of 22.
91. Advocate name is not spoken to the counsel representing respondent number.
Respondent number 1's legal representatives.
FDP number 66 of 2022 before the trial court. List on
11.
That is simultaneously.
Say number 26, M. Narayan Bhatt, XCGP for R1, Nagaya for R2.
For the appellant. My lord, I have served copies, my lord, on my learned friend. My lord, he doesn't dispute that position. My lord, I did not file acknowledgement.
Yes, Nagaya, you have received the copies?
First in the ಸಿಕ್ಕಿದೆ.
That one. 23, 29.
26 ದಲ್ಲಿ.
ಅದರಲ್ಲಿಲ್ಲ.
68, 29.
68, 29 ನಲ್ಲಿ we have not served with copy.
Connected matter ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತಾರೆ.
First matter.
68, 29 you are served?
68, 29, first matter, copy not received.
My lord, then I will serve, my lord, another set.
Is there any other compliance in the connected matters also?
ಅದರಲ್ಲಿ ಭಟ್ರು ಈ ಕಡೆಗೆ ಬರಬೇಕು.
ಇದರಲ್ಲಿ ಮಾಡಿ. 26.
That matter ಮೇಲೆ
Yes, 68, 29.
I request all lordship to take MFA number 2271.
Serial 26.
First, I request our lordship to
recalling the order.
2239, 2239, 2329.
23.
26.39.
6.
26.6.
Deceased appellant setting.
Last time, last occasion, we have submitted.
Filing of counter to IA1.
In this matter, my lord, we have submitted on the last occasion before the court that Siddhappa, the appellant hearing, was the petition before the reference court. Judgment pronounced on 13/12/2022. The death of Siddhappa was not brought to the notice of the court below.
When he died?
He died on 23/9/2019.
23/9.
9/2019, according to their application, what they have submitted for condone the delay and bringing the loss.
Okay, judgment
Judge-
was passed
judge-
on 13th December.
13/12/2022.
This was a single case, not.
Please, my lord. His death was not reported before the court below.
But after his evidence, he died.
ಅದು ಗೊತ್ತಿಲ್ಲ
It is after evidence.
ಅಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅವ್ರದ್ದು.
After arguments, my lord, he died.
After arguments ಆಗಿದ್ರೆ.
ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ,
My submission was.
What by PW1?
My submission before your lordship was. The moment he died, it is obligation on the part of the petitioner to bring the.
Correct. This claim petition does not abate if he died after recording of his evidence and the matter was heard. So that we have to examine here. You are trying to say that the.
That is to be the case. Matter has to be remitted back to court below for.
No, the record show that after his evidence, he died.
It is there in the judgment, which I cannot dispute. That is to be the case. When the
They
judgment
can
was,
come here on record.
when the judgment was passed for and against the dead person. 22 rule 4.
Then that will not become nullity if it was posted, it was passed after he, at the hearing of the matter. His evidence was over, because ಅದನ್ನ check ಮಾಡಿ. Only for on the technical ground.
My lord, it is covered.
That has to be done in the judgment itself.
It is
Before the court below.
ಅದಿಲ್ಲ ಹಾಗಿಲ್ಲ, legal portion is not like that. What are you giving? Judgments,
Judgments.
ಅದೇ, does not
Reference.
abate ಅಂತ ಇದೆ.
ಇಲ್ಲ, reference abate ಆಗಲ್ಲ ಅಂತ ಇದೆ.
Reference is not the case initiated by the party.
Yes.
So there is also one judgment, is you are right.
My lord, in the learned single judges,
This is the last person to make submission before the court.
my lord, page 4, instead of looking into the honorable Supreme Court's decision, my lord, exhaustively learned single judge in another writ petition. And my lord has
Yes,
Cover-
got it. ಅಲ್ಲ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ.
ಕೊಟ್ಟೆ, list ಕೊಟ್ಟೆ.
ಅಷ್ಟಕ್ಕೆ ಮತ್ತೆ ಯಾಕೆ ಅಡ್ಜರ್ನ್ ಆಗ್ತಿರ್ಬೇಕು ಅಂತ ಹೇಳ್ತಿರೋದು. ಇವೆಲ್ಲ ಟೆಕ್ನಿಕಲ್ ಆಫಿಷಿಯಲ್
True. I will examine it is helpful for me also. I will examine the judgment and make my submission and then let's start up hearing. Have the matter next week.
ಇದು ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಏನಿದೆ?
First matter ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
29 ಅಲ್ಲ, ಅಲ್ಲೇ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
My lord, I will furnish one more set, my lord.
26 ನಲ್ಲಿ. Some other applications. ಇನ್ನೊಂದು 26.4 ನಲ್ಲಿ. Written objections, IA2 for documents, IA for vacating stay, vacating interim order, ಅದನ್ನ ಒಂದು ವಾರ ಆದ್ಮೇಲೆ ಬರ್ಲಿ. Recalling application ಇದೆಲ್ಲ 26.5 ಅದು ಕೊಡಿ ನೋಡೋಣ.
ಇದರಲ್ಲಿ
ಇದನ್ನ.
we have deposited the
Notes and. Judgment.
in 6382.
ಒಂದ್ ನಿಮಿಷ ಒಂದೊಂದಾಗಿ 26.5 ನಲ್ಲಿ 2271.
My lord, it was dismissed for non-prosecution.
ಇದರಲ್ಲಿ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ನಲ್ಲಿ ಯು ಸೇ ದಟ್ ಯು ಹ್ಯಾವ್ ಡೆಪಾಸಿಟೆಡ್, ಅದೇನೋ ಕಡಿಮೆ ಇದೆ ಅಂತ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮೆಮೋ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಆಯ್ತು, ಯು ಆರ್ ಪ್ರೆಸಿಂಗ್ ಆನ್ 26.4 ಫಾರ್ ವೆಕೇಟಿಂಗ್ ಇಂಟರ್ವ್ಯೂ.
26.4 ಅಲ್ಲಿ we have deposited the balance.
ಕರೆಕ್ಟ್, ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್.
ಅಲ್ಲ this now well in time we have deposited the balance amount before the court below.
ಅವ್ರು ಕೇಳ್ತೀವಿ ವೈ ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿಸ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ, ದೇ ಆರ್ ನಾಟ್ ಡೆಪಾಸಿಟೆಡ್. ಎರಡು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದಾರಲ್ಲ, 4 of 22 and 1 of 23.
ಹೌದು, ಅದು
not deposited ಅಂತ ಹಾಕಿದ್ದಾರೆ.
Yes.
ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದಕ್ಕೆ ಮೈ ಲಾರ್ಡ್ earlier learned counsel my lord had filed, I had no knowledge of that.
Now whether they have deposited or.
My lord, they are making a statement that they have deposited.
I have brought the DD for having deposited amount before the court below.
ಈಗ ಅವನ್ನೆರಡು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಾ ಏನ ಅಥವಾ ಯು ವಾಂಟ್ ಟು.
My learned friend's statement may be recorded and disposed of.
Those are applications.
ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಅದೇನು ಮೆಮೊ ಹಾಕಿ ಕೊಟ್ಬಿಡಿ ಹಾಗಿದ್ರೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ.
Just now I have brought to the.
My lord, my instructions are that my lord, they haven't deposited. It is all old deposit.
ಕನ್ಸಿಡಿಂಗ್ ಅಂತ ಕೇಳ್ತಾ.
It is a old deposit, it seems.
Deposited on 22/8.
Amount, ಸರಿ award amount.
Only sir.
ಸರಿ.
22/8/2024.
Award amount in compliance the interim order of this court is deposited. Response counsel seek time to examine and submit. List on after 1 week ಅಂತ ಹೇಳಿದ್ವಲ್ಲ ಅದರಲ್ಲಿ 10 days. 10 days. 10 days ಅಂದ್ರೆ after vacation ever. 2371 ಏನು 2271.
2271, my lord.
ಬಂದಲ್ಲಿ ಏನಿದೆ recalling. ಏನಾಗಿತ್ತು?
My lord, it was dismissed for non-prosecution.
Order dated 23/10/2019. ನಿಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಡಿನೈ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ನಾವು ಆ ಪೀರಿಯಡ್ಗೆ 2019 2024 ಯು ಡೋಂಟ್ ಗೆಟ್ ಇಟ್ ರಿಸ್ಟೋರ್ಡ್. ವೆನ್ ಹ್ಯಾವ್ ಯು ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್? In the year 2023.
My lord, it was filed on 18/7/23.
Correct. ಈಗ it was dismissed on 23/10/2019.
5/7/23, my lord.
Correct. 20, 21, 22, 3 years plus 7 months, 6.
It was,
Will
it
deny
was-
for that period.
my lord, it was
What is-
dismissed on 5/7/23.
5/7.
ಹೌದು. I have filed application, my lord, on 18/7/23.
5. ಅಲ್ಲೇನೋ ಮೇಲಿನ ಡೇಟ್ ನೋಡಿದ್ರು 23/10. 5/7. You are right.
5/7.
ಏನದು what was the needful to be done?
My lord, port fee was required to be paid.
ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ?
My lord, I'll pay it in 1 week, my lord, unless it is recalled, my lord.
This application subject to payment.
ಆಗ್ಬೋದು.
As a precondition for consideration of I 2023, needful shall be done within 10 days.
Please, my lord,
Failing which I 2023 shall stand dismissed.
please, much.
Next, ಇನ್ನೊಂದು ಇದ್ರ 26.6 ಇದೇನೋ LR application, that's what he was.
My lord, that is, my learned friend is,
As requested by response counsel. Yeah, not even filed wakalat.
Please.
New. Counsel for respondent 1 and 2, list after 10.
In this matter, we have filed wakalat, we have the appointment for.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದಿರಿ? ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ?
Wakalat filed on 11/9/2024,
11/9. ಇವತ್ತೆಷ್ಟು ಡೇಟು?
but our name is not shown. 24.
24 ಅವತ್ತಿಗೆ ಮಾಡಿದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡ್ತಿದ್ರಲ್ಲ. ಯಾವ ಕೇಸಲ್ಲಿ ಮಾಡಿದ್ರಿ? ನಂಬರ್ ನೋಡಿ ಮೇಲೆ.
23,
There are multiple cases.
MFA number.
23/29 of 2019, 23.
Shri Nagaya Lala Council submits that he has filed wakalat in the registry on ಎಷ್ಟು 11/9.
11/9.
ಬಂದಿದೆ. ಮತ್ತೆ ಇದು ಯಾಕೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? ಸಾರಿ, ಬರೀ ಇದರಲ್ಲೇ ಟೈಮ್. Lala Council registry has placed the wakalat of Shri Nagaya for respondent 1 and 2. His name shall be shown in the call list accordingly. Okay. He seeks time to submit on I number 1 to 3 of 2023, list after 10 days. Okay, 10 days 1 week. Non-filing of amended cost rate.
We will complete course of the day.
Request 10 days time is granted to do the needful. Elladrallu 10 days ಅಂತ ಬರುತ್ತೆ. List of yes, next question.
So number 27.
Appellate.
Kantar Gavle.
26/123, your lordship. 26/123, I appear for respondents in 3 cases. 26/123.
ಆಯ್ತು ಹೇಳಿ ಮುಂದೇನಾಗ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ they have not deposited as ordered by your lordship. 50% of the total award amount they have to deposit.
ಅಂತ ನೋಡಿ 10 days ಅಲ್ಲಿ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ vacating application ಹಾಕೊಳ್ಳಿ. ಇಲ್ಲಾಂದ್ರೆ you can execute if they have not done that. Yes.
My lord, in this
Number
case, I appear
27.
for the appellant, my lord. The objections are ready, my lord. I shall file it. Kindly be called immediately after vacation.
Withdraw the amount, madam.
He is not entitled to withdraw the said amount, my lord. Objections are ready, my lord. I am awaiting affidavit.
Counter to that.
Yes, my lord.
5 lakhs he has deposited and
ಅದು counter file ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ kindly my lord, we have served the copy on 5/9 itself.
5/9.
5/9/2024.
5/9. They are awaiting the affidavit, my lord, from the party who is at Mysore.
ಇದರಲ್ಲಿ only we withdraw the amount.
I shall file my objections, my lord, called immediately after.
To seek time to file counter to I 1 of 2024, list on date ಕೊಡ್ತೀವಿ.
30th.
No,
After
no.
vacation, before vacation, list of
Audit.
1510.
15.
Great.
So number 28, by Rajendra Prasad Shetty, Nitin Prasad.
For the respondent. Council on record is not in station, my lord, he has intimated me. Some date may be fixed, my lord.
IA for withdrawal ಹಾಕಿದ್ದೀನಿ.
ಇಲ್ಲ, ಹಾ.
ಇಲ್ಲ ಅವ್ರ objection ಕೂಡ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ ಅಂತ.
Furnishing of PF to the.
ಇಲ್ಲ ಅದು
civil
ಬರಲ್ಲ. ನಾನು
PF they are
ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ.
ಹಾಕ್ಬಿಟ್ಟು.
already they have filed
But
ವಕಾಲತ್.
since Nitin Prasad has appeared for the respondent, office objection regarding furnishing PF to respond is overruled. Okay. Withdrawal of the amount is money recovery suit.
Yes.
Then
Advocate on record ಇಲ್ಲ sir. He is not in station.
is what is
Some
Some
date.
date may be fixed.
as requested by Appellant's counsel, list on
1610.
16.
Great.
Please.
So number 29, P Mahesha.
For the appellant.
For 2 weeks.
Sorry.
328
It will be called, my lord, after 2 weeks, my lord, I will file.
non-filing of wakalat advocate for response.
Last time, my lord, I have been served with a copy.
ಅಲ್ಲ ಸರಿ ವಕಾಲತ್ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು.
The ವಕಾಲತ್. I have sent to my lord the papers.
328 days ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋದು. ಅವ್ರು ವಕಾಲತ್ ಹಾಕ್ಲಲ್ಲ.
Delay may be condoned.
ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೋದಾ?
But this is a matter wherein Malat's claim petition was dismissed. Injury case. During the pendency of the claim petition, the original claimant died, Malat. The tribunal has dismissed the claim petition, Malat.
On the ground that it
On the ground that,
survive.
please, Malat.
ಅದು incorrect ಅಂತ ಕಾಣಿಸುತ್ತೆ.
Because he is sustained, my lord, fracture of,
Appeal is filed by whom?
by LR.
By the LRs of the original claimant.
During pendency of,
Come on record even before the
Please,
tribunal.
Malat.
pendency of the claim petition itself, not the original claimant died. The LRs have been brought on record.
He is submitting that the trial tribunal has dismissed the application on the ground that cause of.
Yes, ma'am, there is
does
no,
not
there is no nexus between the injuries suffered, my lord, and the,
no nexus ಅಲ್ಲ cause of action survive ಆಗೋದಿಲ್ಲ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
no nexus ಅಂತ ಹೇಳ್ತಾರೆ.
ಏನು ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರ ಮಾಡಿರ್ಲಿಲ್ವಾ?
ಅಲ್ಲ, no post-mortem report, no doctor, nothing.
Yeah, not examine the doctor, then why did you not examine?
Malat,
See, to claim compensation.
Malat, I'm not on the part that I died because of the accident injured,
Even for
Malat.
injuries it is does not.
Please, Malat,
It
Supreme
survives.
Court had submitted a judgment, Malat.
Yes.
Please, Malat, Supreme Court
Even if there is no nexus, cause of action survives.
survives, Malat.
That is the.
But for limited purpose, not it survives.
The limited
I am-
expense for injuries, medical expenses.
Please, Malat, attendance charges, medical expenses,
but-
lots of estate time
The entire
entitled,
picture.
Malat.
That has been rejected by the internal page, not 14. On the ground that the only medical bills have been produced without any prescription.
Malat, prescription is not needed, Malat. There are medical bills in the name of the patient.
But you should have done one thing. You should have examined the doctor. Why did you not examine?
Malat,
the-
that was a mistake which was done by the advocate
Even-
before that.
Now again, remand.
Please,
Even-
Malat.
Even no PM report, what nothing has been,
ಅಲ್ಲ,
postmortem report.
that's whether it was disputed by you.
I am not disputing that
You, they have disputed the death. It appears the tribunal dismissing the petition on the ground that she died, and she was, they were permitted to come on record shows that he had not disputed the death.
Eh,
Now he is saying, even assuming that death had no direct nexus to the injuries, still his petition survives.
For limited blood, about medical expenses and
Limited or unlimited, that is only thing. Now they have not examined the doctor even to prove the
no material,
expense and injury suffered by the victim. That is their mistake.
no,
Now,
no
now-
medical records, nothing.
petition can be, case can be remanded ಅಂತ ಹೇಳ್ತಾರೆ.
Remanded under, because there is no material has been produced before the tribunal. Even no discharge summary, murder.
Play condoning ಮಾಡೋದು. ನೀವು, if you keep stretching it like this, then it will adjourn it to some other day by condoning the delay. Because you have not yet filed wakalat.
Yes, madam, yes.
Service ಆಗಿತ್ತೋ ಇಲ್ವಾ?
Service-
Before service only was directed to take notice or?
Please, Malat.
Yes, madam. Last time, madam, he. served the
Considering
copy.
this aspect, your lordships had directed me to serve a copy on him, Malat.
ಓ, ನೀವು ಹಾಗೆ ಮಾಡಿದಿರಲ್ಲ, ಅಪೀಲ್ 2023 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ, it was
On
not
two-
complied.
On 2/9, murder, second day of this month.
Office objection 2024 ವರೆಗೂ ಕಂಪ್ಲೈ ಮಾಡೋದಿಲ್ಲ ನೀವು.
Malat. Sorry, Malat. I didn't know that aspect, Malat.
Yeke, you are a new advocate?
No, my lords, this file was not with me, my lords.
Not with you means?
My lords, I joined this office later on, my lords.
Adela, vicarious liability, you have to take it.
Please, my lords.
Even before.
I don't understand.
Compliance ಗಿಂತ ಮೊದಲನೇ ಅವ್ರಿಗೆ notice ಕೊಟ್ಟಿದ್ದೀವಿ ಇಲ್ಲಿ.
I don't understand.
You have complied, it came before the court on 12/2/2024. Appeal is filed in 2020.
23, my lords. 22nd May 2020.
Yes, sir. 2024. ಏನಂತ ಹೇಳಿದ್ದಾರೆ ರೀಸನ್ 41 years.
No, 67.
His son or?
See, lady not age about 67 years.
Not contact his earlier counsel.
ಅಲ್ಲ ಅದಾಯ್ತು ಇವರು how he is related to the deceased?
Yeah, children.
Children, my lords.
41 ವರ್ಷ ಅಂತ ಇದೆ.
ಅಲ್ಲ 67 ವರ್ಷ.
36 ವರ್ಷ, my lords.
No, see the daughter.
ನಿಮ್ಮಲ್ಲಿ 41 years ಅಂತ
ಅಲ್ಲ
ಬರ್ದಿದ್ದೀರಿ.
daughter but they are the
Abdul Naveed who has won the affidavit, my lords.
LRs melody.
Son of Fatima. How old was that lady?
67 years.
67 years, 65 years at the time of accident.
In court judgment, 67.
65.
Plus deny ಮಾಡೋಣ. ನೀವು 2 ವರ್ಷ ಕಂಡ್ರೆ 3 ವರ್ಷ delay of 328 days in filing the appeal is condoned in the interest of justice with a condition that if the appellant succeeds, appellants succeed, they shall not be entitled to interest on the compensation. Now, no compensation for a delayed period of 328 days.
Please, my lords, very well.
1/24 is disposed of. Oh, delay application 1 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದೀರಾ?
For that.
Admit call for TCS.
Please, my lord.
Please,
Obliged.
Bill number 30, Pawan Kumar Vayan.
Manager New India Assurance Company. Yes, they are served.
Yes, my lords.
CD of 122 days. Case of death or injury?
Case of injury. Yes, my lords.
You are on which point? 10,67,750 is granted.
Yes, my lords.
You are on what point?
Sorry, my lords.
You are on which point? On what point you have challenged the award?
My lords, income.
Is there disability taken?
Disabilities, my lords.
On the lower side or income is on the lower side?
Yes, my lords. Income and disabilities are lower side.
Both you are disputing?
Yes, my lords.
120 days. ಯಾರು ಇಲ್ವಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅವ್ರು ಇಲ್ಲ ಯಾರು? ಮ್ಯಾನೇಜರ್ ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ಕಂಪನಿ ಅವರೇ ಹೇಳ್ಕೊಂಡು heard the appellant's counsel. The respondents, those served are unrepresented. And the respondent to those served is unrepresented. Considering the reasons assigned to explain the delay of 122 days in filing the appeal is condoned in the interest of justice, with the condition that if the appellant succeeds, he shall not be entitled to interest on the delayed period of 122 days. Yes. Shall not be entitled to interest on the enhanced compensation for the delayed period of suit. And 1/2023 is disposed of accordingly. Admit call for TCRs. List after the receipt of TCRs. Let the trial court take back.
Obliged. Bill number 31, Government Advocate.
If you for the state, your lordships have imposed some cost, I have paid you.
We had asked you to get it paid through the officer.
Yeah, ಅವ್ರ ಕೈಯಿಂದ ಕೊಟ್ಟಿರೋದು.
ಅವ್ರ ಕಡೆ
ಇದು copies.
ಇಸ್ಕೊಳ್ಳೋದೇನೋ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Leonard GS. You are AG?
AG.
Leonard AG. So and so. So and so Leonard GA submits memo with ಒಂದೇ ಸೆಟ್.
2 set ಕೊಟ್ಟು.
Memo with cost paid receipt.
Please. ಆಮೇಲೆ
next.
And modification of one submission.
Yes.
ಇದರಲ್ಲಿ interim order has been granted on 16/7/2024, your lordship, on deposit of 50% amount and 50% in.
Now delay is not yet condoned. Delay has to be.
ಅಲ್ಲ, ಅದ್ರ ಆಗಿದೆ, already stay has been granted, but execution court has not released our ತಿಂಗಳಿ-
The order?
Please, sir, I am producing all the copies in four
When
matters.
was that order interim order was passed?
16,
7/2024.
please, your lordship.
Now this appeal arises out of which LAC?
ಒಂದೊಂದು appeal separate ಇದೆ.
ಅಲ್ಲ ಎಲ್ಲಾ appeal ಅಲ್ಲೂ attachment ಆಗಿದೆಯಾ?
ಹೌದು, ಹೌದು. ನಾನು ಕಾಪೀಸ್ ಕೊಡ್ತೀನಿ, your lordship. It's
Similar application is filed in all the cases?
similar, separate applications, your
ಅಲ್ಲ
lordship.
separate but in all these cases.
ಇದು ತಗೊಳ್ಳಿ, ಇದು 4 ಕೇಸ್ ಇದು. Your lordship, I will take it,
But you are hurrying only about that application. First submit on your delay condonation application.
My lords, may I make one?
1,402 days delay. How much is 1,401? ಇನ್ನು 31.1 compliance ನಲ್ಲೇ ಇದೆ. Issue notice to R3 and 4.
My lords, may I make one
What has
submission?
happened, your lordship?
Are you taking notice in that?
Please, my lord, in serial number 31 and 31.3, my lord, I appear for
31.1.
31 and 31.3, my lord.
You appear for the claimants.
Please, my lord, the respondents herein. You received the papers, my lord. I may be granted a short time to file wakalat and objections to the IAS, my lord.
And 30,
31 and 31.1.
3, my lords, 31 and 31.3.
and 31.3 ಅಲ್ಲಿ already taken notice.
ಹೆಸರು 31.3.
2 ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ ನೋಟಿಸ್.
31.3 ನಲ್ಲಿ
ಇವ್ರು ಈಗ ತಗೋತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ,
ಅಷ್ಟೇ ಇದೆ.
31.2 ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ.
31 point I appear for the respondent claimant. 31.2 ನಲ್ಲಿ I already filed wakalat.
ನಿಮ್ ಹೆಸರು ಇದೆ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ?
ಇದೆ
ಕರೆಕ್ಟ್ ಅವರಿಗೆ 31 and 31.3 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. There is a sole respondent.
Please, my lord.
ಪ್ಲೀಸ್ ಎಲ್ಲಾದ್ರು 31.2 ನ 3
Shri so
Three,
and
ma'am.
so,
Three.
learner council. You have filed wakalat or yet to file
Correct
wakalat?
to file, my lord.
Undertakes to appear for respondent. This is Rashid. He is permitted to file the wakalat in the registry within ಇದು ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅಲ್ಲ ಪ್ರಾಪರ್ಟೀಸ್ ಮೀನ್ ಫರ್ನಿಚರ್ಸ್ ಆರ್ ಅಟ್ಯಾಚ್.
ಹೌದು, ಅಟ್ಯಾಚ್ ಆಗಿದೆ. And last 2 months government department is not able to work, your lordship. Department ಗೆ ತುಂಬಾ ಕಷ್ಟ. Day to day general public is suffering end of the day, your lordship. Revenue department.
ಕರೆಕ್ಟ್ ಯು ಹ್ಯಾವ್ ಡೆಪಾಸಿಟೆಡ್.
Please, your lordship, I produced now copies, everything.
ಅವ್ರ ಹೆಸರು ತೋರ್ಸೋಣ. So and so is undertakes to appear for respondent. Is permitted to file a wakalat in the registry. The registry shall show his name in the causes accordingly. Now, yes, submit on the delay condonation. We'll go one by one.
Please, your lordship, first matter ಅಲ್ಲಿ
401. Do you have serious objection for delay condonation?
13.2 I have to file objection, my lord.
Correct, 2023 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಲ್ಲ?
ಅಲ್ಲ
And
ಇವಾಗ
in one
recent
case, your party was served and she has not appeared.
now only 18/7 I have filed wakalat. Last week is matter posted. I will seek for 2 weeks. Again matter is posted by in view of their seeking for modifications.
Correct, file ಮಾಡ್ಬೇಕಲ್ಲ objection ಅನ್ನ ನೀವು ಅಷ್ಟರಲ್ಲಿ. Otherwise we have to consider the next application. Now they are submitting that they have deposited. Is that correct?
Please, I have produced all the
Lord,
sets.
as per my instruction,
ಇಲ್ಲಿದೆ ಇದರಲ್ಲಿ ಇವಾಗ ಫುಲ್ ಸೆಟ್
ಕೊಟ್ಟು copies
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
Lord, entire 50% amount is not deposited. Only they have
Entire
deposited 92,67,473. Crore 79,27,000. They are not calculated. That is the, I will produce the trial court order.
One thing, this calculation will not do. We'll delegate it to the executing court. If the entire amount deposited is 50%, let them release,
Yes, yes.
raise the attachment.
Yes.
Sir,
Yes.
now I have produced some
We will
documents, your
decide.
lordship.
If you have deposited, you should go
Please, your
to the
lordship.
executing court and convince it.
Yes.
No, we said, your lordship, in spite of that, execution court has now passed order. In page number, now I have produced the copy, your lordship. Now ಇವಾಗ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ page number 78 ಅಲ್ಲಿ.
Page number 70.
8, your lordship. Now they have, execution court has passed order saying that application under 161, 151 filed by JDR is hereby allowed. Office is directed to release the attached property in favor of the JDR department in accordance with law by collecting necessary charges if incurred any in accordance with law. Further, DHR is also directed to deposit the expenditure or security amount if there is any balance to be paid. To pay balance ಅಂತ till the date of ಅಂತ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
Balance ಎಲ್ಲ ಕೇಸ್ಗಳಲ್ಲೂ
Your lordship, page number executable order is page.
Correct. The trial court or executing court has not said here
Yes.
whether it satisfies the 50% or not.
Page number 40.
Entire amount ಬೇಡ.
ಇಲ್ಲ ಇಲ್ಲ
But,
ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. Page
the
number, your lordship may.
Executing court does not say that this satisfies.
ಅಲ್ಲ, our contention is that ನೀವು till date ವರೆಗೆ interest ಕೊಡ್ಬೇಕು ಅಂತ. But executable order is at page number 47, your lordship. 47.
Forty-seven.
47, your lordship, page number. ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ಆದೇಶ ಆಗಿರೋದು 4,93,86,050, your lordship. Out of 50%, 2,46,93,026.
Interest.
Not calculated the interest.
Interest, your lordship, till the issuance of warrant, your lordship, execution.
That's why we said we will not calculate it, we'll delegate it to the executing court. If it is satisfied, then the attachment shall be raised. Otherwise, that can proceed. Executing court.
But order.
You find satisfy there. If it is not, you file a memo of calculation there.
ಎಲ್ಲ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. ಅವ್ರು ಬಟ್ ಟಿಲ್ ಡೇಟ್ ವರೆಗೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆರ್ಡರ್ ನಮ್ಗೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಬಂದಿರೋದು ಇದ್ರ ಮೇಲೆ.
It's the order passed here.
Please, your lordship. Page number.
What was the
Page number 16, your lordship. 14 in the 16. 16. Order. 16, your lordship. Page number 6. ಈ ಕೊಟ್ಟಿಲ್ಲ. A waiver assigned affidavit so and so acceptable is hereby allowed and operation of the judgment and award dated 18/11/2007 LAC number separate LAC number ಇದೆ.
Deposit of 50% with accrued interest before the court.
Yeah, till the executable order.
Huh?
Till the execution of warrant banda.
No, it says till 50% of the award amount with accrued interest.
Before the below that we have deposited.
The order was passed in 16/7/2024.
Please,
Have
sir.
to calculate the interest up to 16/7/2024 and a deposit. Have you calculated up to 16?
This one, if at all execution court had this clarification, they could have easily told us, clarify the order.
They tell us you have taken an order from the high court, you should.
Because.
Madam, you are unnecessarily
Please,
taking
your
our
lordship,
time.
please. On that, we are ready to deposit that till date, your lordship. That whatever order has.
ಮೊದಲು ಹಾಗೆ ಹೇಳಿದ್ರಿ, ಈಗ ಹೇಳ್ತೀರಿ.
ಅಲ್ಲ ಏನ್ ಮಾಡೋದು, because ಅವರು 2 months ಇಂದ all the materials all seized. Your
ಆಯ್ತು, 2 months ಇಂದ ಆಫೀಸರ್ಸ್ ಯಾರು ಸ್ಯಾಲರಿನೇ ತಗೊಂಡಿಲ್ವಾ?
that I have no.
Then ಈಗ ಅವ್ರು ಕುತ್ಕೊಳ್ಳೋಕ್ ಕುರ್ಚಿ ಇರೋದಿಲ್ಲ, ಅದಕ್ಕೆ
ಅಲ್ಲ ಅವ್ರು ಪ್ರೈವೇಟ್ ಲ್ಯಾಪ್ಟಾಪ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ ಡಾಟಾ ಎಲ್ಲ ಇದೆ, ಪಬ್ಲಿಕ್ ಜನರಲ್ ಪಬ್ಲಿಕ್ ಡಾಟಾ. your lordship,
taken an order, you should comply it.
please, we have complied and your lordship may pass that order, we will deposit, your lordship.
Delay condone ಮಾಡೋಣ ಎಲ್ಲದರಲ್ಲೂ. Delay condone ಮಾಡಿ this order will clarify. That's all. They have to pay the interest of.
We'll pay, your lordship. We'll pay, your lordship.
Administrative delays ಎಲ್ಲದರಲ್ಲೂ.
Administrative delays only.
ಮತ್ತೆ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡೋದ್ರಲ್ಲೂ 1402 days ಅಂದ್ರೆ ಎಷ್ಟು ವರ್ಷ ಆಗುತ್ತೆ ಚೆಕ್ ಮಾಡಿ.
different date ಇದೆ, your lordship.
ಅಲ್ಲ ಇರ್ಲಿ.
ಒಂದರಲ್ಲಿ
2 cases ಅಲ್ಲಿ 1400.
ಇನ್ನೊಂದರಲ್ಲಿ
And in one case you have not even furnished the PF.
More than 3.5 years.
ಇಲ್ಲ ಎಲ್ಲದರಲ್ಲಿ ಇಲ್ಲ. ಒಂದರಲ್ಲಿ 639, ಒಂದರಲ್ಲಿ 420, ಇನ್ನೊಂದರಲ್ಲಿ 1402, your lordship.
ಎರಡರಲ್ಲಿ 1402.
Please, your lordship, please.
And ಇನ್ನೊಂದು 31.1 ನಲ್ಲಿ we do not know because it's not mentioned here.
Not mentioned.
ಅದಕ್ಕೊಂದು ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕಾ ಈಗ?
No.
Who is responsible for this delay? ಫೈಲ್ ಕಳ್ಸೋದೇ ಇಲ್ಲ, ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಅದನ್ನ ಮುಚ್ಚಿಟ್ಬಿಡ್ತಾರೆ.
Some administrative.
ಏನ್ ನಿಮ್ದು ಮೂವ್ಮೆಂಟ್? Award was passed on 18/11/2007.
Please. 17 ಒಂದು.
17, I'm sorry.
ಒಂದು 17, 121, ಒಂದು 19 ಅಲ್ಲಿ.
Letter was written on 1/6/2020.
Please, your lordship. ಒಂದು 17 ಅಲ್ಲಿ, ಒಂದು 21 ಅಲ್ಲಿ, ಒಂದು 19 ಅಲ್ಲಿ, ಇನ್ನೊಂದು 17 ಅಲ್ಲಿ.
ಅವ್ರು ಯಾರು ಲ್ಯಾಪ್ಸ್ ಮಾಡಿರ್ತಾರೆ ಅವ್ರ ಕಡೆಯಿಂದ ರಿಕವರ್ ಮಾಡಿ, ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಹಾಕ್ತೀವಿ.
ಮಿನಿಮಮ್.
In these appeals ಎಲ್ಲ 31 to ಅಲ್ಲಾದ್ರಲ್ಲಿ ಇನ್ನೊಬ್ರಿಗೆ ನೋಟಿಸೇ ಸರ್ವ್ ಆಗಿಲ್ಲ. 31, 31.2.
We have given your lordship already second time.
31.1 ಅಲ್ಲಿ R3 and 3 ಸರ್ವ್ ಆಗಿಲ್ಲ. 31, 31.2 31.3, 30, list ತಗೊಳ್ಳಿ.
And ಇವಾಗ ಇವ್ರು ತಗೋತಾ ಇದ್ದಾರೆ 31.1 ಅಲ್ಲಿ.
No, my lords,
Delay
1 ಅಲ್ಲಿ ತಗೊಳ್ತಾ ಇಲ್ವಾ?
31.3.
is the administrative reasons. Cases involve inordinate delay of 1,400. Two cases involve inordinate delays of 1,401 and 1,402 days. Considering the same, the delay of 1,401, 639,
ಇನ್ನೊಂದ್ರೊಳಗೆ 553.
1,400, ಅದರಲ್ಲಿ ಇನ್ನೂ ಸರ್ವ್ ಆಗಿಲ್ಲ, that we cannot condone. 1,402 is hereby condoned on payment of cost of rupees 2,000 in each case payable to the High Court Legal Service Committee ಅಥವಾ Advocates Welfare Fund. Advocates Welfare Fund cost shall be recovered from the officer who has committed the lapses on holding an inquiry, and a report to that effect shall be submitted to this court. IA 1 of 2023 23 are disposed of accordingly. So far as IA number 1 of 2024, counsel for the appellant submits that the appellant, despite the appellant depositing the amount in compliance with the order of interim order of this
16/7/2024, your lord.
2024, the executing court is proceeding with execution, and the property of the appellant are attached. Whereas counsels for respondents submit that the appellant has not deposited the entire 50% with accrued interest up to 16/7/2024. Liberty is reserved to both the parties to file memo of calculation and satisfy the executing court in that regard. If the order is complied, the executing court shall not proceed with
Release
the recovery.
ceased, already cease ಮಾಡಿದ್ದಾರೆ.
Executing court shall not, shall release the attached properties. If the order is not complied, the executing court is at liberty to proceed further.
Within 3 weeks.
In 3 weeks.
ಅಲ್ಲಿ ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ, ನೀವು ಹೋಗಿ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಾಕಿ ಸ್ಯಾಟಿಸ್ಫೈ
Please,
ಮಾಡಿ.
please.
ಯಾಕೆ 3 weeks? ಸೂನ್ ನಾಳೆ ನೀವು ಹೋಗಿ ಪ್ರಿಪೋನ್
Please,
ಮಾಡಿಸ್ಕೊಂಡು ಇದರಲ್ಲಿ 31.1 ಅಲ್ಲಿ ಫೈನಲಿ 2 weeks time is granted to do the needful in respect of respondent 3 and 4, failing which appeal against them shall stand dismissed.
Permission to withdraw the amount.
ಮೆಮೋ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕಾ ನಮಗೆ? ಆಫೀಸಲ್ಲಿ ಕೊಡಿ, ಅವರೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರೆ. ಅದನ್ನೆಲ್ಲ ನಾವು ಚೆಕ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಮೆಮೋ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
One request, withdrawal of the amount after debt.
You file the application.
Number 30.
ಇನ್ನು ವಕಾಲತ್ತೆ ಹಾಕಿಲ್ಲ ಕೆಲವೊಂದು ಕೇಸಲ್ಲಿ.
Number 32, Shruti SP, Vishnu Vinayak CR.
Paying for the appellant, my lord.
Pay for the respondent in this case.
Yes, what do you say for the condonation of delay?
420 days in delay, my lord.
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ? What do you say?
I'll file my objections, nuts.
ಯಾವಾಗ?
20 days, ಒಂದು ವಾರ time. I'll file my objections to the stay application as well as the delay application.
ಏನು, what is the
My lordship, it's
First
ex parte
the-
decree.
ex parte decree?
Yes, my lordship. Paper publication, no notice whatsoever, served. That's why there is a delay.
ಅಲ್ಲ, prior to the decree of divorce,
Yes, you are staying in the same address or different address?
Staying in the same address, my lordship. No,
Staying
no.
with him only?
No, my lordship.
But why the paper publication was taken?
ಕೋವಿಡ್ ಟೈಮ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇದು ಕೋವಿಡ್ ಕೇಸ್.
Yeah.
case.
21 ಅಲ್ಲಿ my lordship. ಅವಾಗ ಇನ್ನು
Action was filed in 2021 and decree was passed in
divorce, there was a petition for restitution of conjugal rights filed by the respondent. That was contested by the petitioner through her advocate. She did not file any objections. She did not contest the petition.
restitution case, she had not contested.
ಇಲ್ಲ ಮಾಡಲಿಲ್ಲ.
Probably she was also willing for restitution.
ಅಲ್ಲ, ಹಾಗಾಗಿ ಇದ್ರೆ ಅಲೌ ಮಾಡ್ಬೋದಾಗಿತ್ತು, ಇಬ್ರು ಜೊತೆಗೆ ಸಂಸಾರ ಮಾಡ್ಬೋದಾಗಿತ್ತು, ಅಲ್ಲೂ ಬರ್ಲಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ ಲೀಗಲ್ ನೋಟಿಸ್ ಕಳಿಸಿದ್ವಿ, ರಿಸೀವ್ ಮಾಡಿದ್ರು, ಅವಾಗ ಬರ್ಲಿಲ್ಲ. ಬರ್ತಾ ಇಲ್ವಲ್ಲ ಅಂತ ಡಿವೋರ್ಸ್ ಕೇಳಿದ್ರು, ಇವಾಗ ಬಂದ್ರು ಗಂಡ ನೆನಪಾಗಿ.
420 days is condoned in the interest of justice. I number 2 of 2024 is disposed of accordingly. Admit call for TCRs, interim stay of the execution of the impugned decree till further orders. I have 1 of 2024.
ಅಲ್ಲ, I'll file my objections. Until then, ಒಂದು ವಾರ ಟೈಮ್ ನನಗೆ. After I file my objections, let the IA be considered on merits.
We saw it has taken place during COVID period.
22ರಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿರೋ ಡಿವೋರ್ಸ್ದು.
ಆಗಿದೆ, ಶುರು ಮಾಡಿದ್ದು 21ರಲ್ಲಿ into 2021 you filed the petition in this thing.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಮುಂಚೆ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಹಾಕಿದ್ವಿ, ಬಂದ್ ಸಂಸಾರ ಮಾಡ್ಲಿ ಅಂತ, ಅದಕ್ಕೂ ಬರ್ಲಿಲ್ಲ.
3 times we'll repeat that. Next person.
Case number 33, Ganpati Bhatt.
This case, my lord, there is a 45 days delay. In connected matter, interim order granted, my lord. The suit has been decreed, my lord, partially decreed. Insofar as, my lord, item number A.
The appeal is admitted.
My lord, first appeal is filed by me.
Huh.
My lord, plaintiff's suit for partition and separate position is partly decreed, as against which I am before your lordship. My appeal has been admitted. Now, my lord, my friend says that, my lord, he has filed another appeal. Allah, adan nanage papers kottru nan yak
Condoning the delay, appeal is admitted. You are saying first appeal is admitted.
ಹೌದು.
First appeal, there is delay of 44 days.
ಅಲ್ಲಲ್ಲ, ಅದರಲ್ಲಿ ಇವ್ರು ಹಾಕಿರ್ತಕ್ಕಂತ
First appeal ನಿಮ್ದು ಅಂದ್ರಲ್ಲ.
First ನಂದು
His appeal is first.
ಫಸ್ಟ್ ಸಾರಿ, ಐ ಬೆಗ್ ಎ ಪಾರ್ಡನ್.
Urgent for
This is my case.
ಅಲ್ಲ, ಇದು this is by plaintiffs or defendant?
No,
The other one is by plaintiff. Other ಇನ್ನೊಂದು ಕೊಡಿ ಅದನ್ನ. Appeal ಇಲ್ಲಿ.
Suit schedule A, my lord, B. And B schedule 1, 2.
Plaintiff.
2 to 6 has been, my lord, to B. Which is, my lord, that they are.
What is your explanation for delay?
Delay, my lord, that I have filed affidavit.
How they are related?
Please, my lord.
How they are related parties?
Appellants, my lord, that they are
Not this plaintiffs are the
This is, my lord, plaintiff Sunandamma is the wife of, my lord, one of the brother of the plaintiff.
Sunandamma. Defendant number 1 is Sunandamma. Defendant number 1 is Sunandamma. Huh.
She is the wife of late, my lord,
Srinivasamurthy.
Narasimha.
Srinivasamurthy.
Srinivasa.
Hmm.
Srinivasamurthy.
Hmm.
Srinivasamurthy is the brother of plaintiff. And, my lord, the Srinivasamurthy died. Therefore, my lord, that they have brought the son and
Sisters of the deceased.
yes.
Hmm.
And, my lord, my private property has been included, which the trial court has, my lord, rejected. Insofar as schedule A property and item number 1 of the B property, my lord, the C property.
Item number 1 and 4 in B schedule properties are the self-acquired properties of defendant number 1. That was your contention.
How?
That is held partly in affirmative.
ಹೌದು ಸರ್,
ಯಾವ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿಲ್ಲ ಅದರಲ್ಲಿ 1 and 4 ಅಲ್ಲಿ?
ಬೆಂಗಳೂರಲ್ಲಿ ಇರೋದು.
ಅಲ್ಲ, 1 and 4. He claimed that 1 and 4
ಹೌದು.
are the self-acquired properties. 4 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. Number 2 to 6 of B schedule property ಅಂತ ಹೇಳಿ. So far as item number 4, your prayer is rejected.
Item number.
4 in B schedule property.
My lord, I have sought dismissal, which has been, my lord, has not.
But issues show that your challenge was only with regard to B schedule item number 1 and 4.
No, it is statement, my lord, everything.
Like-
Clearly, I have taken a contention, so in the written statement filed by me, saying that, my lord, item number.
Yes, are you seriously disputing the delay condonation, learned counsel?
ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ
ಗಂಗಾಧರ್
my
ಅವರು
lord, my humble
Notice order.
ಇನ್ನ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನು
ಅಲ್ಲ, ನಿಮಗೆ ನೋಟಿಸ್
ಬಂದಿದೆ.
ಮಾಡಿ. You represent all the response.
ಇಲ್ಲ ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ.
Only
ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಅದಕ್ಕೆ ಅಲ್ಲಿ ಏನಾಗಿದೆ,
Only
ನಾನು
plaintiffs,
ಕಾಪಿ
huh?
ಕೊಟ್ರೆ ನನ್ನ ಪ್ರಾರ್ಥನೆ, ನಾನು ಯಾರಿಗ ಅಪಿಯರ್ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿ ನಾನು
ಅಲ್ಲ ರೀ, ಬೇಡ ಅಂದ್ರೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ಬಿಡಿ. ಹೇಗಂದ್ರೆ ಹೇಗಿದ್ರು ಡಿಲೇ ಇದೆ, ವಿ ಕಾಂಟ್ ಪಾಸ್ ಆರ್ಡರ್. ವಿ ಆಸ್ಕ್ ಹಿಮ್ ವೆದರ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಅಪಿಯರ್. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ರು
my lord, my anxious
ಎಲ್ಲರೂ ಪ್ಲೇಂಟಿಫ್ಸ್ ಇದ್ದಾರೆ.
ಇಲ್ಲ, ಎಲ್ಲಾರು
ಆಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ ಶೋನ್ ಆಸ್ ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 1 to 12.
ಅಲ್ಲ, ಒಂದು ಪ್ರಾರ್ಥನೆ, ನನ್ನ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಎಲ್ಲಾ ಪ್ಲೇಂಟಿಫ್ಸ್ ನನ್ನ ಜೊತೆ ಬರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಹಾ.
ನಾನು ನಂದ್ರಲ್ಲಿ co-plaintiff ಗೆ ನಾನು ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು.
Respond
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್
ಮಾಡಿದ್ದೀರಾ
3 ಗೆ
ನೀವು?
ಹೌದು.
ಯಾವ ಮೇಲ್
ಹಾಗಾಗಿ ನಾನು ಇನ್ನು ಅವ್ರ ರೆಕಾರ್ಡ್ ಮೇಲೆ ಬರ್ಬೇಕು.
ಒಂದ್ ನಿಮಿಷ.
ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಅವ್ರು ನನ್ನ ನನ್ನ ತಮ್ಮನ ಹೆಂಡತಿ ಮಕ್ಕಳು ಕೋಪ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರು. ನಾ ಪೂರ್ತಿ ಆಸ್ತಿನಲ್ಲಿ ಭಾಗ
ಅವ್ರು ಹೇಳೋದು ಅವರಿಗೆ ಕೆಲವೊಂದಿಷ್ಟು ಜನ they have not joined him
ಹೌದು ಸ್ವಾಮಿ.
in filing the appeal ಅಂತ
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್. R3 ಗೆ ನಾನು ಸ್ಟೆಪ್ಸ್ ತಗೊಂತೀನಿ.
One-
ಇನ್ ದ ಮೀನ್ ವೈಲ್ ನಮ್ಮ
Plaintiff
ಸ್ನೇಹಿತರು
number
ಕೊಡ್ಲಿ
one-
ನಾನು
1 to 5, 10 to 12 they have joined together.
ಹೌದು. R3 ಗೆ ನಾನು ಸ್ಟೆಪ್ಸ್ ತಗೊಂತೀನಿ. ಬಿಕಾಸ್ ಈ ಇಸ್ ನಾಟ್ ವಿತ್ ಮೀ.
ಆಯ್ತು ನಿಮ್ಗೆ ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ? ಅವ್ರು ಯಾರಿಗೂ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
ಅದು ಒಂದ್ಸರಿ ನಾನು ವೆರಿಫೈ ಮಾಡಿ ನಾನು
ಬರ್ಕೊಳ್ಳಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಬರ್ಕೊಳ್ಳಿ. ಇಶ್ಯೂ ನೋಟಿಸ್
R3 ಗೆ ನಾನು ಒಂದು ವಾರದಲ್ಲೇ ತಗೊಳ್ತೀನಿ.
the respondents. ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಮಾಡ್ತಾ ಇದೀವಿ. ನಿಮ್ಮದ್ರಲ್ಲೂ ನೀವು ಹ್ಯಾವ್ ಟು ಕಂಪ್ಲೈಂಟ್. ಅವ್ರೇನೋ ನಾವು ನೋಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ, ಬೇಕಾದ್ರೆ ನೋಡಿ
ಮಾಡಿ.
ಅವ್ರಿಗೆ ನೀವು ಕಾಪಿ ಸಾರು ಮಾಡಿ, ಅವಾಗ ಅವ್ರ ವಕಾಲತ್
ನಾನು ಹೇಳೇ ಬಿಡ್ತೀನಿ.
in your case you have to take fresh steps to R3.
ನಾನು ತಗೊಳ್ತೀನಿ ಸುಮ್ಮನೆ ಒಂದು ವಾರ ಟೈಮ್.
ಅಲ್ಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಮಾಡಿದ್ರಲ್ಲಿ ಡೇಟ್ ಹೇಳಿದ್ರಲ್ಲಿ 13/11
Please.
ಇದರಲ್ಲಿ 33.1 ಅಲ್ಲಿ at request 10 days time is granted to do the needful. If no needful is done, issue notice to respond number 3 list on same date.
Please. I am
ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು ಅಪೀಲ್ ಅದು 832 ನಲ್ಲಿ ನಾವು ನೋಟಿಸ್ ಮಾಡ್ತಾ ಇದೀವಿ. ಅವ್ರು ಯಾರೋ ಪ್ಲೇಂಟಿಫ್ಸ್ ನೀವು ಕಾಪಿ ಕೊಡಿ, ಅವ್ರು ಕೊಟ್ರೆ ಅವ್ರು ಅಪೇರ್ ಆಗ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Seal number 34, Vijay Kumar R, Venkatesh H.N., B. Somshekhar Naidu.
I am permitted to file the objections to IA number 2, Madam. I'm sorry, yesterday I couldn't file it.
IA2 were vacating state.
Modification of interim order ಕೇಳಿದೀನಿ. Even their objection statement, they say that it may be permitted. Therefore, the entire compensation amount has. Interim order is saying the entire compensation amount payable.
So when that was passed?
That was passed on 1/7/2024.
Your Lordship may permit me to file the objection.
Section
I have served a copy.
1/7/2024.
Yes.
Keeping up open office objection relating to jurisdiction
1/7/20.
is granted, restraining response from withdrawing the deposited before the court.
Can I make one submission, Madam?
What is that compensation?
What can I make this submission?
It is his application part, first list.
IA number 1 is there for entire thing, for injunction and all that. Then, my lord, at that time, what happened is on 1/7/2024, there are some confusion about the jurisdiction of the High Court. So whether it should go back to the district court or whether the High Court, that confusion was
No,
going
it's
on.
not there. No. Now
Not,
it's-
not now. Then the lordship said, as an interim measure, we will do this, we'll take it up later.
Right.
Then, my lord, if my lords permit me to make submissions on IA 1, I will assist your lordships. Or IA number 2, you can make, then I will.
His application, no, IA2 for vacating, IA1 for TI.
Yes, ma'am.
Now interim order was granted. He wants this to be.
No, that interim order is limited to only withdrawal, not to withdraw. But I have sought for a comprehensive interim order for injunction and all that. Because there are some property which should not be alienated. Not only the compensation, there are other properties.
You can make your submission.
Yes, madam. I am grateful to your lordships. My lord, what happened is, Mrutyunjayappa was the father. If your lordships were to see the genealogy,
Page number,
kindly come to the genealogy, my lord, which I have produced.
page number, any
Yes, my lord. Just a moment, my lord. 78, my lords. My lord, take page number 78. And he is the father of,
78.
your lordships got it, my lord?
Yes, yes.
Mrutyunjayappa was the father of the appellant. He had two wives, namely Gangamma and Shardamma. Then, my lord, D1 was born to Gangamma, first wife. So far as Shardamma is concerned, she left behind all these 8 members, 7 members. Then that is how, my lord, they have, Mrutyunjayappa had 8 children, namely 4 sons and 4 daughters. Admittedly, my lord, these properties are self-acquired properties of Mrutyunjayappa.
suit schedule properties. There is no dispute about it.
The father-
Relationship between the parties, there is no,
The plaintiff is whose daughter?
Sharadamma's daughter through Mrutyunjayappa. He had two wives. Then my lord, these,
ಹೆಸರು P degree ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರೇ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
ಹೌದು, ಒಂದು ಗಂಗಮ್ಮ ಅಂತ ಒನ್ ಅಂತ ಹಾಕಿದೀವಿ, ಅದು ಟೂ ಇಂದ ಹಾಕ್ಬೇಕಷ್ಟೇ.
Right, all those facts
ಇದು
are
ಒಂದ್ ನಿಮಿಷ ಇರಿ.
admitted.
ಒಂದ್ ನಿಮಿಷ
Nothing
ಇರಿ.
has been disputed. Simply dragging on the issue.
He should convince us to be, let him submit.
Right, suit is dismissed. Suit is dismissed.
Let
Now
him-
he is trying to get an injunction order.
Let him submit this one.
There is already an interim order operating in favor of him.
We are hearing you on this application. Do you permit us to hear you on the application or not?
My application has to be heard, Your Honor,
No,
because parties
You
are
have filed-
90-year-old, 90-year-old.
Learned counsel, look at the application. Entire application was not allowed. If
Yeah.
application was allowed, right, only your application has to be heard for vacating. The application was not allowed in its entirety,
Yeah,
only.
quite true.
part-
Right, there are-
I am intending to take the compensation amount which has been stayed by this honorable court. That is my grievance, Your Honor.
See, you are the officer of the court, right?
Yeah, I am assisting the court.
Right. Now, IA 1 and 2 are to be heard. IA 1 is his application.
Please hear,
Here
please
he-
hear, please hear.
Here he
Then
must-
without hearing IA number 1, there is already an interim order that has been heard ex parte.
Interim order was granted only limited, not the, as sought in IA number 1. So you have filed vacating. That application is not fully disposed of. That application is still pending. Yes, yes.
Sorry, ma'am. Now what has happened is this, my lord, admittedly, my lord, Mrutyunjayappa left behind 4 sons, namely defendant number 1. My lords were to see the OS judgment. He left behind defendant number 1. My lord,
Yes.
that is M.R. Rajshekaraya. Then my lord, the other son Shankarappa, defendant number 2, he died even before the suit was filed. Then my lord, his children were brought on record, namely 2A Mrutyunjaya and Manjunatha. My lord, they were brought on record. Then my lord,
See,
deed,
now your
Now the-
relationship is admitted. On what
and-
ground you are disputing their entitlement?
now 1 minute, my lord.
Huh.
After the death of Mrutyunjayappa, under section 8 of the Hindu Succession Act, all his children have succeeded to the estate of Mrutyunjayappa.
Yes.
4 daughters are entitled to 4/8 share. The 4 sons are entitled to 4/8 share. Now, I filed the one plaintiff filed the suit. The other 3 sisters supported my case, they also sought for partition. Now the trial court holds that these self-acquired properties of Mrutyunjayappa. And applying Vinita Sharma, it says that partition has taken place in 1995, 1994 between the 4 brothers, to which we are not parties. The sisters.
When was that partition? But in
7/11/1994, my lord.
7/11/19, when
Yes.
father died?
Exhibit, my lord.
1965.
He died in 1964.
Partition between whom?
Between the 4 brothers, namely defendant number 1, deceased Shankarappa, defendant number 4, and defendant number
D1,
5, my lord.
4,
4, defendant, father of defendant 2A and 2B,
our sons, auto.
All 4 sons and
4 sons. ಸುಮ್ನಿರ್ತೀರ ತಾವು?
Between sons, okay. But according to, this was a self-acquired property of,
Therefore, my lord, that is not binding on us.
What
The
is-
4 sisters,
what is, right, how he acquired that property?
they acquired it under sale deeds, that is admitted. There is no ancestral
Which
property.
year?
And the prior to his death.
It must be
No, no,
prior to death only.
there is no dispute about it, my lord. We don't get these details of all that.
They claim that the suit is barred by limitation. That was one ground they had.
That is correct. That is, your lordship will have to,
Joint properties of herself and.
your
dependent
lordship will have to visit that those issues, whether the barred by time, whether this decrease.
What was the substantial defense ante ಕೇಳೋದಕ್ಕೆ?
Substantial defense was that there is a partition in 1994. That is the defense. Mainly that is the defense of the brothers.
Trial court has rejected on the ground that there was already a party.
There was a partition to which we are not parties. Supposing, my lord, we were parties. My lord, in a case where it is ancestral property, there is a partition, my lord, then Vinita Sharma will come into play.
Limitation is also held against you.
Limitation, there are no proof of Worcester, there cannot be proof of Worcester. The daughters are married, they are staying with their respective husbands. The brothers are there.
Additional issue number 2 is
Yes, my lord.
And does not bind her.
Yes,
Yes, what is your case? That's all?
that is one thing, my lord. What I am saying is,
My lord,
kindly look at,
ಅದೇನೋ ಮುಗ್ದಿಲ್ಲ ಅಂತ ಹೇಳಿ. Yes. ಹೇಳಿ, yes. What is the other contention?
1 minute, my lord. Now, my lord, the appeal is yet to be admitted. Records are not yet called for. Your lordship sees the decree, my lord. There is one item, 7 acres, 10 guntas of land. What happened is this, my lord. Out of
Which
10
which is
acres
the-
of land, out of 10 acres of land, 3 acres were acquired by the National Highway Authority, which is 11th respondent in this appeal. It granted compensation, 1,52,51,52,983. It deposited in an acquisition case before the learned principal district judge at Chitradurga. That amount is lying in deposit. Now, my lord, all the parties, 8 parties are entitled to 1/8 share in the compensation. That is number 1. Then, my lord, what happened is, the item number 1 is still available, 7 acres, 10 guntas. Item number 2 is the compensation. Item number 3 is a house property situated in so and so. Now, my lord, what I am saying is, kindly grant an injunction insofar as not to alienate insofar as item 1 and 3, item 1 of A schedule and item schedule B till the disposal of this appeal. That is number 1. Please do not disperse the amount of 1,51,52,000.
According to they are entitled to certain shares, 8 share, 1/8 share.
Yes, that could be. That is why I said if your lordships take my objection filed today, your lordship should kindly see that. What I am saying is, subject to furnishing adequate security,
Even according to they are entitled 1/8 share each.
similarly, I am
Now,
entitled. Similarly, I am also
sir,
entitled.
your entitlement has to be decided now.
Quite true. What could be done is this, my lord. Their 1/8 share, D1 and D8, that could be released in their favor, subject to any condition that your lordships may. Because subject to the,
But it was your clear case, no, before the trial court that they are also entitled to 1/8 share.
quite true, everybody is
All-
entitled.
All
Now,
sons.
four daughters and 4 sons are all equally entitled to. If supposing, my lord, the properties are, some properties are sold and all that happens,
Alienation aspect is different.
your lordship may protect the interest of the daughters. What I am saying is, kindly look at their plight also. The daughters are married and they are staying with their husband.
Yes, that's
Now
the-
that is one. Your lordship may pass an interim order in IA number 1. So far as IA 2 is concerned, your lordship will kindly take my paragraph number 9, ma'am. Today, which I have filed. What I am submitting to your lordship is, your lordship, if your lordships think reasonable, at the end, my lord, paragraph 9.
Yes.
If your lordships think right and fair to permit a respondent 1 and 8 to withdraw their 1/8 share in the compensation amount, subject to furnishing adequate security to the satisfaction of this honorable court, so that the interest of all parties to these is protected. In the event of this honorable court permitting the respondent 1 and 8 to withdraw their 1/8 share compensation, remaining amount be ordered to be kept in fixed deposit. Your lordship may keep it in fixed deposit. I'm not coming in the way. I'm not saying, please pay it to me.
By way of objection, you are making another prayer, another application.
No, madam. I'm only assisting your lordship. That's
Yes,
it.
ಹೇಳಿ. ಸ್ವಲ್ಪ
my lord,
ತಾಳ್ಮೆಯಿಂದ ಇರ್ಬೇಕು.
ಆಯ್ತು.
Yes, ಹೇಳಿ.
ಇವಾಗ respondent number 1, he is the eldest son of the family.
ಹ್ಮ್.
And respondent number 8,
Respond number 8. ಹ್ಮ್.
ಈ ಇಬ್ಬರಲ್ಲಿ ಮತ್ತು ಒಂದ್ ಶಂಕರಪ್ಪ and ಮಹದೇವಪ್ಪ ಅವ್ರ 4 ಜನದಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಗಿದ್ದು. ಅಂಡರ್ ದಿ ಪಾರ್ಟಿಷನ್ ಶಂಕರಪ್ಪ.
One query, whether according to this is self-acquired property of the father or ancestral property? According to you, whether these properties are the self-acquired?
My submission is that, my lord, it is an ancestral property.
Now, what was the ground taken before the defense taken before the trial?
It is judgmental ancestral property and I have
Was
taken.
contained
Yes,
as
my lord.
ancestral.
Yeah. First, initially, they also took up a contention that it is the ancestral property.
Right property ಅಂತ issue ಮಾಡಿದ್ದಾರೆ.
Plaintiff.
ಅಲ್ಲ,
ಇಲ್ಲ
issue-
ಆಮೇಲೆ subsequent ಆಗಿ it came to be amended. And later they claim that it is joint Hindu family property. It was self-acquired property of Mrutyunjayappa. Now the question is, my lord, the 2 brothers, Shankarappa and Mahadevappa, they have, one Mahadevappa sold the property in favor of his own brother Rajshekharaya, that is R1. Under the very partition deed, Shankarappa said that I don't want any partition, amount has to be settled by Rajshekhar. He has bequeathed his property in favor of M.R. Rajshekhar. Therefore,
Relinquished.
pardon?
Bequeathed or relinquished? Relinquish ಮಾಡಿರೋದ bequeath ಮಾಡಿರೋದ?
ಅದು ರಿಲೀಸ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾನೆ. He has released in fact. So, property of Shankarappa and Mahadevappa is not available for any partition, and their members claiming again under Shankarappa and Mahadevappa does not arise. Therefore, respondent number 2, respondent number 3 and 4 and 5 and 6 are not entitled for any partition or any relief in the compensation amount. First thing. The secondly, Lord, the court has held that father died in the year 1965.
According to you, who are not entitled, respond number?
2 to 6, 2, 3, 5, 6
Heirs
and
of-
7.
Heirs of Shankarappa and
Shankarappa's son is respondent number 2.
you said some two persons or two family members released their share. Who are those members? Shankarappa and Mahadevappa, na?
Shankarappa, Mahadevappa has sold. He has executed a sale deed itself after partition.
Favor of
In favor of Rajshekhar, R1.
Shankarappa and yaru ಮತ್ತೆ?
Shankarappa released his share under the partition deed.
Mahadevappa sold it.
Yes, Mahadevappa sold by way of registered sale deed. 2.5 acres, 2 acre 20 guntas.
So there is no conflicting interest between them.
No conflicting interest.
They
But
have
unnecessarily they have been.
ಕಾಮನ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದಾರಾ? ಇಲ್ಲ ಬೇರೆ ಬೇರೆಯವರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಕನ್ಸುತ್ತೆ.
R2, R3, R4, R4 ಇಲ್ಲ. R4 is the daughter. R5, R6, R7.
D5 is Prabhudevaya.
Prabhudevaya is my brother. He has got a share under the
They have
partition.
filed a common.
Leelavati is having a share according to her, according to them. And Manjula is having a share. So R9, R10, R8 and R1
So they have
and R4
Yes,
are only the
yes.
parties who are entitled, provided that this court comes to a conclusion that partition has to be effected.
Yes.
My lord, before the court below, it was contended that father died in the year 1965, Murtyunjayappa.
Yes.
Succession to claim partition open on 1965, my lord. 1964, I mean, sorry. Suit is brought
2018.
in 2018. I have also sought a plea of ouster of the plaintiff and her other sisters who are subsequently got married in the year 1967. 67, 70, 75, they married. He, the respondent number 1, in place of his father, he looked after them. He married, he performed the marriage of his sisters, and they were out of the family. Nobody was in possession of the suit schedule, either suit schedule property, that is land, agricultural land, or the house. House which was referring to is the house constructed by R1. A thatched roof was earlier in the year 1965. That was demolished, reconstructed by R1. He was an engineer in PWD, Lord, then itself, at
We
the
saw
date of.
that castrated. We are seeing more disputes in the engineers family, PWD engineers family. Yes.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಏನು ಅಂದ್ರೆ ಇವಾಗ they don't want land, they want money, for which his brother never said. He is the son of his first wife's of Murtyunjayappa. The other children, 7 children, are second wife's children. He brought them up, he educated them all
Now that property was standing in his name.
in his name, and his another brother R8. He is owner of 2 acre 20 guntas. and M.R. Rajshekhar being, having acquired the property under sale deed and relinquishment deed,
When
he
the
is
pro-
entitled
When the property was acquired,
acquired,
probably the suit is filed after that.
ಅವಾಗ್ಲಿಂದನೇ ಶುರು 17 ಅಲ್ಲಿ notification, 18 ಅಲ್ಲಿ suit filed. The court has come to the conclusion that suit is barred since the plea of
We are now not hearing on the main matter. We are hearing on this interim applications. Right? Those things have to be considered.
My lord, when the trial court has dismissed the suit of the plaintiff, holding that she is not entitled, suit is barred under law, all this has to be heard by your honor on merits.
Yes.
The as on date to obtain an order of injunction, the appellant must show that there is a prima facie case in her favor. That is not there. Balance of convenience. I am not asking the court to pay entire compensation to me. I am asking only our share. Respondent 1 and respondent 8 share should be provided because they are already approaching their evening life.
That's what he considered for that, 1/8 share.
That's why until this is decided whether they are entitled to or not, question of granting injunction does not arise. Absolutely, prima facie case is not there.
Only thing in reply, one thing I would like to point, my lords permit me, kindly look at the finding recorded by the trial court, paragraph 26, my.
Correct. It's not.
Just a moment.
Was dismissed on the ground of limitation
I'll tell your lordship, 1 minute.
and on the ground of prior.
1 minute, man. Kindly look at para 26. And
Here, instead of showing that.
the finding is that we have a right by succession. In para 27 at page 60, your lordships will kindly come to page 60. There's a categorical finding recorded by the trial court that we have by inheritance have 1/8 share, the daughters who have.
No, what he said, he is 1/8 share if we permit them to withdraw that.
But your
that's
lordship may
okay.
consider,
He
subject
said
to
that.
whatever condition my lords may fix, and in relation to IA number 1, rest of the properties be protected.
He respond over 1 and 5. We represent
1 and 8, your honor.
1 and 8.
1 and 8.
I represent 4, 5, 6, 9 and 10.
You sail with them, it seems.
Yes, they are
4, 5,
daughters, they
6,
also filed the statement and they also want
The
partition.
trial court has recorded that they have sailed with you.
Yes, correct, absolutely.
5 and 6 have no right because they have already sold the property. Their children cannot claim.
1
As
and
your-
8, alva?
As your lordship knows,
Eight proposal.
in a partition suit, my lord, everybody is a plaintiff,
Malcolm.
everybody is
Malcolm,
grateful.
But
Order, sir.
R1 is entitled to 3 shares, my lord, not 1/8 share. 1/8, 1/8, 1/8.
ಈಗ ಇದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಆಗಿರ್ಲಿಲ್ವಾ ಅಡ್ಮಿಟ್ ಮಾಡಿ
ಇಲ್ಲ, ಇನ್ನು ರೆಕಾರ್ಡ್ ಕಾಲ್ ಫಾರ್ ಆಗಿಲ್ಲ, ಮಾಡ್ಬೋದು.
ಬರೀ ಇಂಟ್ರಿ ಮಾಡರ್
ಹಾ, ಹೌದು, ಅವತ್ತು ಇದು ಕನ್ಫ್ಯೂಷನ್ ಇತ್ತಲ್ಲ, ಅದರಿಂದ ಯಾವ್ದು ಮಾಡ್ತಿರ್ಲಿಲ್ಲ.
ಹಾರ್ಡ್ ಮ್ಯಾಟರ್ ರಿಕ್ವೆಸ್ಟ್ ಟು ಟೇಕ್ ಕನ್ಸಿಡರೇಷನ್ ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCRs. Appellant's counsel shall file the paper books within
8 weeks, my lord.
8 weeks. ಎಲ್ಲರೂ senior citizens
ಇಲ್ಲ,
ಇದ್ದಾರೆ.
6
Within
weeks,
4 weeks.
6 weeks, my lord.
4 weeks. ಅದ್ರಲ್ಲಿ ಏನು?
ಆಗ್ಬೋದು. Whatever your lordship says, I am bound by it.
Orders and I number 1 and 2 of 2024. By the impugned judgment and order, the trial court has dismissed the appeal of, suit of appellant. On the ground that there was already a prior partition in the year 1994. Suit is barred by time, etc. On 17, admittedly, part of decree schedule A alva?
ಹೌದು. ಇಲ್ಲ,
Decree schedule.
larger portion was 10 acres,
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ acquire ಮಾಡಿರೋದು
3 acres.
3 acres is acquired.
ಬಿಕ್ಕಿದ್ದು schedule ಅಲ್ಲಿ item number 1.
So,
And in survey number ಅಂತ ಹಾಕ್ತಾರೆ.
acquired. And a compensation of rupees 1,51 lakhs,
Yes,
52,938
yes.
is deposited before which court?
AC before learned principal district and session judge at Chitradurga.
Correct ಅದು?
ಹೌದು.
For the principal district and session judge ಚಿತ್ರದುರ್ಗ, in case number ಎಷ್ಟು?
AC
7 of 18.
Correct, 7 of 2018. Arbitration case.
ಹೌದು.
7 of
ಇಲ್ಲ, acquisition case ಅದು.
LIC.
LIC acquisition.
LIC number 7 of 2018.
ಕೊಡಿ.
This court by order dated 1/7/2024 had restrained the respondents from withdrawing the compensation of the said amount. There is a relationship between the parties is not in dispute. Not in dispute. Even according to the plaintiff also, respondent number 1 and 8 are entitled to 1/8 share each.
ಹೌದು.
They are aged 80 and 72 respectively. Therefore, restraining them from withdrawing even their share operates oppressively. According to respond number 1, ಯಾರು ಇನ್ನಿಬ್ರು ಬ್ರದರ್ಸು ಮಹಾದೇವಯ್ಯನ
Mahadevaya and Shankarappa.
brothers. Other brothers, Mahadevaya and Shankarappa.
Yes, ma'am.
Shankarappa and Mahadevaya. Shankarappa, ಮೊದಲದು Shankarappa, the predecessors of predecessor of respondent number 1 to ಯಾರು ತಂದೆ ಅವ್ರು ಎಲ್ಲಿಂದ ಎಲ್ಲಿವರೆಗೂ ಇಲ್ಲಾಂದ್ರೆ ಹಂಗೆ ಬರ್ಕೊಬೇಕು ಅಂದ್ರೆ ಅದರ್ ಟೂ ಶೇರರ್ಸ್ ಹೀಗೆ ಇಷ್ಟ ಬರ್ಕೊಬೇಕು. Shankarappa and Mahadevappa have relinquished / sold their shares to respond number 1. Therefore, whether plaintiff and the heirs of Shankarappa and Mahadevappa are entitled to receive any compensation has to be decided on hearing of this appeal. But however, there is no difficulty in directing to release the shares of respondent number 1 and 8 in the compensation amount referred to above. So far as Schedule B property and Schedule A and the other part of Schedule A property which is not acquired, the same need to be preserved till the disposal of this appeal.
And even Schedule B, my lord, there is house property.
Part of Schedule A.
No,
Part of Schedule A property is not
Schedule A
acquired.
is total extent 7 acres.
ಅಲ್ಲರಿ ಅದ್ರಲ್ಲಿ ಎಲ್ಲ ಅಕ್ವೈರ್ ಆಗಿಲ್ಲ 3
ಇಲ್ಲ
ಎಕರೆ.
ಇಲ್ಲ, ಅದು 10 ಎಕರೆ ಇದ್ದಿದ್ದಲ್ಲಿ 3 ಎಕರೆ ಅಕ್ವೈರ್ ಆಗಿದೆ, ಐಟಮ್ ನಂಬರ್ 2 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು.
ನೀವು ಐಟಮ್ ನಂಬರ್ 2 ಅಂತ ಮಾಡಿಲ್ಲ, ಐಟಮ್ ನಂಬರ್ 1 7 acres 10 ಗುಂಟಾಸ್.
ಅದೇ ಕರೆಕ್ಟ್, ಅದು ಬಂದು ಫುಲ್ ಇದ್ದಿದ್ದ.
ಉಳಿದಿರೋದಾ?
ಹೌದೌದು, ಅಕ್ವೈರ್ ಆಗಿದ್ಮೇಲೆ ಉಳಿದಿರೋದು.
Schedule A item number 1 and Schedule B property need to be preserved ಅಂತ ಮಾಡಿ. Then ಉಳಿದಿದ್ದು ಕರೆಕ್ಟ್. Hence the following order. Respondent number 1 and 8 are permitted to withdraw 1/8 share in the compensation deposited before the in LIC number 18 of 2018 before the principal district judge
ಚಿತ್ರದುರ್ಗ.
correct ಅದು
ಹೌದು,
ಚಿತ್ರದುರ್ಗ.
ಹೌದು.
The other amount shall be invested in FD in any nationalized / scheduled bank for a period of 1 year ಅಂತ
ಒನ್
ಮಾಡ್ತೀವಿ.
ಇಯರ್ ಮಾಡಿ
For a period of 1
ಆಟೋಮೆಟಿಕ್
year.
ರಿನ್ಯೂವಲ್ ಒಂದು ಆಪ್ಷನ್ ಕೊಡ್ತೀವಿ ಇನ್
The
ಕೇಸ್ ವಿ ಡೋಂಟ್
response
ಗೆಟ್.
are hereby restrained from alienating suit schedule A item number 1 and suit schedule B property till further orders.
Great.
Number 1 and 2 of 2024 are disposed of accordingly.
Let there be an observation that the compensation amount of R1 as well as sale deed and release deed, he is entitled to 3 shares, Your Honor. ಅಲ್ಲ 1/8 share ಅಂತ ಬಂದಿದೆಯಲ್ಲ.
1/8 ಈಗ ಸದ್ಯ ಕೊಡೋದು 1/8.
ಅಷ್ಟೇ.
ಯಾಕಂದ್ರೆ
ಅಲ್ಲ ಅವ್ರು ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಮಾರಾಟ ಮಾಡಿದ್ರು ವಿಲ್ ಡಿಸೈಡ್ ದಟ್.
ಹೌದೌದು, ಹೌದು.
ಮಾರಾಟ ಮಾಡಾದ್ಮೇಲೆ ಅವ್ರದ್ದು
We do not know what was the
Correct.
written statement. Records are not before us.
ಹೌದು.
Soon after the records are issued, you can do that. Because they are there, the trial court judgment shows that they filed written
ಹೌದು
statement
ಹೌದು 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 ಹೌದು
supporting them.
ಹೌದು ಅಬ್ಸಲ್ಯೂಟ್.
1 and 8 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಏನ್ ಹೇಳಿ?
Sale deed, it is a registered sale deed and registered partition deed.
Yes. Next.
Much obliged.
My lord, if there is any mistake committed by us, kindly pardon.
ಏನಿಲ್ಲ ನಾವು ಹಾಗೆ proceedings ನಡೀಲಿ
We are only trying to assist your lordships in it.
35
Great.
ಶಿವಶಂಕರ್ SK Cantes, P. Madhusudan Rao.
Okay, correspond number 1.
My lord, in this, my lord, one submission, my lord. The party is intended to engage one more counsel. The NOC is ready, he is be collecting today, my lord.
Serial number
Notification.
in 78. Okay. One is for TI, one is for stay. Whom do you represent?
I appear for appellant, my lords.
They cannot adopt these kinds of tactics.
No,
ಮಾಡಿದ್ರೆ ಮಾಡ್ಬೇಕು ಇಲ್ಲ ಅಂದ್ರೆ interim order ತಗೊಳ್ಳುವಾಗ ಒಬ್ರು
no, my lord, there is no interim order there in this matter. There is no interim order.
No interim order.
order ಆಗೋದನ್ನ postpone ಮಾಡೋದಕ್ಕೆ.
Illa, sir,
Last time
it's,
your lordship said.
because it has a technicality and one more IA is filed, my lord, in the last week for additional grounds. Additional grounds, they want to engage another counsel along.
Now appeal was filed by the plaintiff.
Yes, my lord.
Suit has been rejected, so they filed a suit for partition.
Under Order 7
been
Rule 11, my plaint came to be rejected, my lord. I am the plaintiff.
Now who is going to file NOC ವಕಾಲತ್ತು?
I have already kept ready, my lord, as per instruction. He has to collect it.
ಬದಲು ಬೇರೆಯವರು ಬರ್ತಾ ಇದ್ದಾರಾ?
Yes, my lord. Ramachandra Reddy, they are engaging Mr. Ramachandra Reddy.
ಅದಕ್ಕೇನ್ ಟೆಕ್ನಿಕಲ್ ಪ್ರಾಬ್ಲಮ್?
My lord, and they one IA is also filed, my lord, in the last week. For that purpose only it is filed. For additional grounds.
Additional grounds in order 13.
It is titled as 1 under 39 rule 1 and 2, but it's
No,
actually
no, my
under
lord.
6 rule 17.
6 Rule 17.
ಇದ್ದಾರೆ.
I'll see.
ಆ ಇಂಡೆಕ್ಸ್ ನಲ್ಲಿ 39 ರೂಲ್ 1 and 2 ಅಂತ ಬರ್ತದೆ.
I'll correct that, my lord. They have filed one.
ಗ್ರೌಂಡ್ಸ್ ಅಮೆಂಡ್ ಮಾಡಿದ್ರೆ ವಕಾಲತ್ ಹಾಕೋದಕ್ಕೆ ಏನ್ ಟೆಕ್ನಿಕಲ್ ಪ್ರಾಬ್ಲಮ್?
My lord, they have sought.
ಸರಿ, yes, what do you say?
No interim order that it may be taken up after vacation.
Interim order is not
ಏನ್
there.
ಇಲ್ಲ.
No, it's not there, ma'am.
Keep it, sir.
Keep it up sometime after vacation.
As requested by the appellant's counsel, list after 2 weeks.
Very
Ach.
grateful.
ಇಷ್ಟು ಹೇಳೋದಕ್ಕೆ ಸುಮ್ನೆ 2 weeks ಟೈಮ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬೋದಿತ್ತಲ್ಲ. Yes, next.
Number
Great.
36, Rajshekhar S.
Appearing for the appellants in this case, my lord, there's a delay of 18 days,
12 days.
12 days, my lord.
18 days or 12 days?
12 days, my lord. Notice has to go to the respondents, my lord. The appeal is filed challenging the rejection of the counterclaim filed by the appellants in MC number 548 of 2022, my lord. For
Counterclaim
counterclaim for seeking divorce, my lord.
of the is hereby decreed. Respondent is directed to restore the matrimonial relationship.
She has filed counterclaim to
For that, counterclaim for dissolution.
dissolution of the marriage, my lord.
Issue notice.
No, that's a connected case, my lord.
Which is that?
MFA 2083 of 2024, my lord.
This is ordered in that.
Yes, my lord. Stay has also been granted, my lord.
Particularly ಬಂದ್ಮೇಲೆ connect ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
Please, my lord.
Issue notice. Respondent list on
1311.
Grateful, my lord.
Say number 37, Chandrasekhar GM.
Yes, madam. Here in this case, this is the defendant's appeal by the husband, and there is an ex parte judgment and decree, and she filed a dissolution of their marriage and also sought for permanent alimony. Accordingly, there is a delay of 14 days in filing the present appeal, madam. Right?
notice to the respondent.
Yes, please,
List on
11.
please.
Till number 38, Sharad Gowda GB.
Your lordship, suit is for declaration, your lordship. It delays there, your lordship. 222 days.
your suit is
Declaration, your lordship.
because the declaration.
In the trial court, I am the defendant, your lordship. Defendant appeal is this, your lordship.
The interview is hereby declared as null and void.
Yes, your lordship.
But why, on what ground?
Your lordship.
On what ground?
ಸ್ವಾಮಿ
Because-
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ ವೈಫ್ ಅವ್ರಿಗೆ ಮೊದ್ಲೇ ಮದ್ವೆ ಆಗಿರುತ್ತೆ, ಆಕೆ ನನ್ನ ಲೀಗಲ್ ವೆಡೆಡ್ ವೈಫ್, ಇವ್ರಲ್ಲ ಇವ್ರು ಇದನ್ನ ಹೇಳಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಇದಾಗಿದೆ, ಡಿಗ್ರಿ ಆಗಿದೆ ಇದು.
He himself, he marries and again he comes and declares, claims this thing, or he has disputed the marriage also?
Disputed the marriage only.
Marriage also. Issue emergent notice to the respondent, list on
2310.
23.
Much obliged.
For admission, cell number 39 adjourned. Cell number 40, Chandrasekhar PV, Harish HV.
On it, my lord.
ರಿಲೇಶನ್ಶಿಪ್ ಬೆಳೆಸ್ಕೊಡ್ತಾರೆ ಮೊದಲು.
The land action officer, three appeals were filed. Two are already admitted by your lordships and enter interim order of stay subject to depart of 50% of the amounts. In fact, in this case also, we have departed 50% even before the order passed. My friend has made an application for withdrawal of that amount also.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಅಷ್ಟೇ ಉಳಿದಿದ್ರಲ್ಲಿ.
ಇದೊಂದರಲ್ಲಿ ಇದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಂಪ್ಲೆಕ್ಸ್.
My application not put up, my lord.
ಪುಟಪ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲ. Put up and
ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಅಷ್ಟೇ ಇದೆ.
ಅಲ್ಲ,
ಕೇಸಸ್ ಇದಾವೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ ಬಟ್
I'm pass on the order passed by lordships in other cases.
appeal has been valued at 3,81,380. The appeal is to
Some office objection could not.
single judge ಬಂದಿತ್ತಾ? It was before a single judge.
It was dismissed for non-compliant office objection. It was listed before single judge, that's recalled.
After recalling, it is listed.
Listed before divisional bench.
There was no interim order earlier.
No, my lord.
There was no. 2022 matter.
No, three appeals were filed, two are admitted only by oversight. I could not
One
complete
submission,
it.
my lord. I claimant also filed appeal, my lord, 3 appeals, my lord. That appeals along with my lord list it
Appeal order ಎಷ್ಟು 38 ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ನಾನು?
38, 51, 37, 38.
38, 73, 36, 30 and 37, 38.
My appeals not put up, my lord.
ಇದರಲ್ಲಿ interim stay ಇದೆ, subject to deposit of.
I have departed already, my lord.
Already
ಇಲ್ಲ,
LC.
deposit.
My lord, what has happened in two cases, we lordship have passed on order. So I instruct,
ಇದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ ಅಂತ ಸುಮ್ನೆ.
ಮಾಡಿದಾರೆ, ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರೆ ಇಲ್ಲೇ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ, ನಾವೇ ಹಾಕಿದೀವಿ.
ಇಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ.
ಇದ್ರಲ್ಲೂ ಹಾಕಿ ರಿಲೀಸ್ ಹಾಕಿದಾರೆ.
Notice ನಾವೇ implementing application, warrantly file application.
So you are not pressing this application.
Because they filed execution, that's why I moved for
For TCRs, interim stay subject to deposit of 50% of the award amount with accrued interest, if not already deposited.
yes.
Come on. ಎಲ್ಲಿ before this court or?
Before the reference could lordship have passed orders.
ಇಲ್ಲಿ ಮಾಡೋಣ, ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ.
ಅಲ್ಲ, ಅದು ಅಲ್ಲೇ ಮಾಡ್ಬಿಟ್ಟು ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ ಅಲ್ಲೇ ಡೈರೆಕ್ಷನ್.
ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ ಬಂದಿದೆ.
LCR ಬಂದಿದೆ sir.
ಅದಕ್ಕೆ ಇಲ್ಲೇ ಮಾಡ್ಬಿಡಿ.
ಅಲ್ಲಿ ಡಿಪಾರ್ಟ್
ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಇರ್ಬೇಕು.
ಅಲ್ಲ 3 ಕೇಸು ಬಂದಿದೆ sir.
Before
Yeah.
this court, before this court, within 4 weeks from the date of this order.
we are already departed in
If not already deposited.
there we are departed. 17/10/23 itself we are departed.
ಅಲ್ಲ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಅದು ನೀವು can file a memo to that effect. ಹೌದಾ ಮಾಡಿದಾರಾ?
ಯಾಕಂದ್ರೆ ಈ ಮೇಡಮ್
Verify, my lord.
ಅವ್ರು ವೆರಿಫೈ ಮಾಡ್ತೀನಿ ಅಂತ
Verify
ಹೇಳಿದ್ರು.
submission ಮಾಡ್ತೀನಿ sir. ಅಲ್ಲ,
ಹಾ,
the
ಆಯ್ತು.
fact that
Before the reference court ಅಂತ ಮಾಡಿ ಹೋಗಿ. Trial court, before the reference court ಅಂತ. Okay. I1 of 22 is disposed of accordingly. It is, as per the registry's note, this matter is connected to MFA number. ಇಲ್ಲಿದೆ ನೋಡಿ 3 cases ಇದೆ ಹಾಕೊಂಡ್ಬಿಡಿ. So and so list all the matters together. After records ಬಂದಿಲ್ಲ ಏನು?
ಅಲ್ಲ LCR ಬಂದಿದೆ sir.
After 4 weeks.
ಅವರೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲಿ. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಡಿಪಾರ್ಟ್ ಮಾಡಿ ರಿಲೀಸ್ ಮಾಡಿ I1/24 ಲಾಸ್ಟ್ ಕಳಿಸಿ.
ಬಂದಿಲ್ಲ ಅಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ, ಅಲ್ಲಿ ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ I1/24.
2 weeks ಅಂತ ಬಂದಿದೆ ನಮ್ಗೆ ಬಂದಿಲ್ಲ.
ಸರ್ವ್ಡ್ ಕಾಪಿ ಟು ಮೀ.
ಇಲ್ಲಿ ಬಂದಿಲ್ರಿ ನಮ್ಗೆ. When did you file the application?
That was filed on 2/24. I1/24 last ಕಳಿಸಿ.
Right.
They filed application release, decide that we are departed for.
Please direct the trial court to release the deposit.
Because we are departed, therefore they filed application.
Deposit ನೀವು application ಹೇಗೆ ಹಾಕಿದ್ರಿ? Deposit ಮಾಡಿದ್ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
No, I normally instruct the officials to depart because ಈ 3 ಕೇಸಲ್ಲಿ ಸಪರೇಟ್ ಆಗಿ ಫೈಲ್ ಹೋದ್ರೆ 6 ತಿಂಗಳಾಗುತ್ತೆ. ಒಂದೇ ಸರಿ ಇನ್ಸ್ಟ್ರಕ್ಟ್ ನಾರ್ಮಲಿ ಟು ಪ್ರೋಸೆಸ್ ಇಟ್ ಅಂಡ್ ಡಿಪಾರ್ಟ್.
ಸಬ್ಜೆಕ್ಟ್ ಟು ಡೆಪಾಸಿಟ್ ಅಂತ ಮಾಡ್ತಿರ್ಲಿಲ್ವಲ್ಲ ಆರ್ಡರ್ನ. ಹೊಡೆದಾಕೊಂಡ್ಬಿಡಮ್ಮ ಇನ್ನೊಂದ್ಸರಿ. ಸುಮ್ನೆ ಕೆಲಸ ಮಾಡಿಸ್ತೀರಿ ನಮ್ಮ ಹತ್ರ. Heard admit ಅದೆಲ್ಲ ಇದೆ. Orders in I1 of 2022 and orders in I1 of 2024. As per ಎಲ್ಲಿ ಅಫಿಡವಿಟ್ ನಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Permission to withdraw my.
ಅಲ್ಲ ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ
ಅಲ್ಲ ಏನೆಲ್ಲ ಹೇಳ್ತಾರ ಅವ್ರು.
has deposited 50%, para 7 ಅಲ್ಲಿ. I'm sorry, I have 2022 is filed seeking stay of the execution of the included award. I have 2024 is filed by
17
respondent
and
claimant,
23.
seeking release of the 50% of the award amount deposited by the appellant before the reference court.
17 and 23 ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ. Para 7.
Since 50% of the award amount is deposited as since admittedly 50% of the award amount is deposited on 17/10/2023, interim stay of execution of the included award till further orders. The reference court is directed to release
Amount in deposit.
deposit to the claimant.
Yes,
Digitally. I number 1 of 2022 and 1 of 2024 are disposed of accordingly. Yes. ಅದಾದ್ಮೇಲೆ list all the matters together. Yes.
Date given me. Date soon.
ಅಲ್ಲ ಈಗ ನಿಮ್ಗೆ ರಿಲೀಸ್ ಆಗುತ್ತಲ್ಲ
Release amount 93 is 93 land acquisition.
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks.
Date me.
Bill number 41, Dinesh Kadlas, B.N. Murlidhar.
Yes. ಏನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡ್ತೀವಿ ಈಗ ನೀವು ಮಾಡಲೇ ಇಲ್ಲ.
Worship, the facts of the case in a nutshell is this. The testator by name C.R. Anand Rao was the owner of the scheduled property. And he has purchased it in the year 1984. He has executed the will in favor of the appellant. And he has executed the will on 22/12/2020. Further, my lord, the testator's wife.
So the trial court has dismissed the petition on the
Howd,
ground that
howd, howd.
handwriting signature do not.
Howd,
match.
howd, howd,
Yes.
howd,
We'll
howd.
admit and call for records.
Please, please.
Records have come.
ಬಂದಿದೆಯಾ? Howd admit? List.
Defendant's appeal. So there's a suit for money recovery, my lords. The suit is filed under order 37 rule 192, my lords. Suit is decreed, my lords. Lords, here, my lords, the
Yesterday, somebody in the similar case, same form it seems. You are going to appear for them?
Appearing for the respondent.
serve agide, please.
Shrimati, you give your name. Shrimati so and so.
I'm for the respondent. I filed the wakalat today.
Have filed it already?
Yeah, in the today morning. It may reflect in the system.
100% submits that she has filed wakalat for the respondent today in the registry. Registry shall verify. If found correct, show her name in the process.
Kindly give a short time to file the objection.
Request. In execution ಹಾಕಿದಾರಾ ಈಗ?
Please, my lords, next date is on 22nd 10th,
22nd.
October 22nd.
Before that.
Yes, Your Honor, the case, the thing is, the beginning of this month only, the respondent received the notice. Before that, we filed the execution petition. So I apply for the copy of the certified copy of the execution petition and the order sheet and all, just for delaying only, because it's the times is already lapsed for this case. The thing is, the order is passed on 1st September 2023. Then the.
Oh, this is a summary suit, huh?
Please,
Yes,
please,
the respondent waited for 9 months to executing the order. And we didn't get any notice to file any appeal before.
It was filed in November 2023. my lords.
Yes, Your Honor. Afterwards, after filing November, 10 months they slept over to rectify the objection.
That execution is on 22nd
Please, my
October.
lords, before that.
No,
any time, I did-
execution petition filed on first in,
Correct, now it is listed on 22nd.
yes, today was
October
the hearing.
22nd.
And it next hearing date in 22nd.
From today, it is adjourned to 22nd of October.
Yes, Your Honor.
Right, if you want to file objection, you file before that.
I will file it, Your Honor.
But
Kindly give a time for.
As you, it request 1 week time is granted to file counter to I-1 of 2023. You want to file counter, no? List on soon after vacation.
1410.
1410.
15, my lords, may seek for 15.
1510.
Oblige.
Cell number 43, Priyanka Yaugal, N. Krishnaswamy, Paratu.
My lords, appearing for the appellant, my lords, I seek for a short accommodation, my lords. This is the complainant's appeal seeking for enhancement, my lords, MVC case.
Purple. Adjourned at the request of the appellant's counsel. ಏನದು ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು ಅಡ್ಮಿಟ್ ಮಾಡಿ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಬಂದಿದೆ ರೆಕಾರ್ಡ್ಸ್
Please, already records.
ಪೋಸ್ಟ್ ಮಾಡಬಹುದಿತ್ತಲ್ಲ
Please, madam.
awaiting TCRs ಅಂತ ಇದೆ. By two different judgments,
Connected matters, ma'am.
connected matter.
Same
records-
incident,
But accident is same.
please,
So in the connected matter, records are not yet received.
maybe called for.
Already called for. But
My lords, actually, what had happened is records already bandittu. Then we filed for,
43 and 43.1 ಎರಡು ಒಟ್ಟಿಗೆ ಬರ್ಕೊಳ್ಳಿ.
please,
Admit list for final hearing of after vacation.
lords, one humble submission. My lords, in second petition, my lords, Mr. Harish Bandari has filed wakalat for respondent number 1. Respondent number 1 in the first petition also same, my lords.
ಅಲ್ಲ ಅದ್ರೆಲ್ಲ ಅವ್ರು ಬಂದ್ರೆ ನೋಡೋಣ.
Please, my lords.
ಸನ್ನಿಧಿ ಎಂಟರ್ಪ್ರೈಸಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1.
Please, my lords.
ಅವ್ರು ಬಂದ್ರೆ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದೆಮ್ ನೋಡೋಣ.
Please,
Next
please,
time.
oblige.
ಎಷ್ಟು 4 weeks ಬಿಟ್ಟು ಹಾಕೊಳ್ಳಿ ಡೇಟ್ ಎಷ್ಟು
411.
411.
Oblige.
Cell number 44, Anup Sitaram Rao.
It's case of death minutes, appeal of the insurance company challenging liability, negligence finding and quantum. Two vehicles were involved, both drivers had been charge sheeted. Yet there is negligence finding only against one of the vehicles.
But respond on behalf of response, any witness was examined. RW 1 to 3 hours. So how much is awarded? 21 lakhs 26,600.
Please, move.
Admit call for TCR. Issue notice to the respondents. In the prior respondent in the insurance company. There was only one vehicle was insured.
The other vehicle was not made a party.
No, respondent. No other insurance company is responding. Issue notice to the respondents, interim stay of the execution of the interim award. Till further order, subject to appellant depositing 50% of the award amount with the accrued interest before the tribunal within 4 weeks from the date of this order. I have 2024 is disposed of accordingly. List after the receipt of TCS.
Much obliged.
Cell number 45, D. Vijay Kumar.
My lord, I am for the appellant, my lord. This appeal by the insurance company challenging the involvement of the vehicle in the accident and also liability to pay the compensation. My lord, the accident has taken place in the midnight. It's a case of hit and run. They have falsely
Subject to
implicated the tractor trailer.
Subject to deposit of 50%. of the
Much
award.
obliged, much obliged.
Same previous case.
46, B. Pradeep.
Challenging the liability negligence quantum, 22 lakhs 25,056 has been awarded. The trailer attached to the tractor is not insured with the insurance company. The rider of the motorcycle was also contributed, deceased.
You are on the point of negligence
Neg-
and
Liability as well as quantum
same previous 50% deposit.
for MSCT.
MAC.
Please.
Previous case.
For further hearing, cell number 47, Dr. M. Sunil Shastri.
Seeking a passover, my lords, Mr. Holla is.
230 ಅಂತ ಹೇಳಿಲ್ವಾ? Yesterday whether it said 230?
213 ಹೇಳಿದಿಲ್ಲ.
ಹೇಳಿಲ್ವಾ? ಸರಿ.
Passover.
ಪಾಸ್ ಅವ್ರು ಕೇಳ್ತಾ ಇದಾರಲ್ಲ.
Mr. Holla is about some small.
Yesterday he said he has finished his
15
submissions.
minutes, Mr. Holla has. He wanted to clarify only on the manner in which, my lords, the properties are devolved on the family members. Because from the 48-49 suit, my lords, there were various suits on, or not more than 10 to 15. He only wanted to show the pleadings of Venkatama.
You want two arguments?
My lords, Passover, my lords.
You have any other work in the afternoon?
230 ಇನ್ನೊಂದು part actually ಏನಿಲ್ಲ ಬರ್ರಿ.
You can make note of whatever he submits.
Very well, my lord.
I mean the lordship change over it.
Very well, whatever. Because he had requested for a short Passover. Otherwise, in the morning.
Is it possible now?
No, it may not be possible.
I don't know. They are not looking.
After completing that,
Please, not, I'll see, not if.
you talk to each other.
Very well, I'll ask.
Yes, make a
Grateful.
convenient time.
Grateful.
Pass it to them.
My apology.
For final disposal, cell number 48, S. Y. Kumar, KV Harish.
I think some advocate has left their phone here. I'll just hand it over to the court officer.
Yeah.
ಯಾರೋ ಫೋನ್ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ.
ಅಡ್ವೊಕೇಟ್ ಒಬ್ರು ಸಬ್ಮಿಟ್ ಮಾಡ್ತಿದ್ರಲ್ಲ ಅವಾಗ ಅವ್ರ
ಯಾರೋ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ ಇಲ್ಲಿ.
ಅದ್ಯಾವ್ದೋ ಒಂದು ಅಪಿಯರೆನ್ಸ್ ಹೇಳಿದ್ರಲ್ಲ.
Cinema.
ನೀವು ಒಂದು ಹುಷಾರಿಂದ ಇಟ್ಕೊಳ್ಳಿ ಮತ್ತೆ ನಡ್ಕೊಳ್ಳಿ.
Present appeal is for enhancement. Death case, my lords.
ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ sir.
Withdrawal of amount filed, cross objection.
48, my lord, serial.
Yes,
It's for enhancement, my lord. Death case.
yes.
The future prospectus is not taken into consideration.
These, all the three arise out of the same case, 48,
48 and 49.
ಅದು 49, okay. Yes. Case of death.
Yes, my lord. And survived by mother and brother.
Accident is
Date of accident is, my lords, 5/8/2017.
5/8/2017 at 5/10/15. Yes,
Yes, my lords. The tribunal has awarded 11 lakh. Towards the loss of estate, my lord, 10,20,000.
he was unmarried.
Yes, my lord, unmarried.
What was the age?
Age at the time.
27 years.
27 years.
27 years. Employment, any proof is there?
My lord, he was working in various offices, my lord,
Income proof?
role as income,
Proof of income?
my lord, exhibit P12, P14.
Employer is not examined.
Not examined.
Not examined, my lord.
How much is taken by the tribunal?
My lord, tribunal has awarded
Is 18,000 per month ತಗೊಂಡಿದ್ದಾರೆ. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
10,000 ತೊಗೊಂಡ ಲಾರ್ಡ್. ಮೇ ಸಬ್ಮಿಟ್ ಪ್ಲೀಸ್ ಮೇಡಮ್. 10,000 ತೊಗೊಂಡಿದ್ದಾರೆ ಅನ್ಮ್ಯಾರಿಡ್ 11,000 ಪ್ಲಸ್ 40%.
Judgment paragraph. Income.
27.
27 ಅಲ್ಲಿ it is crystal clear that he was earning 18,000 ಅಂತ one. Similarly,
18,000, 24,000 and 6,000, my lord. He was doing it in 3 jobs, my lords.
Certainly he was working as 6,000. Petitioner have not produced present evidence to prove income of the deceased. Petitioners have failed to examine the author of the document.
Yes, my lord.
Prove the contents. Moreover, salary slip and wage register have not been produced. These petitioners have failed to establish prove the income. So notional income ತಗೊಂಡಿದ್ದಾರಲ್ವಾ?
How's sir?
ನೋಡ್
10,000.
1,000 ಕಡಿಮೆ ತೊಗೊಂಡ್ರೆ 1,000 ಜಾಸ್ತಿ ತಗೋ.
2017 ಅಲ್ಲಿ ಎಷ್ಟಿತ್ತು?
11 ಇದೆ.
2017, 11,000.
11,000, 40% future to be added, not given by
11,000 ಅಲ್ಲಿ he was bachelor ಅಲ್ವಾ?
unmarried.
Bachelor,
Half
no.
of the income has to be deducted.
Not 40%.
Personal expenses, half deduct
That is been ಅಲ್ಲ ಫಸ್ಟ್ ಇದು ಆಡ್ ಮಾಡ್ಬೇಕಲ್ಲ ಫಸ್ಟ್.
ಇದನ್ನ ಮಾಡ್ಕೊಂಡೆ deduct ಮಾಡೋಣ, ಅದನ್ನ ಮಾಡಿ ಅದನ್ನ ಮಾಡ್ಬೋದು. Both
When it comes to
11,000 ಪ್ಲಸ್ 40% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 4,400 ಬರ್ತದೆ.
4,400.
ಟೋಟಲಿ 15,000 ಪ್ಲೀಸ್ ಮೇಡಮ್.
15,400.
15,400.
50%.
50% deduct ಮಾಡಕ್ ಬೇಕಾಗುತ್ತೆ.
7,700.
Into 12 into multiplier.
7,700. 700. Multiplier applicable is?
17 please.
ಇದು 12 into 17 ಆಗುತ್ತೆ.
ಹೌದು 12 into 17.
15,70,800.
15 lakh
70,800.
70.
70.
20,800.
Plus 40% plus 30,000 please.
40%.
40,000 plus 30,000.
Mother.
Mother
and brother, my lord.
brother is not entitled to that.
44,000 ಕೊಡಿ ಪಾಪ.
ಆಯ್ತು ಆಗಲಿ ಪ್ಲೀಸ್.
44,000 plus 33,000.
ಪ್ಲೀಸ್.
ಟೋಟಲ್ ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ?
16 lakh 47,800.
16 lakhs
47,800.
The same is against 11 lakh please.
ಅವಾರ್ಡ್ ಮಾಡಿರೋದು ಎಷ್ಟು? 11
11 lakh.
ಎಷ್ಟಾಗುತ್ತೆ enhancement?
5,47,800.
ಅಷ್ಟೇನಾ?
My lord, one more submission, my lord. In support of exhibit P12 to P14, my lord, I had also produced statement, my lord. At exhibit P18,
ಏನದು ಯಾವಾಗ ಕೊಡ್ತೀರಿ?
the salary rating of the salary, my lord.
ಮತ್ತೆ ಅದನ್ನ ಹೇಳೋದಿದ್ರೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡೋವರೆಗೂ ಯಾಕೆ ಸುಮ್ಮನೆ ಇದ್ರಿ?
They have not examined that author of those, all those documents.
The contention is I have not examined the author, my lord.
18.
Yes, my lord.
Mere production of the documents, not in a proof of incomplete.
What was his qualification?
Qualification, my lord,
P17, P18 ಏನು ಅದು ಯಾವುದೋ ಒಂದು ಶಾರ್ಟ್ ಪೀರಿಯಡ್ ಅದು 31st December 2015.
yes, my lord, he was doing part-time jobs, my lord.
16. ಅಲ್ಲ ಎವ್ರಿ ಮಂತ್ ಕ್ರೆಡಿಟ್ ಆಗಿದೆ ಏನಾದ್ರೂ ಇರ್ಬೇಕಲ್ಲ?
ಇಲ್ಲ, ಆ ಥರ ಏನು document ಇಲ್ಲ.
ಆ ಥರ ಏನಿಲ್ಲ, part-time job.
ನಾನು ನೋಡಿದ್ದೇನೆ, there is no such a document.
10,000, 1,09,9 rupees ಆಗಿಲ್ವಲ್ಲ ಕ್ರೆಡಿಟ್ ಡೆಪಾಸಿಟ್ಸ್? ಹೇಳಾಗೆ ಮಂತ್ಲಿ ಏನು ಡೆಪಾಸಿಟ್ ಆಗಿಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲ,
My lord, he was doing part-time jobs. Yes, my lord.
Assured.
Yes, my lord.
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್
Yes, my lord. Yes, my lord. And my lord, exhibit,
ಏನು ಬ್ಯಾಚುಲರ್ ಆಫ್ ಕಾಮರ್ಸ್.
yes, my lord. At exhibit P19, 20, 21, my lord, and 22. These are the applications made by the petitioner, my lord, during his lifetime for government jobs, my lord.
ಸಿಕ್ಕಿತ್ತ ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ 27 ಅಂತ ಹೇಳ್ತಾ ಇದೀರಲ್ಲ?
He was qualified, my lord. He was qualified for the application of these posts.
ಕ್ವಾಲಿಫೈಡ್ ಇದ್ರು he had the income ಅಂತ ತೋರಿಸ್ಬೇಕಲ್ಲ?
Well, future
know that
prospectus.
He was only some judgments engineering ಅದೆಲ್ಲ ಮಾಡಿ notional income ಬೇರೆ
I can understand. This honorable would taken this such higher income.
has taken.
In this case, no such a situation in this.
My lord, my only submission is regarding the,
Interdiction ಮಾಡಿದವರೇನೆ they are working for 10,000 or so. ಈ ಟೀಚಿಂಗ್ ಪ್ರೊಫೆಷನಲ್ ಇರೋರು. If it's not a permanent employment, what would it? Okay. You get more than that. This 40% amount is just is a question in this case. The appellants are second claimant will not get anything.
yes, my lord, he was made a party.
The mother, she is a widowed mother.
Yes, my lord, we don't.
Is a widowed mother and elder brother.
Elder brother.
Of deceased, what is his name? Deceased
Sergeant.
surgeon on 5/8/2017 at 10:15 PM. When surgeon was crossing road near Hanumantappa Circle, KM Road, Chikmagaluru ಇದು ಚಿಕ್ಕಮಗಳೂರು.
Yes, ma'am.
Maruti esteem car bearing registration number K03 P3392. And caused him grievous injuries. He was shifted to MG Hospital, Sikpagalur, where doctors declared him brought dead. At the relevant time, respondent number 1. Who is the registered owner?
ML, R2 is the registered owner, my lord.
What is R1 is the driver?
R1 is driver.
At the relevant time, respondent number 1 was the driver, 2 was the registered owner, and 3 was the insurer of car number K03 P3392. On the complaint, who had filed the complaint? One Arjun MD.
Arjun name.
On the complaint of one Arjun MD,
The brother of the.
Claim, he was not eyewitness, no? In crime number 87 of 2017. On investigation. Charge sheet. Charge sheet ಹಾಕಿಲ್ವಾ ಇಲ್ಲಿ? Charge sheet produce ಮಾಡಿಲ್ಲ.
ಹೌದು ಸರ್.
ಇಲ್ಲಿ ಹಾಕಿದಾರ 333 ಹಾಕಿದಾರಲ್ಲ.
ಹೌದು ಸರ್. Charge sheet, it's produced, exhibit P33.
FIR is exhibit P.
FIR number.
P3. ಅರ್ಜುನ್ NB ಅಂತ ಇದೆ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ.
ಹೌದು ಸರ್.
FIR ನಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ವಿಜಯ್ ಕುಮಾರ್ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಸರಿ ವಿಜಯ್ ಕುಮಾರ್ ಅಂತ ಫಿರ್ಯಾದಾರ ಹೆಸರು ವಿಜಯ್ ಕುಮಾರ್ ಅಂತ. ಏನೋ ತಗೊಂಡ್ರೆ against on investigation, the said police filed charge sheet as per exhibit 333 against the first respondent for the offences first respondent for the offence under section 279 and 304 AIPC and section 187 of IPA. The claimants. Sorry, appellants filed MVC number 152 of 2018 before the second additional senior civil judge and MACT Sikmagalur against the respondents claiming compensation of rupees 1 crore. 1 crore on the ground that deceased was ಎಷ್ಟು earn ಮಾಡ್ತಿದ್ರು ಅಂತ 16,000 was earning rupees 30,000 was earning more than rupees 30,000 per month. ಅಲ್ಲ ಒಟ್ಟು ಟೋಟಲ್ 37,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಏನೇನ್ ಮಾಡ್ತಿದ್ರು ಅಂತ ಆಸ್ by working as executive in ಆಮೇಲೆ ಹೇಳೋಣ ಬಿಡಿ ರೀಸನ್ಸ್ ಹೇಳಿದ್ರು. 30,000 per month. They were dependent on his income, and due to his death, they have lost their breadwinners. Respond number 2 has filed the written statement.
Yes, my lords.
Respond number 2 and 3. Respond number 1, though Appellate has not filed any written statement. 2 and 3 contested the petition, denying the actionable negligence on the part of respond number 1. Age, occupation, and income of and their liability to pay the compensation. Respond number 2. 2 and 3 did not dispute the coverage of the vehicle under the insurance policy issued by respond number 3. In support of the case of the appellant, so appellant one was examined as PW1. She was marked as exhibit R1. What? Please take it. Include awards. Relying on the police records, that is exhibit P22, P228 and exhibit P33, held that the incident occurred due to actionable negligence on the part of the driver of respondent number 1 in driving the vehicle, incident and the consequential death. The tribunal considered the income, notionally assessed the income of the deceased at rupees 10,000, 10,000 per month. Para 27, 10,000 per month. Future prospect ಸೇರ್ಸಿಲ್ಲ ಅಲ್ಲ? Deducted 50% out of the same for the personal income, personal expense of the deceased. Applied, ಎಷ್ಟು multiplier apply ಮಾಡಿದ್ದಾರೆ?
17.
Sorry. Consider the age of the deceased as 27 years. Applied 17 multiplier and awarded compensation of rupees 10,20,000 on the head of loss of dependency ಅಂತ ಆಗಬೇಕಾಗಿತ್ತು estate ಅಲ್ಲ, loss of dependency. The tribunal in all awarded compensation of rupees 11 lakhs on different heads as per the table, as follows, page number 26 alliದೆ ಹಾಕೊಂಡ್ಬಿಡಿ. The claimants are challenged the said award in the above appeal, questioning the adequacy of the compensation awarded to them. Under counsel for the appellant, relying on exhibit P12 P18 submits that P18 and ಮುಂದಿನ ತಗೊಂಡು P18 ಅದರಲ್ಲೇ ಬಂದಿದೆ. Submits that the deceased was a graduate, BCom graduate. He was earning rupees 30,000 per month. Therefore, notional income considered by the therefore tribunal was in error in considering in assessing the income notionally. He further submits that the tribunal ought to have added future prospects to the income of the deceased as per the judgment of the Supreme Court in Pranayaseti versus National Insurance Company. He submits that compensation awarded on the other heads is on the lower side. Shri Avish Penny, learned counsel for respondent number 3, respondent number 3 justifies the included award on the ground that the authors of exhibit P12 to 18 were not examined. Therefore, therefore, the income ought to have been income. Therefore, the assessment of the income notionally is justifiable. Next one. The response are not challenged the findings of the tribunal regarding the actionable negligence, age and age of the deceased. and dependency of appellant number 1. And so, therefore, the only question is whether the income assessed is right one, is correct one, right? So the appellants claimed that deceased was working with Indus Indian Marketing Financial Service as executive. Nothing else. Junior accountant assistant.
Outside.
Alla.
Supervisor in Vaishnavi Group of Hotel, as a supervisor in Vaishnavi Group of Hotel, and part-time cashier at
Supervisor in Vaishnavi Group of
Hotel. Exhibit P12, my lords.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿರೋದ್ರಲ್ಲಿ
Petition.
with one Yogesh Vaishnavi Honda showroom. Vaishnavi Honda showroom. ಏನೋ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ಅಲ್ಲೂ ಮಾಡ್ತಿದ್ರು ಅಂತ. He was earning salary
Cashier.
13,000 from Indus Marketing. ಆಮೇಲೆ ಏನಂತ ಹೇಳಿ and cashier. Iದೇನಿದು multiple role.
Yes, ma'am. He was working as part-time, my lord.
Restaurant.
He was working in hours basis.
ಪೂರ್ತಿ ಕೆಲಸ ಮಾಡಿದ್ರೆ ಅಷ್ಟು.
Listen, he was a student, my lord. By then,
That right, student ಬಿಕಾಮ್ ಮುಗಿದಿತ್ತು ಅಂತ ಹೇಳಿ.
ಅವಾಗ ಬಿಕಾಮ್ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ he was continuing till his death, my lord. All these employments.
Was in error in not considering exhibit P is 12 to 14, 12 to 18, 12 to 18. When the claimants, appellants contended that deceased was working with multiple organizations, the burden was on them to prove the said fact. More particularly, when respondent number 2 and 3 disputed the same. But to prove exhibit P12, to prove such employment or salary certificates and account extract, the appellants did not examine the authors of those documents. Therefore, there is no merit in the contention that the said income should have been taken. The tribunal was justified in assessing the income notionally. However, having regard to the qualification of the deceased, the cost of living and minimum wages during 2017, the tribunal ought to have considered his income at ₹11,000 per month. We'll continue in the afternoon. Okay. Yes.
Serial number 55. First appeal letter, I am responding in 55.1. I am the appellate. Now, they served a copy of an IA. I wanted to file it
I
today.
appeal for the appellant in 1139. We have filed an IA.
What is that IA?
For additional documents.
Nothing is placed before us. Is it filed?
Has to be put up.
IA 1 of 2022 was for production. Today I have filed one more application. Please, members. In which appeal?
In 1139 of 19 minutes.
But Honorable Counsel for the appellant submits that she has filed an interim application for production of documents. The registry shall verify and list after 2 weeks.
Please.
Yes, sir.
Madam, 65 ಜನ ಆಗಿಲ್ಲ ಮೇಡಮ್. 65 serial number.
ಇಲ್ಲ ಸರ್ ಇದೆ. 50 ಇದೆ.
65 ಮೇಡಮ್ 65.
65 ಇದೆ ಸರ್.
ಮೇಡಮ್ 53
ಸರ್ ಇನ್ನೆಲ್ಲ ಇದೆ.
53 ಇದೆಲ್ಲ
53 ಇದೆ.
ಎಸ್
ಮಧ್ಯಾಹ್ನ ನಿನ್ನೆದೊಂದಿದೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
ಮ್ಯಾಮ್ 58 ಎಡ್ಜನ್ ಆಗಿದೆಯಾ ಇದೆಯಾ ಮೇಡಮ್? ಮ್ಯಾಮ್ 54 ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಾ ಮ್ಯಾಮ್? 2:30
ಮೇಡಮ್ ಇದು ಹಾಫ್ ಡಿಕ್ಟೇಷನ್ ಇದೆ, ಫಸ್ಟ್ ಸ್ಟೋರಿ ಇದೆ, ಗೊತ್ತಿಲ್ಲ, ಹೇಳ್ಬಿಟ್ಟು ತಗೋಬೇಕು.
54 ಇದೆ ಅಲ್ವಾ? 54 ಇದೆ ಅಲ್ವಾ?
ಒಬ್ರಿಗೆ ಆನ್ಸರ್ ಮಾಡ್ಬೋದು. 54 ಇದೆ ಮೇಡಮ್. ಏನ್ ಸರ್?
58 ಎಡ್ಜನ್ ಆಗಿದೆಯಾ ಇದೆ ಮೇಡಮ್?
ನೋಡಿ ಮೆಮೋಸ್ ದಿನ ಒಂದು 80 ನಮ್ ಲಿಸ್ಟ್ ನೋಡಿ.
ಮೇಡಮ್ 58 ಇದೆಯಾ?
ಏನು
58 ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಇದೆಯಾ ಎಡ್ಜನ್ ಆಗಿದೆಯಾ ಅಂತ?
58 ಇದೆ ಮೇಡಮ್.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ವಾಯ್ಸ್ ಎಲ್ಲೋ ಮಾತಾಡ್ದಂಗೆ ಕೇಳಿಸುತ್ತೆ. या समिति केस था ठीक है ना पैसा पैसा ಎಲ್ಲ ತಗೊಂಡಿದ್ದೀನಿ ಯಾರಾ ಒಂದು ಮಾತ್ರ ತಗೊಂಡಿದ್ದೀನಿ ಇಲ್ಲ ಒಂದು ತಗೊಂಡಿಲ್ಲ ಇದು ಮಾತ್ರ 3868 ಮಾತ್ರ ತಗೊಂಡಿದ್ದೀನಿ 6868 ಇಲ್ಲಿದ್ಲಲ್ಲ ಸರಿತಾ ಆಗಬೇಕು ಅವ್ರಿಗೆ ಬೆಳಗ್ಗೆ ಫೋನ್ ಸ್ವಿಚ್ ಆಫ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡುತ್ತೆ ಒಂದು ವರ್ಷಕ್ಕೆ ತಾನೆ ಅಂದ್ರೆ ಒಂದೇ ಕೋಟ್ ಹಾಕಿ ಅವ್ರನ್ನ ಟ್ರೈನ್ ಅಪ್ ಮಾಡ್ಬೇಕು ಇನ್ನ ಒಂದೊಂದ್ ಕತೆ ಮಾಡ್ತಾರೆ ಆಮೇಲೆ ಕಲಿಯೋದು ಇಲ್ಲ ಹಿಂಗೆ ಆಗ್ಬಿಡತ್ತೆ ಅಷ್ಟೇ ಬರೀ ಓದೋ ಪುಟ್ಟ ಬಂದ ಪುಟ್ಟ ಕೆಲಸ ಆಗಿರುತ್ತೆ ಅಲ್ವಾ ಅಲ್ಲ ಈ ತರ ಕೇಟರಿಗೆ ಬಂದ್ಬಿಟ್ಟು ನಿಮ್ ಕೆಲಸ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗಲ್ಲ ಅದರಲ್ಲಿ ಕೂದಲು 48 ಅರ್ಧ ಕೆವಿಕಿಗಾಗಿದೆ ಇದನ್ನ ಹಿಂಗ್ ಮಾಡ್ಬೋದು ಆಮೇಲೆ
ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ಇಲ್ಲ ನೀವು ದಿಸ್ ಇಸ್ MFA MEC na
Yes, madam.
we'll take it up after some time because there is one compromise matter and our
Actually-
seniors
Past four matters, seal number 11. Harsha Kumar Gowda.
Appellants, my lord. My lord, the suit for declaration and injunction, my lord.
correct whether the parties came
Yes, my lord. My lord, the appellant number 3 is not here, my lord, because she has delivered the baby last month.
virtually
Appellant number 1 and 2 and respondent is present, my lord.
virtually appear ಆಗ್ಬೋದು ಅಥವಾ ಯಾರಿಗಾರ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಕೊಡ್ಬೋದಲ್ವಾ they can virtually appear or give power of attorney to somebody suit was dismissed.
Suit was dismissed, my lord.
What is the settlement now?
My lord, the appellants filed the suit for declaration and injunction, my lord. Suit came to be dismissed, against which the appeal has been filed. Now the settlement is that, my lord, they're saying that they're declaring that the appellants are the owners of the suit schedule property, my lord. And the respondent agreed that he will not interfere with the suit schedule property, and the respondent agrees that he will not interfere with the possession of the appellants with respect to the suit schedule property, my lord.
Property situates in which place?
In Bangalore, Srigandhada Gaval. Site number 3.
Suit was of the year 2018.
Yes, ma'am, 18. Dismissed on 2003, 31/1/2023.
See what are the issues? Within there is a judgment of the Supreme Court.
My
Yeah.
lord, that is with respect to the eviction, madam.
Compromise, it will be negated.
That is with respect to the eviction, my lord.
Correct. See, it appears you alleged that defendant creating some documents as rental agreement has filed eviction petition against them.
Yes, my lord.
And that was granted and the revision petition here was dismissed and even before the Supreme Court was whether these issues were raised in that case. This title.
Title issue has been raised, my lord,
There
but
is a Supreme Court judgment, is it there in the record?
trial court records.
There are different case owner. Purchased from Shanmugam, 2005. How they acquired the property?
My lord, the appellants
1203 of 2016, which has attained finality up to Supreme Court. Finality in SLP number
26585 of 16.
SLP number ಇಲ್ಲಿ dismissal ಅಲ್ಲಿ ಎಷ್ಟು SLP number
26585 of 2016.
26585 of 2016. Okay. The appellant's counsel shall produce a said judgment also list on it. ಮಾಡ್ತೀರಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
Next week.
30 ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಹಾಕಿಸ್ ಕಳ್ಸಿ.
Yes.
ಬೇರೆ ಯಾವ್ದು ಪಾಸ್ವರ್ಡ್ ಇದೆ ಅವರಿದ್ದಾರಾ?
For further hearing,
ಶ್ರೀನಿವಾಸನ್.
for further hearing, pastor matter. Cell number 47. Dr. M. Sunil Shastri, Gautam Bharatpach.
ಇದು
I'll just read it so that my lord there's continuity. 292 bottom. Arbitrators appointed by the debts. It is therefore directed that the partition with and the shares of the respective parties shall be please come to the page 354. Item 13, Raj. Rajamma, my lord, is the mother of the appellant. Rajamma ಅಂತಿದೆ ನೋಡಿ, his mother. Property is were divided at the rate of 1/10 share each, and those properties are the subject matter of this proceeding. If your lordships take the next page. My lord, para 6 ಅಲ್ಲಿ last, my lord, 7 lines from the bottom. Or 8 lines from the bottom, my lord. An interim report was also submitted. My lords, get that, my lord. An interim report was also submitted to the court by the arbitrator appointed by the court on 3652. Said report, it was stated the immovable properties in the 4 villages of the Bangalore city were divided into equal shares as detailed therein with the consent of parties, and some of the lands were given to the possession
Left out properties.
Correct, correct, correct. Now, my lord, very significantly, my lord, just to assuage your lordship's conscience,
Yesterday you were submitting that an amendment was sought to include this property.
ಅದನ್ನ ಈಗ ಹಾಕಿದ್ದಾರೆ. ಅದು that your lordship get that 361. 361.
In 23.
Huh?
In 23, November.
2023 ನಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಈಗ. Please come to my lord page 361.
Yes, sir.
This item 2 is Mr.
Item 2, my lord, is the disputed property. ತಾವು ಕೆಳಗಡೆ ಬಂದ್ರೆ
This application it's disposed of or still?
ಇಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆ. My lords get that page, my lord, 368, 21/11/2023 ನಲ್ಲಿ ಹಾಕ್ತಾರೆ. 368 bottom, my lords get the date. ರೇಣುಕಾ ಅನ್ನೋರು ಹಾಕ್ತಾರೆ. Not the appellant before your lordships. My lord, I must bring this to your lordship's notice. Appellant claims under, my lord, one Venkatama, his grandmother. Your lordships have seen that.
Yes.
ಇದನ್ನ ತೋರ್ಸೋಣ. Right.
Page 7 onward. The other things you'll cover.
My lord, page 7 ಗೆ ತಮ್ಮ ನನ್ನ ನೋಟ್ ತಮ್ಮ written submissions note ತಗೊಂಡ್ರೆ page 7 ಗೆ ಬನ್ನಿ.
Today file today.
ಹೌದು, what we gave today. ಅದೇ ಕರೆಕ್ಟ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀವಿ.
Behalf of respondent number 1.
ಇಲ್ಲ, ಸೆಪರೇಟ್ ಆಗಿ ಒಂದು ಕೊಟ್ಟಿವಿ ನೋಡಿ.
The written submission on behalf of.
Yes.
First respondent, decree holder. My lord, please look at it. ಏನು ಓದಬೇಕು ನಿಮಗೆ?
Yes.
The documents are aligned with reference ಕೊಟ್ಟಿದ್ದೀವಿ.
It's all right.
Okay.
Judgments alva.
My lord, what is, my lord, just to assuage your lordship's conscience, my lord, why I pointed this out is, ಸುಮ್ಮನೆ ಕೊಡೋದು ಬಿಟ್ಬಿಟ್ಟು ನೀವು ಇದು ಯಾವುದೋ ಹೇಳಕ್ ಹೋಗ್ತೀರಿ, ಸ್ವಲ್ಪ think. My lord, Venkatama, my lord, they claim under Venkatama. Venkatama, my lord, files 4 suits. This is not part of the trial court record. Just to assuage your lordship's conscience, I am, my lord, showing it to your lordships. Please take this. She says there is already a partition.
There is another compilation.
ಹೌದು, ಈಗ ತೋರಿಸ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಅದು strictly may not arise, my lord, in this, but then, my lord, because your lordship's conscience should be satisfied. That's only for that purpose, limited purpose and nothing more. Please look at, my lord, page 1. Venkatama files a suit, OS number 28 of 66.
They claim through Venkatama.
ಹೌದು, she claims, my lord, he claims through Venkatama. My lord, please come to.
That pedigree, where is that?
Yes, my lord. Please take his application itself.
Application.
My lords get that application.
In your earlier.
Yes, my lord.
182.
182 Banitav.
You had showed us some.
Yes, my lord. Please come to
Genealogy.
paragraph, my lord. 183 ಬಂದ್ರೆ ತಾವು. I Yatish 183, my lord. Affidavit ಅಲ್ಲೇ ಇದೆ ನೋಡಿ.
Yes, yes.
Son of S.M. Reddy and Rajalakshmi and grandson of Venkatama. I am the objector and all that, and he says that he claims by virtue of, my lord, Venkatama being the sister of, my lord, Appa Reddy and others. Please come to para 5 at page 184. 184 ಅಲ್ಲಿ last, my lord, 4 lines at paragraph 5. All the revenue records were standing in the name of Muniswamappa. They said Appa Swami is the brother of Venkatamma. Appa Swami, my lord, is my father. Appa Reddy is my father. And he says Venkatamma is the brother, my lord, sister of Appa Reddy. He claims under Venkatamma. Now, the suit filed by Venkatamma, my lord, if your lordships take, my lord, this compilation, first suit in, my lord, suit is 28 of 1966. Please come to the bottom, my lord. Appa Reddy is made the defendant. Please come to page, my lord, 4, paragraph 5. Plaintiff submits that during the pendency of the suit, matter was referred to the arbitrators for passing an award. Arbitrators passed an award, submitted the same to the court. Even before the submission of the award, one of the arbitrators died. But the award, however, having been submitted to the court, it was accepted by all the parties. Certain properties which were subject matter of the said suit were partitioned and properties there too were put in separate possession of their shares. Some of the properties, however, remained joint, and no partition of those properties have taken place so far. The said suit is yet pending. The said suit has now come to be transferred to the court of the City Civil Court and registered as OS 111 of 65. During the pendency of the suit, Muniswamappa died on so and so. Then, my lord, please look at the schedule. Yava property in Kelidar and Teli. Please come to page 21 onwards. This property, my lord, which is the subject matter of the appeal before my lords, is not a part of it.
So this was for declaration.
Yes, my lord, suit for declaration.
They have one.
That they are
They have 1/3 share.
1/3 share, together entitled 1/3 share in each, entitled 1/9 share.
Which went to the share of Muniswamappa because he had died.
Because this is, my lord, on the ground that she claims under Muniswamappa. Please come to my lord, para 6 ali, page 5 bannitav. Torstin, I'll tell you lordships how.
Page 5.
5. Para 6.
Yes.
Plaintiff submit that they who are the daughters of the deceased, plaintiff is my lord Venkatama, one of them, daughters of the deceased Muniswamappa are also his heirs, and they have also succeeded to his estate. As stated above, after the death of Muniswamappa, his wife Venkatama, that is mother of the plaintiff herein, also died. Plaintiff and defendants 1 to 5 are heirs of Muniswamappa as his children. Defendants 1 to 8 also succeeded to his estate as the widow. The plaintiff submit all the properties immobile, movable, owned and possessed by Muniswamappa. Each of the plaintiff is entitled to 1/9 share. So Muniswamappandu share alli ನಾವು ಕೇಳ್ತಾ ಇದ್ದೀವಿ ಅಂತ ಹೇಳಿ. Schedule ತಾವು ನೋಡಿದ್ರೆ, my lords get the schedule at page 21 onwards. 21 to 20, my lord, 6. The scheduled property, my lord, of the appeal, my lord, is not there. It is not there. Therefore, my lord, this is the first suit. Innon suit is there. Please come to my lord, page 27. Somebody else also filed a suit.
Defendant 3, sir.
Yes.
Page 20. So this is the first suit. My lords get that, my lord, 28 of 66.
Yes.
OS 28 of 66.
1980.
Then, my lord, page 27 bandre.
This suit was for?
My lord, suit. This Appaswamy, my lord, the present suit at page 27 is, my lord, for Ramaswamy. ಸ್ವಲ್ಪ ಇಲ್ಲಿ ಹೇಳೋದು ಕೇಳೋದು ಅವ್ರು ಕೇಳಿದಕ್ಕೆ ಉತ್ತರ ಕೊಡಬೇಕು ಆಮೇಲೆಲ್ಲ ರಾಮಸ್ವಾಮಿ ಡಿಸಿ. My lord, please come to my lord, page 47. Declare the plaintiffs are the legal heirs entitled to succeed to the estate of Ramaswamy. One of the brothers died. So my lord, they say that he is entitled, they are entitled to his share. My lord, his property only 1/8 share because he died, my lord, intestate. He was a bachelor, Allah. Yes. So my lord, they say that we have all now all the sister and brothers, my lord, get a right because parents died. And please come to my lord, page 27 again, cost title. Venkatama is, my lord, the third defendant. Venkatama is the third defendant. Now, please come to my lord, running page 30, paragraph 4. Para 4. They are referring to a suit, my lord, in para 3. I'll skip that. Para 4. During the pendency of the said suit, matter was referred to arbitrators for division properties among the parties to the suit and for passing an award. Award of the arbitrators was submitted to the court and it was accepted by the parties to the suit. Some of the properties belong to the joint family which were the subject matter of the said suit were partitioned and parties were put in separate possession thereof. Some of the properties, however, remain joint and are enjoined jointly by the parties and partition of those properties have not taken place. Suit is still pending. Plaintiff submits Ramaswamy, one of the sons of late Muniswamappa, brother of the plaintiffs, died on 1/11/1972. Said Ramaswamy died unmarried and intestate in the suit OS 15 of 1948-49 and as per the award of the arbitrators in the said suit and accepted by the parties thereto. Property is described in detail in the Schedule A of the plaint along with other properties which were not in existence as acquired or otherwise disposed of to the share of Ramaswamy and were allotted to him. After partition and allotment of the shares, Ramaswamy acquired some properties, land bearing number so and so at Banaswadi and BM Kaval. At the time of his death, Ramaswamy was the owner, right title and interest of the property detailed in the schedule. So, my lord, they asked for partition of, my lord, the scheduled properties, which is not, my lord, the subject matter of this appeal.
55.
But
Please
here,
come.
in this suit, it is said that OS 15 of 1948-49 was renumbered as OS 66 of
ಹೌದು 111 ಆಯ್ತು
111
ಆಯ್ತು ಅಲ್ಲ ಅದು
111 of 65.
65. What I am submitting is para 4 ಅಲ್ಲಿ
But
this
that suit is over or it is still pending?
all pending. my lord.
48-49 suit.
I will clarify.
Why I am mentioning this is there is, my lord, a reference to the partition, which, my lord, now please come to her written statement, Venkatamma's written statement. My lords get that at running page 55. Page 55.
No, what we were asking is that 1948-49 suit renumbered as 65.
ಹೌದು
Whether that is disposed or
ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿ ಫೈನಲ್ ಡಿಗ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬರ್ತಾ ಇದೆಯಲ್ಲ.
according to you, that was accepted. I mean, report part.
No, my lord, part of it was accepted. Part of it, my lord, was not accepted. So
Arbitral award partly accepted.
correct. What is not accepted, my lord, final decree proceedings, and some properties were left out. ಅದಕ್ಕೆ ಇವರು partitions
According to us, may not be correct, but let him finish. I'll respond.
No, it is said.
Page 55 ಬನ್ನಿ ತಾವು. Para 1, this is, my lord, filed by Venkatamma, written statement filed by Venkatamma. My lord, please come to page 60. Bottom ಅಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ. Third defendant, she signs it. Venkatamma, third defendant, has filed this written statement.
Page 60.
Page, my lord, 60, bottom.
Yes.
This is the written statement by Venkatamma. Please come back to, my lord, page 30, written statement para 4, which he accepts, my lord, as true in page 55 of her written statement. Please come to, my lord, page 30, para 4. Para 4, sixth line from the top. Some of the properties belong to the joint family, which was the subject matter of the suit, were partitioned and the parties were put in separate possession thereof.
I'm sorry. You said page 30.
30.
Cuts to page 55 and again you are going back to 30.
No, my lord. I'll tell you, lords, is why. Page 30 is, my lord, the suit, plaint. 27 in the ಶುರುವಾಗುತ್ತೆ.
30. Oh, this is met here.
ಹಾ.
This content.
ಅದಕ್ಕೆ written statement is page 55, Venkatamma's written statement.
Yes, here you showed this to say that about the acceptance of the
Correct,
arbitral award.
absolutely. That's all, my lord, my endeavor, because I must satisfy your lordship's conscience.
That is true.
Allegations made in paragraph 1 to 4 of the plaint are true. Paragraph 4 at page 30, your lordship sees, she says, my lord, the statement made by the plaintiffs therein is, there's already partition and some properties are remaining. That has to be partitioned. And, my lord, the schedule shows, my lord, this scheduled property, my lord, which is the subject matter of appeal, is not part of it. So, my lord, Venkatamma files a suit in which, my lord, these properties are not part of it. She accepts partition earlier. In the written statement, she accepts partition, earlier partition in terms of the arbitrator's report. Then, my lord, she files one more suit. Innobba brother Satru. Appaswamy or Satru. He was also not married. Please come to, my lord, page 61. Sorry. Page 61.
Yes, 82.
Venkatamma, my lord, is the plaintiff. Please come to, my lord, running page 63, paragraph 3 of the plaint.
Yes.
Adharalli, please come to, my lord, last 7 lines from the bottom. In the said suit, Appaswamy is declared to be entitled to 1/10 share in the joint family properties, and the properties more fully described in A schedule, given here under, were allotted to
him in that suit.
In the said suit, Muni Swamappa was also allotted for his share properties described in the B schedule. Ramaswamy, one of the sons of B.M. Munaswamy, was allotted properties described in C schedule. When things stood thus, para 4, Ramaswamy died on 1/11/1972 unmarried, leaving behind him plaintiff as one of the heirs. Appa Swami also died on 31/10/1980, leaving behind him as one of his heirs, the plaintiff. Therefore, my lord, they are asking for partition of, my lord, the share which fell to the same share of, my lord, Appa Swami in this suit. Earlier suit was Ramaswami's.
In that suit, this Appa Swami was party in 1980 suit.
80 suit, my lord. 1 minute. Page.
Because Appa Swami was alive then.
Howdu. Yes. Please come to, my lord, running page. I'll tell you, lord. 27. Appa Reddy.
Appa Swami. Plaintiff one.
Alla Appa Swami idar nodi.
ಇಲ್ಲಿ ಅಪ್ಪ ಸ್ವಾಮಿ ಅಂತ ಹೇಳಿ
Plaintiff 1. Howdu Appa Swami.
ರಾಮಸ್ವಾಮಿ
Ade Appa Swami. Please come to, my lord, page 27. He is the first plaintiff.
Then he passes away.
Page 27.
ಫಸ್ಟ್ ಪ್ಲೇಂಟಿಫ್
First plaintiff. ಅವ್ರ ಸತ್ರು. ಅವರ ಶೇರ್ ಅನ್ನ ಇವ್ರು ತಿರ್ಗಾ ಕೇಳ್ತಾ ಇದೆ.
ಆಲ್ಸೋ ಪಾರ್ಟಿ ಹಿಯರ್
My lord, she was a party. Bottom ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಶಿ ವಾಸ್ ಥರ್ಡ್ ಡಿಫೆಂಡೆಂಟ್
Yes. And she, my lord, admits that, my lord, Appa Swami says, yes, there was a partition.
Now these two suits are still pending or disposed of?
Ella pending. Disposed of, is it? Oh, chattel, my lord, dismiss ಆಯ್ತು.
to both.
Yes.
Correct. Yeah, please, my lord, ಬಂದೆ. ಒಂದ್ಸತಿ ಎಲ್ಲ ತೋರಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ my lord, I'll come to it.
If there was any change in circumstance, they could have amended the same plaint. Yes.
ಅವ್ರು ಮಾಡ್ಬೋದಾಗಿತ್ತು, ಏನೂ ಮಾಡ್ಲಿಲ್ಲ. But
I think they filed bond.
yes, they filed, my lord. No.
There of the parties bond
This, my lord-
filing suits before different
Correct.
courts.
All the time, my lord, why, my lord, I am pointing this out is to satisfy your lordship's conscience that, my lord, partition was accepted, partition was completed in respect of, my lord, these properties, and each one of them got 8 acres, my lord, in that Benniganhalli, my lord, Bayappanhalli, Benniganhalli property. Each one of them. Not only that, if my lords come to
157.
157,
First one, 157 was put.
157.
special land acquisition officer, Krishnamurthy, my lord, is one of the brothers. Our property, my lord, acquire ಆಯ್ತು. ಆ 8 acres. ಅವ್ರಿಗೆ there was, my lord, a compensation payable. He files, my lord, a claim. ಆವಾಗ ಇವರಿಗೆ they had no problem. Krishnamurthy, my lord, there was an award. Award, my lord, was challenged by the special land acquisition officer before this honorable court in 1971 in miscellaneous appeal number 5 of 1971.
Survey number 14 ತೋರ್ಸ್ಬಿಟ್ರೆ survey number 14 went to his share with the chart so that she knows.
My lord, ನಾವು 250, my lord, 280 of the original one. The problem ನೀವು ಮೇಲೆ ಕೆಳಗೆ ಮಾಡಿದ್ರೆ ಪಾಪ.
280?
Of the first, my lord, compilation objections ನಾವು ಹಾಕಿರೋದು.
ಇದು ಈ ಕೊಟ್ಟಿರೋದ ಇದು?
ಇಲ್ಲ madam, ಅದು the fact of.
Sorry, this is a problem. Always. All right, doesn't matter. Imagine that. 280 ತಾವು ಬಂದ್ರೆ
Krishnamurthy gets 14.
Krishnamurthyಗೆ in that report, my lord, of the arbitrators. Vande.
Krishnamurthy is survey number
Correct.
14 and 34.
Yes. My lord, 276, so that schedule to that arbitrator's report. Page 280, typed copy ಹಾಕಿದ್ದೀನಿ. ಅದರಲ್ಲಿ serial number 8 is BM Krishnamurthy. BM Krishnamurthy, my lord, got survey number 14 ಅಲ್ಲಿ 7 acres 21 guntas.
We are survey number 15 bar.
ನಮಗೆ 15/1.
Also 157.
ಇದರಲ್ಲಿ survey number 14 ಎಲ್ಲಿ?
ಇದೆ sir, ಇಲ್ಲ. And extending survey number.
My lord, would your lordships now come back to that today's compilation? Krishnamurthy arbitrate, my lord, award ಆಯ್ತು. ಅದರಲ್ಲಿ which land did he, my lord, claim compensation for? Page 157 ಗೆ ಬನ್ನಿ. That LAO challenges, my lord, the award passed by the district court.
8 acres 11 guntas in survey number 14.
An extent of second para ನೋಡಿ. Land measuring 8 acres, 11 guntas in survey number 14, Benniganalli in the outskirts of Bangalore was acquired. Notification to section 4 of the land division was published, in which it is stated the land was acquired for public purpose. So, my lord, Krishnamurthy, my lord, claims right over this and claims compensation. Please come to, my lord, page 161. 161, paragraph, my lord, second unnumbered paragraph therein. Before the land acquisition, before the land acquisition officer, claimant has claimed rupees 22 per square yard, 62,000, my lord, for brick kiln, 10,000, my lord, for stank bud. Who is the claimant? My lord, Krishnamurthy. This again, my lord, shows each person, my lord, was given that in terms of the arbitrator's note, award. Each person was given, my lord, different lands.
This point comes very clear from this, sir. Exactly what we're talking. Krishnamurthy got.
Now, my lord, we produce a Mysore Gazette itself. Next page, bani. 170 bani.
Mark, have a look at this.
Please come to, my lord, right side alli. My lord, different properties were acquired. Krishnamurthy, my lord, right side alli baratte nodi.
Yes, got it.
Krishnamurthy, 8 acres, 11 guntas in Benniganhalli. Appa Reddy, 6 acres, 5 gunta. This is, my lord, the subject matter of the appeal before your lordships. Muni Swamappan acquire aitu.
This is 65. Yes.
Houdu. Ultimately, my lord, each one, my lord, has claimed.
Through Muniswamappa.
Houdu. Some.
Now, they have taken this our compensation of this.
Each one, my lord. Krishnamurthy has taken his compensation. Appa Reddy, my lord, he died. Ultimately, my lord, for 47 years, his daughter, initially he was for fighting. Ultimately, his daughter Indrama, who's the respondent before your lordships, my lord, got. Now, my lord, they come. She's 88 now. Why, my lord, I am pointing out this is how, my lord, just to assuage your lordship's conscience. Partition is accepted by them. His mother accepts. Now, my lord, he comes and says, no, there is no partition. With the greatest respect, my lord.
So that we put it in things so that
my lord,
confusing.
ಈ note ಅಲ್ಲಿ I have put it, my lord, at page 7 onwards. The brief submissions ಹಾಕಿರೋದ್ರಲ್ಲಿ para 22, my lord. Paragraph 22.
Why this was all not within your knowledge earlier?
ಕಾಪೀಸು ಸಿಕ್ಕಿರ್ಲಿಲ್ಲ, ಅದರಲ್ಲಿ ಇವರು ಹಾಕುವಷ್ಟೊತ್ತಿಗೆ ಅಲ್ಲಿ ಗಲಾಟೆಗಳು ಶುರುವಾಯಿತು.
ಇನ್ನು ಏನಾದ್ರೂ ಹೊಸದು
ಇಲ್ಲ ಇನ್ನೇನಿಲ್ಲ. No, this was, my lord, strictly may not be needed because order 21 rule.
They are asking because it seems too many suits. Whether there are any other cases, whether retrieved.
I know. This was only to assuage your lordship's satisfy your lordship's conscience, my lord, because I must be fair to both. Venkatam, my lord, please come to para 22. PM Venkatamma, she, my lord, filed the following proceedings. Expressly admits the earlier partition. OS number 253 of 81, old number OS 28 of 66. Nanu ivag kottirodu. Then, my lord, suitably she says there was a partition. I showed to your lordships. 2 is, my lord, OS 8842 of 1980, old number. Idella puna renumber agide. This suit is pending, my lord, in FDP. First one. Tavu kelidre yen agide anta heli. Suit was decreed. FTP proceeding pending. My lord, in respect of properties other than this scheduled property. Or the appeal before your lordships.
The same 2004 FDP.
No.
Is it,
FTP in relation to this?
No. This is FTP in relation to the suit OS 28, Venkatamma suit.
You submitted that regarding this one FDP is pending.
Yes.
Now this.
No, my lord. Regarding, my lord, this no appeal is pending.
No, FDP.
So that you get it para 19 onwards. FDP.
We are submitting just now that now this suit is pending in FDP OS over 253 of 1980.
FDP, my lord, is in respect, my lord, idralle tavu bandre. Please look at, my lord, para 122I1. Suit was filed in the year 1996 by Venkatamma, Akkayamma and Saraswatamma, daughters of Muniyaswamappa. Suit scheduled properties concerned the properties which fell to the share of late Muniswamappa. It was decreed on 4/3. Final decree proceedings are pending. Then, my lord, second suit, OS 8842 of 1980, my lord, that is renumbered. Earlier was OS 69. Namma nan plain kotiradalli 69 antide. Suit filed on 6/3/1980 by Appaswamy, Akkayamma and Saraswatamma. This suit was in relation to properties which fell to the share of late Ramaswamy. Plaint, my lord, we have shown. BM Venkatamma was arraigned as defendant number 3. In the written statement, she admits the partition. Suit was decreed. Final decree proceedings are pending. in respect of, my lord, different shares of Ramaswamy and Appaswamy. Then, my lord, the other third suit. OS number 468 of 1982. Suit filed on 15/2/1982 by Venkatamma, Akkayamma and Saraswatamma. This suit concerned the properties that fell to the share of their brother Appaswamy. The specific government in the plaint are that there was an earlier partition. Their own claim, my lord, there was an earlier partition. Suit was dismissed on 36/1973. RFA file also dismissed. Renuka, my lord, files another suit. That, my lord, we have placed it in this earlier compilation itself. Ultimately, my lord.
24, what you showed, the 24 and 25, what you showed already.
Paragraph 20. 24 bandre tavu. Page 9. On a perusal of the judgment passed in MFA 5 of 1971, it is clear that one B.M. Krishnamurthy was fighting the land acquisition proceeding qua survey number 14, which fell to his share. Likewise, Gazette notification issued in under section 4(1) of the Land Acquisition Act shows that there were partition among the erstwhile joint family members fell to their respective shares. Thus, appellant Yatish and Renuka, my lord, seek to expand the scope of the concluded partition, which even the grandmother, my lord, accepted, my lord, the partition. That's all, my lord. This was, my lord. Today, my lord, what I filed was only to, my lord, as I pointed out, to satisfy your lord's conscience, that, my lord. And ultimately, my lord, as your lordship very rightly pointed out, we are only concerned with Order 21, Rule 58. What is the scope? I gave your lordship, my lord, 3 judgments, including the Supreme Court judgment, which holds if there is no attachment to correcto, alvo, adin bitre bere barodilla. But I thought, my lord, I must satisfy your lordship's conscience that, my lord, there is nothing, no hanky-panky. Everything, my lord, is just proper and fair. That's all, my lord. Grateful to your lord. And therefore, my lord, the appeal liability.
Now, a new set of documents have been furnished. Your lordship may kindly grant us some time, my lord, to take your lordship to each of these documents and explain. Your lordship may kindly have a look at. First, my lord, in fact, this I would humbly submit. This is precisely why, my lord, there should have been a full inquiry by the trial court, by the executing court, because these things need to be explained. But, my lord, notwithstanding that, I'll point out to your lordship. First, on the aspect, my lord, about the attachment, may I just, my lord, pass on to your lordship, my lord, the order sheet. Yesterday, my lord, I had shown to your lordships the impugned order. The stand that there has been no attachment at all is not correct. Your lordship, may first have a look at, before I take your lordship to the order sheet, kindly may not take the impugned order itself. I had shown this yesterday to your lordship, but just have a look at it again.
Because we have handled too many combinations.
Yes, but now, my lord, there are few more.
Appeal paper.
Yes, appeal, yes, ma'am. Appeal memo, ma'am.
Yes. Page number?
Page 32, my lord.
Yes.
On the jurisdictional issue, my lord, as to whether Order 2858 would lie or not. The argument that there has been no attachment at all, not is incorrect. Your lordship would have a look at, I have already pointed this out, my lord, the 6th line, my lord, from the top. This court, accordingly on 30/11/2021, this court passed an order to release 75% of the total amount attached and deposited. Now, my lord, your lordship would have a look at, my lord, the order sheets also, my lord, which has been filed along with this memo, my lord, which I have now, my lord, just passed on a copy.
No, by the time it is realized whether it still amounts to attachment.
Yes, my lord. For that, my lord, if I may just point out, your lordship, my lord, judgments of the court. Once an attachment is made, the property becomes custodial legis. Therefore, my lord, even if it comes into a deposit into court, it continues to remain in the custody of the court. That is the effect of an order of attachment.
Maybe in the custody of the
Yes.
court. But whether that amounts to attachment.
Yes, my lord. It is only, my lord, once the order of attachment is.
It is in the hands of third party, it will be, I mean, common parlance. When it is in the hands of third party, court attaches that to see that no changes are made or it's not.
Absolutely. May I just take your lordship, not to that itself, in the same memo, my lord, your lordship would find.
Memo of
In the same
citation.
memo of, my lord, which I have just filed.
Memo of citation.
My lord, there is one order sheet and citations also, my lord, which are given in that.
Ivattu kuttiroda.
Yes. What your lordship not kindly turn to
Page
page 34, my lord. My lord, a recent judgment of the Madras High Court, my lord, your lordship kindly turn to page 39, my lord. See page 39, 2024 judgment.
Yes.
Kindly have a look at paragraph 29 at the bottom, my lord, right at the bottom of page 39, my lord. When a property is attached during the course of a suit or in execution, the court freezes the right of the judgment debtor to alienate the property. The purpose of freezing is to keep the property within the control of the court. In case the property is not attached and if an order prohibiting a private sale is not passed, then judgment debtor can defeat the interest of the decree holder of plaintiff by alienating the property and reducing the decree granted by the court into a mere paper decree. It is for that purpose the courts are empowered to grant orders of attachment. Once an order of attachment is passed, the property comes within the power of the court. Right, and this has been explained by other judgments, my lord, which say that it is custodial legis. Now, my lord, whether the property is, no, my lord, if it is removed property, my lord, it cannot be brought to the court. Therefore, my lord, it will be pasted, my lord, at the property saying this property is under attachment. From that moment, my lord, it comes into the custody of the court. Even though, my lord, the property is immovable property, it is as if the court's in the court's possession.
De jure custody.
Yes, ma'am. De jure custody.
Not de
So also,
facto.
ma'am. Yes, ma'am. So also, ma'am, when it comes to movables or debts or accounts, when, my lord, those are attached, it is brought to the custody of the court. The court may then give it, my lord, in the control of either a receiver or we may ask the judgment debtor or a third party to keep it on behalf of the court. But till then, it continues to be under attachment. Therefore, even here, my lord, when the attachment is made of the accounts and the amount comes into the court, it is in the custody of the court. And therefore, only when, my lord, the court passes a release order, that, my lord, then, my lord, it may release either to the judgment debtor or to the decree holder or, my lord, depending on whether there is any objection to a third party, my lord, it may pass orders. Therefore, my lord, your lordship now sees the order sheets, my lord. The order sheets clearly show attachment, and that is how the amounts have come in. But the memo, my lord, would show the lordship, my lord, at page 2, the order of attachment, there's been a application made by the decree holder, and that is how, my lord, the order of attachment is passed. In fact, my lord, this is one instance, my lord, we could find. There have been instances, my lord, where courts have passed repeatedly orders of attachment to get the amounts. In fact, my lord, there are subsequent orders where the court says repeatedly orders of attachment have been passed to, my lord, get the amounts from the decree holder. We'll place, my lord, those orders also before your lordship. Therefore, there is no, and even the trial court, my lord, as your lordship sees, has said it is pursuant to the order of attachment, the amounts have come into court. Now, my lord, it is thereafter, my lord, after dismissing our application now that there is an order of release passed, which now, my lord, because of the matter pending before this honorable court, my lord, it is 75% even before we came to know has already been released. That is in so far, the preliminary objection regarding as to whether there was an attachment at all or not. Now that it is shown that there is an order of attachment, in our humble submission, my lord, order 20 in rule 58 application was perfectly maintainable. Now, my lord, I may just point out, clarify, my lord, on the questions, my lord, which have been pointed out with reference to documents. Kindly have a look at, my lord, my lord, memo with documents to explain, my lord, what has transpired right from 1948-49. Your lordship would find, my lord, the preliminary decree passed at page 8, your lordship would find, my lord.
Yes. Page number?
Page number 8, my lord. That is correct, my lord. It was passed on the basis of a compromise or a Rajinama, as it is called.
Appellate. It's the same thing which.
Yes, ma'am, same. But I have also filed some documents, but they have also filed some documents.
He can refer to one compilation.
Perhaps not.
It's easy for us.
But perhaps not. We'll also give a note. In that, we'll give a common compilation.
Everything in one compilation, give it to your lordship, my lord.
And so that we can make a reference, my lord. Now, my lord, I think their submissions also will make reference to their page numbers and.
If you make one compilation,
Either
side,
Yes.
you can refer to that page number.
Page number, absolutely, my lord. That's what, my lord,
we will do that.
Become minus.
Yes.
I know. It's easier, my lord. Otherwise, ಪಾಪ ಇಷ್ಟೊಂದಿರುವಾಗ it's our duty to assist your lordship.
Everybody act applies here.
ನಾವಿಬ್ರು ಕುತ್ಕೊಂಡು ಒಂದು ಮಾಡಿ ತಮಗೆ ಕೊಡ್ತೀವಿ.
Yes.
But then you'll have to revise the page numbers in your, our submissions will page number, Namdrullu will make a short note, my lord.
One submission, one list of documents is.
Yes.
My lord, just for the purpose of showing to your lordship, my lord, now your lordship takes page
How
5,
much
my lord.
text it will take?
I'll require, my lord, about half an hour to explain this new set of documents, my lord, at least, my
So
lord.
we conclude with that half an hour, see,
Please, my lord, I hope to not conclude today.
because we have to tell others. Yes. So others have no chance. We have one dictation matter which was partly dictated. Other bitre bere yargu chance illa. Because of.
Yes, my lord, this will take, my lord, some,
ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ನಿಮ್ಮ ಡೇಟ್ ಚೀಟಿ ಕೊಟ್ಟು ಹೋಗ್ಬಿಡಿ ಬಟ್ ನಾಟ್ ಎನಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ನಾಟ್ ಬಿಫೋರ್ ವೆಕೇಶನ್. ಎಸ್ ಎಸ್ ಒಂದು ಅವರೆಲ್ಲ ಕೊಡ್ತಾರೆ ಕೊಟ್ಟಿಸ್ಕೊಂಬಿಡಿ ಇಲ್ಲಾಂದ್ರೆ ಮತ್ತೆ ಅದಕ್ಕೆ ಒಂದು 15 ನಿಮಿಷ 20 ನಿಮಿಷ ಹೋಗುತ್ತೆ. ಎಸ್
please. Your lordship takes page 5, my lord. This is the Rajinama initially, my lord, which is filed in the 1948-49 suit.
ಎಸ್
Your lordship, is the plaintiff is B.M. Krishnamurthy. Defendant is Muniswama Panad, who is Venkatappa's father.
this Krishnamurthy himself is the father of this
No,
respondent number
Krishnamurthy's sister, brother. Not, I'm sorry.
respondent number 1 her father
No, madam, brother. Krishnamurthy.
brother Arundhati ಏನೋ ಹೇಳಿದ್ರಲ್ಲ what is her name here?
Not, she's not brother's daughter, Appareddy's daughter.
Brothers
Yes. Krishnamurthy, my lord, they were referring, my lord,
daughter of Apportionment.
no, my lord, Indrama is, yes, my lord, Indrama is daughter of Appareddy. Venkatamma, my lord, is daughter of Muniswamappa. That is the father.
Yes.
So, my lord, the suit was between my father and my brothers. Muniswamappa, my father, my lord, is defendant number 1. Your lordship would then see, my lord, para 1, my lord, at the compromise, the properties in the hands of the plaintiff and defendants, both movable and immovable, shall be liable for partition after ascertainment by the panchayatars of the actual incident of the same. The allotment is made in the following manner. Plaintiff shall get 110 share, defendant number 1 shall get 110 share, so and so.
This was read over by them.
Yes, my lord. Now, my lord, I'm just pointing this out as to what is the effect of this. Based on this, my lord, a preliminary decree is passed. That preliminary decree, your lordship would find it, my lord, at page 8.
See, like yesterday you have covered these
Yes.
matters.
Now, my lord, the legal point, my lord, I'm making is this.
Suit between you is that you say that there is no still final decree.
Absolutely not. For that purpose.
Preliminary decree was not completed. That's
Absolutely not. Not, may I just take your lordship, not,
accepted subsequently. Though arbitral award was rejected, subsequently with the consent of the parties for the part of the award was.
no, my lord, your lordship sees, my lord, that is their contention, and your lordship would find that document is placed now for the first time, my lord, about which, my lord, we have reservations.
Also you submit.
Yes, my lord. Your lordship would just have a look at, my lord, the position in law in just having this in mind, my lord. Because your lordship would just have a look at my memo, my lord, which I have filed, where your lordship had the order sheets. A few decisions, my lord, I have pointed out there. As to what happens, my lord, once a plenary decree is passed.
Page number.
Your lordship would have a look at, my lord, page number, my lord, 8. Could your lordship not kindly turn to para 7, my lord, at page 12. In a suit for partition or separation of a share, the prayer is not only for declaration of the plaintiff's share in the suit properties, but also division of his share by metes and bounds. This involves 3 issues. So and so, lot of the issues in a partition suit. Your lordship would then have a look at, my lord, paragraph 14, page, para 14, my lord, at page 14.
Yes.
The third division of the schedule to the said act prescribes the periods of limitation for applications. The schedule does not contain any article prescribing the limitation for an application for drawing up a final decree. Article 136 prescribes the limitation for execution of any decree.
Read this judgment earlier.
No, my lord, yesterday I had not, this, my lord, in fact, I have filed it only now, my lord.
Somebody has read this judgment, if not both of you.
Possibly, my lord. No, this has not been, my lord, referred to.
Yes.
Kindly turn to, my lord, para 15, my lord. May I just skip those lines? It is thus clear that every application which seeks to enforce a right or seeks a remedy or relief on the basis of any cause of action in a civil court, unless otherwise provided, will be subject to law of limitation. But where an application does not invoke the jurisdiction of the court to grant any fresh relief,
based on a new cause of action, but merely reminds or requests the court to do its duty by completing the remaining part of the pending suit, there is no question of limitation. Your Lordship would then have a look at para 16, where they have referred to the judgments. Kindly turn to para 17 at page 15.
Para?
17, my lord, next page, page 15.
I think on the point of limitation only.
Not limitation is incidental, because kindly
Cited before us.
possibly, my lord. But what is relevant not is para 17. Once a court passes a preliminary decree, it is the duty of the court to ensure that the matter is referred to the collector or a commissioner for division, unless the parties themselves agree as to the manner of division. This duty in the normal course has to be performed by the court itself as a continuation of the preliminary decree. Sometimes either on account of the pendency of an appeal or other circumstances, the court passes the decree under Rule 18.1 or a preliminary decree under Rule 18.2, and the matter goes into storage to be revived only when an application is made by any one of the parties, drawing its attention to the pending issue and the need for referring the matter either to the collector or the commissioner for actual division of the property, be that as it may. Then Manoj, kindly turn to para 18.3 at page 16. As the declaration of rights or shares is only the first stage in a suit for partition, a preliminary decree does not have the effect of disposing of the suit. The suit continues to be pending until partition, that is division by metes and bounds, takes place by passing a final decree. An application requesting the court to take necessary steps to draw up a final decree affecting a division in terms of preliminary decree is neither an application for execution nor an application for seeking a fresh relief. It is only a reminder to the court to do its duty to appoint a commissioner, get a report, and draw a final decree in the pending suit so that the suit is taken to its logical conclusion. Therefore, my humble submission is, and this principle of is reiterated in the subsequent judgment, I will not trouble your lordship with that. It is a well-settled proposition. Therefore, the question is, once there is a preliminary decree, which is drawn up by the court, as your lordship had seen in the 1949-50 suit, there is no final decree till date. And therefore, my lord, all the properties in respect of which right has been declared continue to be available to be partitioned. It is nobody's case that any final decree has been drawn up in respect of either survey number 15/1 of Bendiganahalli village by any method. And now, my lord, your lordship would have a look at reference was made. What happened, my lord, when your lordship would envisage the situation? As your lordship has seen, there are several properties. The daughters till date have not got a single property from this whole process. Daughters of Muniswamappa. Not a single property is given till date. Despite the fact that after Muniswamappa's death, even as per the law in 1956, as it stood, or after the death of my brothers who died issueless and unmarried, 2 of them, or even after the 2005 amendment, till today, daughters have not obtained anything. Now, insofar as the suits which were filed and a reference was made to several plain governments, at that point of time, since I was not a party to the original suit, your lordship recollects, the original suit I am not a party because daughters were not there at that point of time. But I come into the picture after the death of my father, Muniswamappa, by which time there is a preliminary decree passed. I am not aware of the fact that this arbitrator's report, which was referred to by your lordship, has been set aside by the court. And it is on that basis, my lord, I say, okay, something is allotted, please give me a share also. Lord, I was not interested in anything, so give me a share in what is allotted. Then, my lord, when I filed, your lordship now sees the judgment, my lord, which was passed. Kindly have in the same, my lord, list of documents which I had filed. My lord. Let me show the finding of the court to your lordship.
Today?
My lord, in my, no, not today's, my lord, yesterday's original list of documents. Your lordship had seen the preliminary decree just now, my lord, in that compilation. Because the judgment, what has been shown to your lordship, my lord, is my statements. Yes, I made statements.
File on 8/2/2024?
Yes, ma'am. 8/2/2024.
Page number?
Yes, ma'am. Your lordship would have a look at page 48.
Yes. OS 468 of
Yes, ma'am.
22.
This is one of the suits where I had filed because one of the brothers had died unmarried. Now, my lord, in this case, kindly say, my lord, what the court found. May I take your lordship, not kindly turn to page, my lord, 80, my lord.
Page 80.
Yes, in page 80, my lord, internal page 33 of the judgment, my lord, if your lordship, if there is some difference in the pagination. Yesterday, your lordship, my lord, pointed out some issues with the pagination, my lord. In page 80, internal page 33, my lord, para 28.
Page 80. Para
Yes,
20.
para 28. DW1 BK, my lord, this is part of the finding of the court. DW1 BK Ravichandra, the legal representative of deceased first defendant, deposed before the court that in OS number 111 of 1965, though the preliminary decree is passed and arbitrators were appointed for allotting the shares, the report of the arbitrators has been rejected by the court in the suit on 36/1952. Till now, my lord, I was not aware. This is how, my lord, when he brings it to my knowledge, notice. It is also his say that thereafter parties to the suit did not pursue for drawing up a final decree. In view of the death of sons of late Muniswamappa, the preliminary decree now requires to be modified. The shares declared in the preliminary decree has to be modified, taking into consideration of the death of sons of Muniswamappa. It is undisputed that the plaintiffs filed OS 28 of 1966 for partition in the properties allotted to Muniswamappa. Further, the plaintiffs have also filed a suit in OS 8844 of 1980 in respect of properties allotted to share of deceased B.M. Ramaswamy. Exhibits D2 to D4 are the certified copies of the plaints in respect of said suit. Same plaints which are pointed out to your lordship, no, my lord, were pointed out to the court.
What happened to this OS 28 of 66?
28 of 66, my lord, the judgment is not produced, my lord, here.
Numbered ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ?
Yes, my lord, it is renumbered. Only the plaint is produced, my lord, judgment is not here, my lord. We'll have to verify, my lord, the judgment.
It was dismissed.
FTP is pending. Suit decreed, FTP is pending.
Appeal is pending. In this.
Appeal
I just read further, my lord. Kindly have a look at, my lord, further. Let me just read further. Exhibits D2 to D4 are the certified copies of the plaints in respect to said suits. Exhibit D1, the order of the court in OS 111 of 1965 reveals that the report of the arbitrators for allotting the shares of the parties has been rejected. There is nothing on record to show that the preliminary decree passed in OS 111 of 1965 ended in final decree proceedings. In other words, it can be taken that the parties do not yet put in possession of their respective shares by metes and bounds. Therefore, it can be taken that the shares of the parties yet to be worked out, and that under any stretch of imagination, it cannot be taken that the suitable properties described in the plaint were actually put in possession of the respective parties. Further, it is also admitted that after the death of parties, their shares should be modified in the final decree proceedings. It has been held in the decision report in AR's 1976 in the Supreme Court that before passing the final decree, the shares of the parties had to be readjusted in the preliminary decree, and then in the final decree proceedings, shares to be allotted to the respective parties. Hence, here in the instant case, it is the admitted position that the three sisters filed suits for partition on the assertion that already their brothers had taken their definite shares in the joint family properties, even in the absence of drawing up a final decree proceedings. Further, the plaintiffs have not placed any material before the court to show that in subsequent suits of partition also final decree proceedings were drawn. Further, in the decision report in Supreme Court case in 1991, it has been held that unless partition of property is affected by metes and bounds and the allottees of the shares are put in possession of their respective properties, the partition is not completed. The preliminary decree which determines the shares does not bring about the final partition. Further, it is also observed in the said decision that in the pending final decree proceedings, the shares themselves are liable to be, shares themselves, perhaps typing mistake, shares themselves are liable to be varied on account of the intervening events, and the preliminary decree does not bring about any irreversible situation. Here in the instant case, parties to the suit, that is sons of Muniswamappa, are no more. Their shares required to be readjusted, and the shares were not actually handed over to the person of the respective sharers by drawing up a final decree proceedings. Therefore, the suit of the plaintiffs claiming a partition in the social properties, which were not at all divided by metes and bounds, is in my considered view not maintainable. It is not the case of the plaintiffs that parties to the suit, irrespective of final decree passed in OS 111 of 1965, taken possession of their shares by mutual agreement, arrangement, or oral partition. Viewed from any angle, I do not think there is any partition in respect of social properties as connected by the plaintiffs. PW 1 and 2 have also admitted that final decree proceedings in OS 111 of 1965 are still pending. Therefore, in view of the clear admission and as per the order in Exhibit D1, setting aside the arbitrator's report and directing the parties to get fresh steps to get the properties divided, the present suit being their claim as per the decision in OS 111 of 65 is not maintainable. It appears the claim of the plaintiff is misconceived, since the rights of the parties are yet to be worked out in the final decree proceedings. It is also well-established principles of law that for drawing up a final decree proceedings, there is no limitation prescribed. In view of the plaintiffs admitting that their final decree proceedings are still pending, and that in view of setting aside the arbitrator's report for allotment of shares, this court has no option but to hold that suit of the plaintiff is misconceived. Further, it cannot be taken that actually A, B, and C scheduled properties are allotted to the shares of Muniswamappa, Appaswamy, and Ramaswamy respectively. Further, the evidence of plaintiffs in regard to self-acquisition of late Appaswamy is also very vague. So on so on. Then they go on to other issues about other aspects. Then one kindly turn to next page, page 85 on top, third line, page 85, not very next page, page internal page 38, third line from the top. Viewed from any angle, the documentary evidence placed on record undoubtedly established that final decree proceedings are not yet drawn in pursuance of preliminary decree passed in OS 111 of 1965. Hence, for the foregoing reasons, I answer issue so and so in the affirmative. And the Lordship would note that in this suit, Indrama is very much a party. Your Lordship would find apparate. Your Lordship kindly turn to not page 53, 53, the cost title. But not in the Lordship would find not the apparate since dead by LRs Lakshmama Indrama, daughter. Not parties may say anything because not sometimes they may not be aware, especially daughters of Muniswamappa are out of the proceedings till death of Muniswamappa because they are not even parties. Therefore, they assume that yes, some situation has happened. They go on the basis of arbitrator's report without knowing that the arbitrator's report has been set aside. In the written statement here, the defendants take a contention that arbitrator's report is already set aside. Your suit is not maintainable. And now, parties, as I said, not parties may say anything. The court's finding is arbitrator's report has been set aside. Therefore, there is no final decree passed. Parties have not been put in possession. Go back, urge your contentions in this. Now, your Lordship would see this finding was upheld by this honorable court. Your Lordship would find the judgment at page 102. I had shown this to your Lordship, but in the context of reading these findings, I had not read them yesterday, but I thought it is required now to read those findings in the light of the present documents which are filed. Kindly turn to page 111 to 110 where the judgment starts. The court notes in terms of facts in para 1 and 2 about the preliminary decree, final decree being pending. Then kindly turn to para 4 where the High Court refers to the trial court's finding. Trial court has found that the suit for partition seeking share in the estate of their father Muniswamappa and their brother Ramaswamy is not maintainable and they have to work out their remedies in the FDP proceedings. And now, your Lordship would kindly turn to the last line in this page, page 112. The finding of the trial court that the suit filed by the plaintiff seeking share in the estate of their father and estate of their deceased brother, they have to work out their remedy in the FDP proceedings is sound and proper. Not whatever reasoning which the trial court gave, which is including that the arbitrator's report has been set aside. There is no evidence of parties being put in possession, and therefore you have to agitate your rights because there is no final decree drawn up. Therefore, suit is pending, referring to Supreme Court. That has been affirmed by this honorable court. Then, insofar as Appaswamy is concerned, there was some claim of a will, etc. It will not be relevant for the purpose of this case. It is in the light of this judgment, your Lordship would now see, which is binding again, because your Lordship would note again in this, Indrama is a party here in the appeal also. Your Lordship would find that at page 106, right on top, Indrama, daughter of Appa Reddy. Now, in the light of the judgment of the court, forget not, let alone the contents of the parties and the position in law. Position in law is once the suit is decreed by a preliminary decree, it continues to be pending till a final decree is drawn up. And now, in the meanwhile, 2005 amendment takes place, and as interpreted by the Supreme Court now, daughters are to be treated as co-partners, irrespective of whether they were alive, father was alive, dead, all that. Supreme Court has eliminated all those and said, I will get the status of co-partner unless a final decree is drawn and they are done. Then, this is an additional event to say, therefore, I would be entitled to an equal share with the brothers in all the properties. I am not now constrained only to claim under my father Muniswamappa because I will be entitled to an equal status as co-partner. None of the daughters have got even one share. And your Lordship yesterday asked a question. Why is it that the FDP proceedings are also pending for a long time? What has happened, if I may point out to the Lordship, and I may show the order, but though it's not strictly relevant. apart from the fact not which I said yesterday that lot of people have died and LRs are being brought, which happens, there have been alienations of the property by the brothers' children, including by Interim of various properties. So what happens is we have to file then application to implead those because there could be further constructions or disposals, and then the very virtual final decree can be frustrated. Till now we have not got a single property of our father also, let alone as an independent right. Therefore, we have had to file applications for injunction, applications for impleading of the purchasers. In fact, the very Interim who is party to the FDP and who has instituted FDP proceedings, she has herself sold properties after instituting FDP proceedings. We may just point out, may not be very relevant for the purpose of disposal of this. But since your lordship asked about conduct of parties, and my learned friend also, senior counsel also made a reference about conduct. And this in this FDP, as the lordship has already seen, Indrama herself is petitioner number 2. That is daughter of Appa. And your lordship would then find at internal page 9 of the order. Rather at internal page 9, para 3.1. If your lordship will return to internal page 10. There is a reference of alienations. And insofar as lordship sees, para 4.4, internal page 14. Where there is a reference, your lordship sees, respondent number 4 is having a share in the share of his grandfather. On the death of his grandfather, share of his grandfather was devolved upon legislation. As such, petition number 2, your lordship, that is Indrama, petition number 2, 4 and 14, and respondent so and so have no absolute right to get the item number 1 of the suit properties converted in their exclusive name. After getting conversion order, petitioners 2, 4 and 14 have sold the converted properties, namely so and so, in favor of respondent number so and so, illegally and fraudulently so and so. And they have not tried to form sites. A status quo order is passed by the court on 22/11/2018, and your lordship sees 4.5. May I just read 4 lines. A status quo order was passed by this court on 22/11/2018 against the petitioners and respondent in respect to said properties. In spite of the same, petitioners 2, 4 and 14 and 2, 3, 5, 15 and 17 have sold the scheduled properties to respondent number 18 to 20C in violation of the said order. The respondent 18 to 20C have formed layout and trying to alienate sites to third parties. The decreed properties are not yet divided by meets and bounds. This is the observation, and then the court grants an order of temporary injunction restraining. This is how the difficulty is in these final decree proceedings. And now, therefore, coming back to the questions as the lordship framed yesterday. This is a matter which requires adjudication, especially in the light of there being undisputedly a preliminary decree entitling me to the shares. Admittedly, there has been attachment. Order 21, Rule 58, a claim to the property attached, I can raise. I have a claim to the property attached because I have a share in it by virtue of a preliminary decree. And by virtue of law, now by virtue of the Hindu Succession Amendment Act. And the only question is then, if I am somebody bound by the decree which is being executed, it's a different matter. It is nobody's case, nor as a trial court saying that the award passed in those LIC proceedings are binding on me. I am not a party to those proceedings. And the lordship would see, those proceedings are all lis pendens. Now, by virtue of the Supreme Court judgment, once the preliminary decree is passed, the suit is deemed to be pending. It is not disposed of. And therefore, during pendency of suit, if somebody goes because of an RTC finding, they're showing their names, they go and claim an award. And it was pointed out to your lordship, in relation to the documents, an acquisition of 1964 that did not go through. That was for NGEF. That is not the acquisition proceedings in respect of which the compensation is now paid. Acquisition proceedings in respect of compensation being paid is by BMRCL in 2008. Therefore, these proceedings of NGEF are completely irrelevant. That is not the subject matter at all. And in fact, my lord, they sought to challenge the acquisition proceeding by BMRCL on the ground that there was already an acquisition by NGEF, and BMRCL my lord sought to contend that because of the earlier acquisition, they don't have right over it. The court my lord rejected that and said that there was no award passed. There have been observations in relation to those proceedings. So that NGEF proceedings are completely irrelevant for the purpose of the present proceeding, and therefore that it's not an acquisition of 1965, but the award pertains to my lord, an acquisition by BMRCL now. But in the light of this, my lord, your lordship would just have a look at one other judgment which emphasizes this aspect, my lord, of an inquiry once it is maintainable in the same memo, my lord, which I have filed today, where, my lord, I showed to your lordship the order sheets. Just now handed over to your lordship. Page 5. My lord.
Yes, Andhra Pradesh High Court.
Yes. Page 5. Your lordship would just turn to my lord, page 6, para 3, at the bottom, left hand side. Order 21 Rule 58 CPC gives a statutory and substantial right to a person to object to the attachment of any property in execution of a decree when an application in exercise thereof has been filed. Clauses A and B of proviso to sub rule 1 of Rule 58 clothes a court with power to dismiss such an application in limine, or A, that the property attached has already been sold out, or B, it was intended to protract the proceedings, and in that process, the application was designedly made or unnecessarily has been filed. Now, that is not the case. The trial court has not said that I have tried to protract any proceedings, or nor is it in an eliminate dismissal. Then kindly see next. If the court exercises power, the applicant is relegated to vindicate his rights by way of regular suit as contemplated under sub rule 5 of Rule 58 order thereof. If the court did not exercise the power at inception in terms of the above provision, then sub rule 2 thereof enjoins the court that all questions, including questions relating to right, title, or interest in the property attached, shall be determined by that court dealing with the claim or objection and not by a separate suit. Thereby, the legislature intended it as a mandatory duty cast on the court to hold an inquiry. The inquiry thereby posits that an opportunity to be given to the parties to adduce all necessary evidence in support of the claim or to resist such a claim by the opposite party, and thereafter to give finality to the objection by that court, subject to right of appeal provided under sub rule 4 thereof, treating the order thereunder as a decree. The order thus becomes conclusive. Thereby, the legislature has manifested that holding an inquiry in adjudicating the right, title, interest of the objector in dealing with the claim of objection is mandatory, and the order passed thereon shall be conclusive. Rose from this perspective, when we glance through the order passed, it must but be held that the lower court passed the order under sub rule 2 of Rule 58 without holding an inquiry, without giving an opportunity to the party. It straightaway passed the order on minutes. Therefore, the order is per se contrary to the mandatory language and scheme of the court. Thereby, it is not only in excess of jurisdiction, but also is vitiated by material irregularity in excess of jurisdiction. My submission, my lord, your lordship sees. If the trial court had said simply, my lord, it is not maintainable, it is one thing. The trial court, not the executing court now, has even gone on to observe on merits, saying I have not produced any documents to show how I am entitled to it, and therefore not virtually rejects my claim. I can understand, my lord, if the trial court were to say, or the executing court were to say, my lord, that no, I do not find your application maintainable. I leave open all contentions to be urged in whatever proceedings are in FDP or whatever it is. But the trial court goes on to now reject on merits without giving an opportunity. And not all these contentions which have been placed before your lordship, if we had been given an opportunity, we would have placed before the executing court, and your lordship would have had a benefit of whatever reasoning the executing court would have had to say about this. Unfortunately, without that, perhaps the executing court did not envisage the duty which is placed under Order 21 Rule 58, simply based on the application and objections, and without even, according to us, without hearing, as the lordship sees the order sheet also. It is not very clear. On that day, we filed an adjournment application. The court nowhere said it has heard us on our applications. And the lordship recollects why that confusion arose, because certain other parties had also filed applications. And therefore, those applications were also not disposed of on the same day.
Your case that application was disposed without hearing?
Yes, my lord. That's my case. In fact, I have said so in my appeal also.
Argued also.
I have not known. That is our case. I have put it in the appeal also.
Means counterpart.
Naturally, my lord. I have naturally. I am not in the appeal memo also, my lord. We have said so to that effect. And not had we been given the opportunity, we would have placed all these documents, not now what your lordship not is, we are,
They have produced order sheet where it shows that
not, I think they have produced the order. Yes,
not-
your lordship sees
where
page,
it's-
in their objections, but not they have. Huh? First one, not their first,
the order is 11th December 2023.
please, ma'am.
Order sheet is at page number.
But I think,
Page.
not your lordship turn to page, second volume not of that tab, of their 217, 217.
uh, 2 and 7.
Yes, ma'am.
45 of February. This order is passed in 2023.
Please. 2023, madam.
Application was-
Page 226. madam.
Application was filed on objections to IA3. What is this IA number?
But IA3 and then a separate application not for impleading and one more application for stay pending some Supreme Court judgments, not Supreme Court proceedings. But initially, IA3 the lordship saw was page 218. The lordship would get that IA3 15.
Orders on IA3, 11 and 12.
Yes, ma'am.
IA3 was under order 21 rule 58.
Yes, ma'am. And not the other one was under order 1 rule 10 for impleading.
So here
Yes.
JDA number to find.
Not the lordship sees. Thereafter, some other applications also came to be filed by other parties also. There is an IA4 also, which is thereafter filed.
Where do we find that party is absent, therefore he is not heard?
No, not. In fact, your lordship sees, I had filed an adjournment application on that is recorded at page 226. The lordship turns to.
This order is passed on 11th December.
Yes.
Which date?
But page 226, 4/12/2023.
Adjournment application.
Advocate for objector filed adjournment application under, yes, not page 227. At the bottom of 226, the lordship it starts 227 to defer the matter for 1 week. Or the DHR third party applicant for orders. But here, I may point out, there are other third party applicants. That is not what your lordship would find, that one daughter of Krishnamurthi's daughters, they had also filed. That is, your lordship would find their applications also in the order sheet. 8/8/23, there is one order 20 and rule 858 filed by them also at page 223.
Yes, there are enough 3 applications.
No, they have also filed. Your lordship sees page 223, 8/8/2023. Advocate or applicant filed IA7 under order 21 rule 58.
ಇಲ್ಲಿ advocate for objector ಅಂತ ಹೇಳಿದ್ರು. So there are 2 objectors.
Yes. That's where the confusion is. There seems to have arisen.
Whether you are other objector.
There are other objectors also. But all that I would say is, I had filed an adjournment application. If I were given an opportunity, I would have placed all these. The preliminary decree, the orders passed, the judgments passed. We had no opportunity, as the lordship sees, order 21 rule 58 has got. I can understand if this trial court, executing court also had simply said, your application is not maintainable, you urge your contingency elsewhere. It does not say that. It also goes to rule on merits. It says you have not produced documents, you have not shown how you have got a right, which in my humble submission is very unfair considering that the preliminary decree is there and the daughters are entitled now under the Hindu Succession Act by virtue of your lordship just take the judgments which have been cited by the other side. I'll just point out from that a few aspects. It was filed yesterday,
Respondent number 1.
yes, ma'am. Judgment shall by respondent number 1.
13/9.
Yes, ma'am. But I also not kindly turn to the first judgment,
23/9. Even for this, you have not signed.
But we will also check not whether we have also signed one. Sometimes we're not, when we are handing over, we straight away hand over without.
No. Yes,
Not, first judgment of the Orissa High Court was pointed out to your lordship. Kindly have a look at Malad, page 2. Before that, Malad, yeah, kindly have a look at Malad, page 2. Para 5. Malad.
they only
The
have.
precondition of application under Order 22 Rule 58 are that there must have been an attachment of any property for execution of the decree, and the claim should have been preferred or the objection should have been made to the attachment on the ground that such property is not liable to such attachment. The question therefore that to be decided by the court in application of this rule is whether the property is liable to be attached or not. No question which has been finally decided between the parties can be reopened by a third party by filing an application under Order 21 Rule 58 CPC, much less by a person who has not been a party to the original litigation. In the present case, whether the marriage between the decree holder and judgment debtor is valid or not, and whether the decree holder is entitled to maintenance from the judgment debtor, and to what extent has already been decided by the competent court, this judgment is a judgment in rem and consequently is binding on the whole world. As per the provision of Section 14 of the Evidence Act, the judgment could be challenged only by a party to the litigation, that too in a competent appeal. It is in this context, my lord, where it was a judgment in rem that the court said this application is not maintainable. Here, my lord, there is no judgment in rem insofar as we are concerned. What is?
Right to say that.
Yes.
First sentence.
Yes, ma'am. That, my lord, I have shown to your lordship.
There must have been.
An attachment. That, my lord, is that's why, my lord, I satisfied your lordship that there has been an attachment.
Section or should have been referred to the attachment.
Yes, ma'am. My lord, the whole argument is which I have made in the petition is.
How that the property is not liable.
Yes,
to
my lord.
such
Now, my lord, insofar as the whole amount, she does not have a share. In view of the preliminary decree, she cannot claim to be the owner. And therefore, not the property which is subject matter of preliminary decree, which has now been acquired and replaced by compensation. The whole of the compensation she cannot be entitled to. She is only a sharer in that. And therefore, the whole of the amount cannot be attached or and paid to her. That is the objection raised. Your lordship sees not insofar as the next judgment is concerned, not it was regarding a garniship proceedings, not which your lordship also noticed. Order 21 Rule 46 is not attracted here. Your lordship turn to the third judgment, not to point out. Kindly have a look at page 35. This does not deal at all with Order 21 Rule 58. And here, my lord, what was the prayer made was, they wanted in the execution proceedings an award to be made in their favor. Certain co-sharers, my lord, as the lordship would find from the facts. Kindly turn to page 36, para 2. When Rumal, page 36, para 2. When Rumal Singh filed execution application to enforce his award made under subsection 26, the petitioners filed an execution application to the execution court to award the same compensation on a par with Rumal Singh. That is not my case. That is not a case of Order 21 Rule 58 at all. It is in this context, not that para 4, it is observed at the bottom. The question is whether the execution court which passed the award in the case of Rumal Singh had jurisdiction to implement non-parties to the award and make the award in their favor. It is settled out the execution court cannot go behind and award the awarded decree. It has jurisdiction to execute the decree and made under section 26. This has no application to Order 21 Rule 58 at all. Not the principle, if I may humbly submit, that the executing court cannot go behind a decree has no applicability to either Order 21 Rule 58 or Order 21 Rule 97, 98, which are specific provisions made only where third parties who are not bound by the decree are before the court, saying that no, we have got an objection. Then, my lord, the court has to see whether they are bound by the decree. If they.
That was contended in the context that,
yes,
according to them, this arbitral award, subsequently part of that was accepted. So, executing court cannot go beyond that.
No, my lord, that
That
of
was
course
the
I did not.
submission.
My lord, if that is the case, my lord, there is a finding of the.
That was the submission. In
But if that is the case, my lord, then in the light of the judgment of the trial court affirmed by the High Court where they are parties, and now that operates as res judicata, I would humbly submit that judgment operates as res judicata because that judgment has held that in the light of the arbitrator's award having been set aside by the court, and at no point of time, your lordship would recollect in their FDP also, not when they, your lordship, so when I just take a few minutes, not insofar as after finishing these judgments, I'll point out to that. Your lordship would just have a look at not the next judgment, my lord, which was relied on at page 38, my lord.
Yes.
This was again a case, my lord, not involving Order 21 Rule 58. What happened, my lord, is when a Section 18 reference was done for enhancing the compensation, your lordship would find that, my lord, at para 3 at page 39. And that was enhanced. Kindly turn to para 4. The person who was a party to those proceedings at para 4, after about 2 years, the respondent filed execution petition number so and so and prayed for issue of a direction to the appellants to pay the amount of compensation. The appellants filed objections. That is not, that is the very judgment debtor filed objections under section 47. Please, that the determination made by the reference court was erroneous. The very party to the judgment was trying to raise a contention in execution, saying that the order was erroneous. Naturally, it is in this context that the court held that in para 9 that you cannot go behind the decree and you are bound by those proceedings. Therefore, you cannot raise this objection. So, not every judgment will have to see in the context of the facts how the question arose and in what context. These are not judgments not under Order 21 Rule 58, excepting the first judgment, which was pointed out to your lordship, which again reiterates there should be an attachment which is satisfied. None of the other judgments will not deal with Order 21 Rule 58. And therefore, not these judgments would not have any applicability to the facts of this case, is my humble submission. In the light of Order 21 Rule 58 and the judgments which clearly say that there has to be a full-fledged inquiry, then to say that you cannot go behind the decree is really putting the cart before the horse, if I may humbly submit. The whole purpose is somebody who is not bound by the decree. Here, I am referring to the decree as the decree in the LAC proceedings. The LAC proceedings, I have not been a party. Neither before the collector or before the High Court, wherein it went for enhancement. I am not a party to any of those proceedings. Therefore, there is no, I would humbly submit, there is no judgment against me which operates as rejudicator to hold that I don't have a share or that I am not entitled to any share in this property. Contrary to that, there are two judgments which operate as rejudicator. One is the preliminary decree where this property is covered, which operates as rejudicator. Second, the judgment of the trial court confirmed by the High Court, to which Indrama is also party, where a clear finding is given, there has been no partition by metes and bounds, no putting of possession, and that arbitrator's order has been set aside by the court. And therefore, you cannot really make a separate claim for the share of Muniswamappa or his brothers, which is affirmed by the High Court also. I have read out to your lordship. In the light of those judgments, which are adjudicator in between them also, because they are also parties. Then not my humble submission, then my objection had to be entertained by the executing court is my submission. Then insofar as I would only make one last submission. Just yes, I wanted to show one statement to your lordship. Kindly have my the list of documents which I had furnished of 8/2/24, February 24. In the FDP filed by Indrama, which she filed 8/2/24, the memo with the lordships have not may turn to. I'm sorry,
Because of your too many.
Yes, we have to take the blame. We have multiplied. We will definitely sit together and have a common. 8/2/24. Page 37.
What is your 9/2 ಅಂತ ಇದೆ ನಮ್ಮದ್ರ ಮೇಲೆ. ಅದಕ್ಕೆ ನಾನು ನೋಡಿ ಆ ಕಡೆ ಕೊಟ್ಟೆ.
But I think it was signed on 8/2 and maybe
Text is changed, it is
9/2.
changed.
I'm sorry.
And index is totally in blank.
Blank. Which should at least have a description of what is the document that is.
After engaging the advocates like you, they submit these kinds of compilations.
But these should have come to us after it's already been filed. So, not kindly turn to page 37.
ಅಲ್ಲಿ ಮೇಲೆ ಪ್ರೆಸೆಂಟೇಷನ್ ಶೀಟ್ ಅಲ್ಲಿ 9/2 ಅಂತ ಹಾಕಿ ನೋಡಿ ನಾವು ಕೊಟ್ಟು
Yes.
9/2 ಅಂತ ಹೇಳಿ.
Yes.
This is all domestic violence to us. Yes. Yes.
Page 37.
37.
Your Lordship's wordings will not because smile at that.
ಏನ್ ಹೇಳೋದಿಲ್ಲ. Because first thing, there will be long drawn litigations and too many compilations. So ultimately, maybe the case may have been decided on some points raised, but for that we have to churn this much. Adu properly organized way nalli irodu.
But we'll have it not all put in one compilation, not with a continuation page number so that it's convenient to your Lordship.
Yes,
Page 37, not your Lordship had already seen this.
page 37.
And page 37, right?
FD, yes.
But the second petitioner your Lordship would note is Indrama on top note. And your Lordship was read not certain amendments of this petition where they say we are filing for partition of balance properties. Kindly turn to page 44.
Yes.
Para 6 minute. May I just read that fully so that your Lordship would have a.
He once read, he can.
Yes, I'll just read it a bit fully so that your Lordship would see the. Petitioners further submit the suit in OS 15 of 48-49 filed by B.M. Krishnamurthy, father of response 2 to 5. Against his father, Dhunaswamappa and others were decreed in the year 1950 under a compromise petition filed by all the parties to the suit. And under said compromise decree, each party to the suit was allotted 1/10 share in the suit properties. Subsequently, the arbiters were appointed to divide the scheduled properties. As per compromise decree, and an interim report was also submitted to the court by the arbitrators appointed by the court on 30/6/1952. And in said report was stated that the immune properties of the 4 villages of Bangalore were divided into equal shares as detailed therein, with the consent of the parties, and some of the lands were given to the possession of the respective parties, and rest of the properties were left undivided due to non-cooperation by some of the parties to the suit, and hence those leftover properties which are undivided by the arbitrators is the subject matter of this final decree proceedings. The Honorable First Traditional District Court, which passed the preliminary decree in the said suit, also made an observation dated 2012-1952, that 2 is missing. Right? This is the order which recalled the arbitrator's report, that either plaintiff or one of the defendant may take steps to get the properties divided as per the terms of the Rajinama. This Rajinama is the compromise arrived at in 1950, not the arbitrator's report. Some of the legalized deceased parties have also filed separate suits. Now, my lord, this is referring to us. May I read what they have said? Some of the legalized deceased parties have also filed separate suits before civil court, seeking partition and separate portion of the properties fallen to the share of deceased persons. In OS number 15 of 48 of 99, Srimati late Venkatama and her 2 sisters had filed 2 separate suits, OS 253 of 81, 468 of 82, for the properties of late Dhunaswamappa and B.M. Appaswamy. The same parties had also filed another suit along with Appaswamy for the properties of late B.M. Ramaswamy, who died unmarried and interstate. All these 3 suits are disposed of, and agreed parties have preferred RFS, which are pending before the High Court. However, in OS 468 of 82, the Honorable Civil Court, while dismissing the suit, observed the suit properties are not allotted to the share of late Appaswamy in OS 1548, and hence this case is filed for dividing the suit properties. Not therefore they accept the finding in OS 468 of 82, and they have made that statement in the FDP. Therefore, not only is the judgment res judicata, Indrama has acted upon it. Conveniently, they have said, they have left out certain properties.
According to them, in this Rajinama, this survey number, so and so was not, the subject matter, present subject matter was not allotted to her share.
Yes, my lord. That is different. But now, my lord, by virtue of the Muniswamappa or even by amendment of Hindu Succession Act, I am entitled to a share in all the Rajinama properties because there is no final decree. And that judgment is also placed on record. That is a well settled position, not that the Hindu Succession Amendment Act would apply in respect of daughters as long as final decree is not passed. That judgment is in the compilation itself. Now, therefore, and kindly note, here nowhere have they said that this order of 2012-1952 is recalled by some so-called order which is now produced before your lordship of 1954, saying no, parties have agreed. And that order also says some contesting defendants have agreed. Your lordship sees the order, which is not the authenticity of this is really in dispute, because neither in the earlier suits or in this FDP or even in before the executing court, now this order surfaced. Now for the first time, this is surfacing before this honorable court, and the lordship would see the that order which is produced. Correct.
It was being submitted that this contention was not taken before the execution.
ಅದಲ್ಲ ಈಗ ನಾವು ಪ್ಲೇನ್ ತೋರಿಸಿದ್ರಲ್ಲ ಶೆಡ್ಯೂಲ್ ನೋಡಿ.
Correct.
None of these, my lord, that Beniganahalli, my lord, property.
They have not made this part. That's why, my lord, there is an amendment made. Right? Just because a party chooses to file.
Is it that now the whole heartburn is that daughters are not given anything?
We have not received anything, and we are entitled to a share.
Only one daughter is saying or other daughters are?
No, other, I'm not sure about the other daughters, my lord. At least I am not, I mean, your lordship sees I've been agitating. Either give me under my father, that also I did not get. Give me under my brother who died, I did not get. Now, my lord, by virtue of Hindu Section Amendment Act, I'm entitled to. That also, my lord, and now your lordship sees what has happened. And why, my lord, I'm agitated by this. And why I objected to this and why it's important, my lord, to preserve this amount. The reason is, your lordship has now seen properties in the meanwhile have been frittered, they have been alienated, third parties have taken up, sites are formed. But father died. I have given the list of dates, my lord, I'll just give that. In my list of dates, my lord, I have given.
The two brothers, when?
Yes, my lord, I'll give those dates. 26 to 1965, Muniswamappa passed away. We had given a list of dates yesterday, my lord, it's there in that list of dates.
No, brothers, other two brothers. when-
Yes, my lord, I have given those dates also.
This is all the. Not sitting with it, but
List of dates on. Yes, my lord, your lordship will just make a note. My lord. Just-
sweet is there.
In the list of dates, my lord, the second page, my lord, your lordship would find. At the bottom, my lord, serial number 5, 6 and 7.
Father died in
1965. One brother died on 1972. Another brother died in 1980.
So,
And my lord, now independently, my lord, I have a
1965 up to filing of this suit, he had not made any claim.
I made this, yes, my lord, this suit I made a claim.
1980.
66, there is one other suit. 66, there is one some suit.
You had.
Yes,
claim.
Property,
66,
property, yellow
which is what they have
mark,
produced that plain, my lord, in that suit. Correct.
All right, just.
I have not 100% I agree. At that time, I assumed, my lord, that the arbitrator's report was final and I sought for those properties. But that's when my claim has been rejected by the trial court saying you are wrong. And that's the defense taken up by the others. Brothers, my lord, took a defense. No, you cannot claim on that basis because arbitrator's report has been set aside. Not there, and the judgment has been accepted by everybody. They have also accepted it. That's why, my lord, I showed to your lordship the statement in the FDP, where they rely on that finding of the trial court. And said, since trial court has said that the arbitrator's report has been set aside, I am filing the FDP.
Yes.
Therefore, my lord, my submission is, my lord, in the light of this, there ought to have been an investigation, my lord, under Article 21, Rule 58, and the trial court, my lord, has erred on the basis that the application is not entertainable, that it cannot go behind the decree my lord, being the LAC decree, not the revenue decree.
Yes.
Kindly for a moment, my lord, just have a look at the three aspects, my lord, which is there in the impugned order. I have pointed this out to your lordship, my lord, but just to conclude. At para 11, my lord, at page 35 of the appeal paper book, my lord, if your lordship takes the appeal paper.
Yes.
Right at the bottom, my lord, at para 11. On a carefully aforesaid provision makes it clear that when any claim is preferred by the party that can be determined by the court, Admittedly, objector has no grounds as against the award of this court sought to be enforced, and also against mode of execution of decree against second GED in particular. Hence, it is contended the objector cannot invoke the provisions of Article 21, Rule 58. As per the said provision, the same can be invoked for adjudication of claims to or objection to attachment of property. The provision makes it clear that the said provision is meant for any claim or objection on the ground of non-liability of the property for attachment. In the event of any rival claim over attached property, the executing court will have to adjudicate the same. After saying so, my lord, also it contradicts itself. It is connected to very reading of the application affidavit.
It was pointed out.
Yes, my lord, yes.
Trial court sometimes, executing court, sometimes it, extracts it's
My lord, your lordship would then-
argument, and sometimes it gives as if.
No, this because your lordship sees not from para 10, he says, my lord, I have carefully gone through. So that's why, my lord, I thought this is part of the finding, but my lord, kindly see para 10, it starts on the rival submission of both parties. I have carefully gone through the application, so and so. So therefore, my lord, I would assume that para 11 is part of his.
I think para 16 in the shuru
Very well, my lord. Next to correct, I pointed out yesterday. One kade shuru ಮಾಡ್ತಾರೆ ಆಮೇಲೆ ತಿರುಗಿ ಕಂಟಿನ್ಯೂ ಹೇಳ್ತಾರೆ 16 This court carefully perused the records and documents. On going through the record, it is seen that there are nothing on record now to examine the alleged share of the objector in the acquired property, and the objector has not placed any documents to her rights. Not my humble submission is this was most unfair. It was never posted for inquiry, and not had it said so, your lordship would just see the the damage caused by this. Had it simply said, your application is not maintainable, whatever content is yours elsewhere, that is one aspect. It then goes on hold on merits also, my lord, virtually it is precluding me now. It is shutting me out by saying that's all. Over this, you don't have any claim. Then, my lord, that could not have been done without an inquiry.
Yes.
Then para 17, not again they say that executing court cannot go beyond the decree. That is not applicable under Order 21 Rule 58. Because 21 Rule 58 is by a person who says he is not bound by the decree. Had he been bound by the decree, he could not have objected at all. Then, para 18, the court says, I cannot convert it into a partition suit. Complete misreading. In fact, I am pointing out there is already a partition decree, which is binding on the parties. It has become final. Preliminary decree.
Yes.
Then, at the bottom of page 41, in the present case, there is no attachment of any property of JDR, and the object is not claiming right in the attached property, which is again improper, incorrect, in the light of the order sheets which I have shown to your lordships at the bottom. And I am making a claim. What is my claim? I am saying I have a share because of the fact there is a preliminary decree, and therefore this whole amount cannot go to this person. This person admittedly has only a 1/10 share. At the most, we are not assuming that Indrama is claiming through her father, Apportionment. He had a 1/10 share only. It could not, and your lordship would note the difficulty caused. 75%, about 100 crores have already been taken by her. This is the only thing, because I was not even aware. This is the only thing left. And what has happened is, all other properties, as your lordship has seen, alienated, sold, layout formed. Now, if this is also out, then I will have a very paper decree.
No mediation was tried in this. We were asking whether the heartburn is only the daughters were not given share.
Really, final decree.
Final decree. Now there are several cases, several FDPs, whether any settlement,
It appears it's not.
Whatever is alienated, whatever is left out, whether the parties.
Other properties mediation go get
Other?
original FTP.
Our instructions, we were told we will be given, but nothing is given. But of course, not.
Other suits in other suits.
Other properties ಬಗ್ಗೆ ಅಂದ್ರೆ ಈ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಬಗ್ಗೆ mediation ಗೆ ಹೋಗಿತ್ತು ಅಂತ ಅಂದ್ರೆ ಏನಾಯ್ತು ಅಂತ ಹೇಳಿ.
How long they keep?
How long and what happened?
How long they keep on fighting like this?
Mediation failed.
Even assuming that an inquiry is if we accept that an inquiry is needed or application is maintainable, then again all these things, now we have
Correct.
argued it, even these records were not part of the record before the trial. Now, if at all that is the situation, if dismissed, gone again some appeal and special petition that may be there. Otherwise, if at all we hold that application is maintainable, we cannot decide all these things. We have to send it
That's
back
all
to
right.
trial.
That of course.
Executing court. Why can't they come to it?
But always, party should be ready to when it comes from the court, certainly.
Probably ಇಲ್ಲಿ ಹಿಂದೆ ಕುತ್ಕೊಂಡಿರೋ ಸಾಲ
But I'm sure from their side, they would be ready because they have been deprived. My instructions are, they're ready to sit, whatever is given, they're willing to take.
to take what?
Okay to sit for any mediation and
To take. What happens in this? Persons who are already having benefit, they will not want to.
What we can guess is, when the land is there, nobody will be interested. When it becomes, cultivable land, when it becomes, it gets some NA potentiality or NA, then, and now it is acquired and crores of rupees, many crores. ಮಾಡ್ತಾರೆ ಅವ್ರು ಯಾರು ಎಷ್ಟನೇ ಜನರೇಷನ್ ಅವ್ರು ಇದ್ದಾರೆ? None of them are ready for this. 4th generation. ಯಾರಿದ್ದಾರೆ ಇಲ್ಲಿ ಇಲ್ವಾ ಪಾರ್ಟೀಸು ಯಾರು? He is from your side. From this side?
This side.
ಏನು ಇದನ್ನ ಏನು ಕೂಡಿ ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳೋದಿಲ್ವಾ? ಸೆಟಲ್ ಮಾಡೋದಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ವಾ?
FDPs are pending, madam, for other properties.
FDPs are pending out of the court. Can you not settle this matter?
Mediation was tried by Mr. Srinivas Gowda once in High Court, but the opposite side they didn't agree, madam.
Now they are saying, ಏನ್ ಕೊಟ್ಟು ತಗೊಳ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ನೀವು. ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಒಬ್ಬರದಾಗೋದಿಲ್ಲ. If once all daughters probably, if one is satisfied, the other may come because there are other proceedings also.
And somewhat, what has happened also is, ನಾವಲ್ಲ ಬೇರೆ ಬ್ರದರ್ಸ್ ಇದೆಲ್ಲ ಇದೆ, ಅವ್ರು ತಗೊಂಡಿದ್ದೆಲ್ಲ ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ, ನಂದಕ್ಕೆ ಮಾತ್ರ ಇಲ್ಲಿ ಬರ್ತಾ ಇದ್ದಾರೆ, ಅದು ತೋರಿಸ್ತೀನಿ ನಾನು. ಇನ್ಫ್ಯಾಕ್ಟ್ ದೇ ವೆಂಟ್ ಟು ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಸೇಮ್ ಪರ್ಸನ್ ವೆಂಟ್ ಟು ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. What would be the effect and all that, you'll have to see. And then there could be a final decree, preliminary decree ನಲ್ಲಿ final ಆಗಿರುತ್ತೆ. ಇದರಲ್ಲಿ ಫೈನಲ್ ಆಗಿದೆ preliminary decree ನಲ್ಲಿ as far as one portion is concerned.
Ask for that purpose. See, father was also allotted a share even in earlier decree.
Correct.
That
ಮುನಿಸ್ವಾಮಪ್ಪ was allotted a share. ಅದರೊಳಗೆ ಬರುತ್ತೆ ಅವರಿಗೆ.
there should have been some division.
Correct.
Munishwamappa's share.
ಹೌದು.
At least they were getting
That they are entitled to.
Then not
That they are entitled to. We don't think anybody has. We have not even disputed.
Correct. ಅದ್ರಲ್ಲಾದ್ರೂ ಕೊಟ್ಟು
ಕೊಡ್ಬೇಕು. ಅದ್ರಲ್ಲಿ ಕೊಡೋದು in fact my some instructions are that ಅದರಲ್ಲಿ
Everything has been alienated, right? Not.
No.
in the form of cash again.
Why, absolutely not. We are ready to take whatever they give here. There's no difficulty.
Property ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ in the
Yeah,
form of
absolutely.
cash something could have been.
Let FTP 124 implementation, we'll also participate.
FDP ನಲ್ಲೇನೋ
Also not could be a bit magnanimous. After all, they've had out of 100 crores has already gone to them. It's not. We also.
whole FDP can be
Embroiled in litigation.
whole FDP ನೇ mediation ಕಳ್ಸೋದು ಬೆಟರ್ ಅಂತ ಕಾಣುತ್ತೆ.
ಅಲ್ಲ,
Not
ಅವ್ರು
only
that
portions.
Just because ಮತ್ತೆ ಈ ಕೇಸ್ ಹಿಯರ್ ಮಾಡಿ ಸುಮ್ನೆ ಕಳ್ಸೋದಲ್ಲ. If they are sincere in that.
ಅದು ಕೇಳೋಣ, ನಾನು ಬೇಕಾದ್ರೆ ಇನ್ನೊಂದ್ಸಲ ಕೇಳ್ತೀನಿ.
These executions.
ಸ್ವಲ್ಪ ಕೇಳ್ರಿ.
Ask both the parties.
What the judge says.
We are not. Once it comes from your lordship, not as we feel, not. We should tell the parties also, not they should be ready. There's no.
Senior counsel said if FDP itself is closed, then all the litigations are.
Everything gets sorted out. FDP ನೇ
That's not, of course, we are, there are other parties also not there.
That's why FDP there are other parties.
But these properties are not part of FTP.
That's why in the beginning only we asked whether relationship is disputed.
Relationship is not in this.
But so.
In fact, FDP ನಲ್ಲಿ ಇರೋ ಪ್ರಾಪರ್ಟಿ ನಾವು ಯಾವ್ದು ಕ್ಲೇಮ್ ಮಾಡ್ಲಿಲ್ಲ. ಅದ್ರಲ್ಲಿ
whatever-
ಬೇಕಾದಷ್ಟು ಪ್ರಾಪರ್ಟೀಸ್ ಇದೆ.
ಅದ್ರಲ್ಲಿ ನೀವು ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ ಅದರಲ್ಲಿ. ನೀವು ಆರ್ಡರ್ ತೋರಿಸಿಲ್ಲ, ಕೋರ್ಟ್ ಆರ್ಡರ್.
This is not, the.
Ultimately, even if if their contention is accepted, still in that Muniswamappa share, they were entitled to.
Then the other two brothers' shares also are there.
Other two brothers, they were unmarried. Even their shares also.
Appaswamy
One, it appears.
Muniswamappa share, they were entitled. ಅದಾದ್ರೂ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ ಇದೆ.
ಕೊಡಬೇಕು.
How are they placed? Probably this much of property.
ಅದರೊಳಗೇನೆ 8 ಎಕರೆ ಅದ್ರಲ್ಲಿ ಬಂದಿದೆ ಮುನಿಸ್ವಾಮಿಗೆ.
How are they placed financially now?
They are well off.
Obviously,
In
they will
fact,
be well off.
they
after
went to
having
the
received
Supreme-
100 crores, so therefore.
They are all well off. What difficulty?
ಕೊಟ್ಟು ಇಲ್ಲಿ FTP ಅಲ್ಲಿ how many generations they keep.
I know.
treating like this?
But I'm told, this Muniswamappa and the Tappa Mestri family, the whole of that, if your lordship sees in the preliminary decree, they don't even give survey numbers. They have just described villages. So it seems to be like totally there's a.
It seems they are also not this daughters also they did not fight. He is the son of one daughter.
Daughter is.
Other generation in the.
Daughters file the cases. That's why it's not the.
Papa, those ladies are ಏನ್ ಗೊತ್ತಾ?
No, that was.
ಯಾರು
not,
ಹಾಕಿಸ್ತಾರೆ?
ಅಲ್ಲಲ್ಲ, 1982 ನಲ್ಲಿ, not now. 40 years back. Like, you would not.
ಮ್ಯಾರಿಡ್ ಡಾಟರ್ಸ್ ಯಾರೋ ಅಲ್ಲಿಂದ ಆ ಕಡೆಯಿಂದ ನಮಗ್ ಕೊಡ್ಲೇ ಇಲ್ಲ, ನಿಮ್ ತಂದೆ ನಿನಗೆ ಕೊಡ್ಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿ
ಇರ್ಬೋದು. That we cannot.
But justifiably they were entitled to share in
Correct.
Muniswamappa.
Correct.
Please.
We have never denied it. Not only that, we have also not denied in their entitlement in the shares of Appaswamy and Ramaswamy.
But
That
those-
also we have not
those
denied.
dismissed ಅಲ್ವಾ?
No.
ಇಲ್ಲ. FTPs are pending ಅಲ್ಲ.
FTPs are pending.
3 FTPs are pending. ಹೌದು.
They were.
So far as
One
Ramaswamy, one person claims, of course, she claims to be the wife and child, and that was.
ಬೇರೆ ಇದೆ ಇದ್ರಲ್ಲಿ.
There is though we took a condition, he was unmarried, all of us. Somebody came and said that they are the wife and child, and there is a wife, he had a wife and child, which not to say.
What happened ultimately in those?
That is in RFA, so far as they.
So one RFA, only about two brothers.
That is, no, one brother.
That is Appaswamy, Ramaswamy. ಅಲ್ಲ, ನೋಡಿ.
Ramaswamy,
ಮಾಡ್ತಿಲ್ಲ
Ramaswamy.
ಅಂತಂದ್ರೆ we can.
Not.
He must also be a fourth generation person.
ಅಷ್ಟೇ ಹಿಂಗೆ ಇದು
See,
entire
we have
FD.
paid, you are paid for our services. But these people will be there in the court in eternity. Yes, ಏನಾದ್ರು try ಮಾಡ್ತಾರಂತ? ಇಬ್ರುನು, you should be,
FTP
both should be flexible.
But we, from our side, when the court suggests, not they have to be agreeable to sit and talk. There's no difficulty.
We can direct even reference in the FDP also, because this matter arises out of execution arising out of FDP.
No, no, executing arising from that LAC proceeding.
LAC, my lord. FTP. In fact, your lords may just have a
But anyway, that has some, yes.
one judgment, my lord, my learned friend started saying, my lord, oh, final preliminary decree, or the final law. Even a preliminary decree can be, my lord, final also. In this case, my lord, to the extent of, my lord, that property, my lord, in Bendiganahalli, it's become final. Please look at paragraph 8 of this judgment.
Your contention that there was a acceptance of the
Correct,
arbitral.
correct, my lord. That is, my lord, they are, my lord, speaking of estoppel. Paragraph 8 bani. Idralli.
Estoppel, because they had contained in their.
No, lord, ಮೂರ್ ಸುಟ್ಟಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
But what was the finding? Whether their statement by because.
Lord, what happens is,
And I was
if
not.
they
aware
don't
of the
contest
recording
the,
order.
Lord, if they don't contest the case properly, why, I can't be blamed. I did not, my lord,
If I
contest
am,
it.
if I am not even aware, my lord, of what has
Look at
happened.
paragraph 8. There can be more than.
I was not aware of the order of the court. The court order, my lord, it was pointed out to me later. Court order, I was not aware, which rejected the arbitrator's report. I was not aware of it.
Not,
I was-
not that.
Ah.
This, it was being submitted or said. There were two other proceedings between the parties.
Yes, my lord.
That brother Appaswamy
Correct,
and
correct.
who's that Ramaswamy.
Yes, ma'am.
In
ಅದರಲ್ಲಿ
both
ಡಿಗ್ರಿ ಆಗಿ
proceedings.
that, my lord, final decree proceedings or final decree proceedings ತಗೊಂಡಿದ್ದಾರೆ.
Correct, not there itself, my lord, I have not been aware of this court order. The court order, my lord, which rejected the arbitrator's report.
Contended that final decree proceedings are concluded, I mean.
No, I have not said
concluded
final decree
by
proceedings are concluded.
acceptance And one of the parties.
Final.
signed
That is based on the arbitrator's report.
a statement saying that, not
Correct.
arbitrary. It was pointed out.
Yes,
it
my lord.
was read out.
That is
for
based
us,
on the arbitrator's report.
Not arbitrary.
Arbitrator's report. The order of the court which rejected that, I was not aware.
Not order.
Ah.
In
That is
plead-
arbitrator's report.
In pleadings, it was contended that the parties
Yes.
have consented.
That is based on the arbitrator's report.
Lord, they are in possession. They, my lord, each one of them is enjoying absolutely, my lord, selling properties. They also know about it. They agree to all that. And thereafter now come and say,
Brothers and brothers' children are in possession, but daughters and
Yes.
daughters'
no, my
children.
lord, what has happened is, daughters, so the brothers, the other two brothers, my lord, and Muni Swamis, they are asking. That, my lord, we did not contest it as far as we are concerned. We have not denied their share also. Please come to, my lord, paragraph 8.
Better alva idu adin.
No, we are ready for
There
us, we have not said, my lord, we are ready to
There
talk.
can be
There's
more
no
than
difficulty.
one.
Paragraph 7, my lord, if your lordship sees, para 7. Preliminary decree declares the rights and liabilities of the parties. However, in a given case, sorry.
ಅಲ್ಲ, ಹಾಗೆ.
ಕೊಡ್ಲಿಲ್ವಾ ನಿಮಗೆ?
ಏನ್ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ ಇದು preliminary decree, my lord, 7 declares the rights and liabilities of the parties. However, in a given case, a decree may be both preliminary and final. There can be more than one final decree. A decree may be partly preliminary and partly final. In this case, part of it, my lord, is final. Because that's why, my lord, they also, my lord, in their suit say, yes, there is. Otherwise, my lord, look at their schedules also. They ask, my lord, only in respect of this, excluding, my lord, the Bendiganahalli property. Therefore, this judgment, my lord, the judgment that my learned friend has given has no application. That's all.
That's all your submission, no?
Not only last submission, which I have already made, madam. If at all, my lord, the trial court had to hold, or if your lordship had to hold, my lord, that the application is not maintained for whatever reason,
Slowly.
then not, there cannot also be a finding that time not on merits. That cannot happen.
Not fine.
That's-
If application is.
Maintainable, then
maintainable, nothing.
Naturally,
it's-
correct. Because the trial court will not, your lordship saw, made that, will not,
Go and find some other case in that.
I do not want to, not, this is the,
We can foresee that.
that should not be done, my lord. That's why, my lord, I objected here. Because this is the full-fledged inquiry.
Your ear must be all round.
I wanted this inquiry, I had filed an application.
Nalla. What about any inclination for?
We are ready, my lord, as your lordship suggested.
Full, my lord, mediation ಕಳಿಸ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ. We have no objection. The FDP proceedings. Correct. ಇದರಲ್ಲಿ, my lord, please look at this aspect also.
ಇದರಲ್ಲಿ
ಸ್ವಲ್ಪ ಇಲ್ಲಿ ಹೇಳು.
And if once we refer to the mediation, everything should be.
Yes.
I mean, status quo.
Yes.
ಅಂದ್ರೆ ಅಲ್ಲಿ 26 ಜನ ಇದ್ದಾರೆ. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಇದು ಸ್ವಲ್ಪ ಹೇಳೋದು ಕೇಳ್ತೀರಾ ನೀವು? ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ FTP ನಲ್ಲಿ?
ಅಲ್ಲಿ ಇದೆ ನೋಡಿ a petition.
I'm not, if
There are
lordship had to
lot-
order, not all of them to go, we'll go, my lord. There's no
70
difficulty.
people. 70 ಜನ ಇದ್ದಾರಂತೆ. ಮತ್ತೆ ಅದು
Otherwise, all right, we'll pass orders on this.
ಆಯ್ತು ಅಷ್ಟೇ ಅಂತ
ಅಂದ್ರೆ
ಕಾಣ್ಸುತ್ತೆ.
you have to
70
give us
ಇದು
one
ಕಪ್ಪೆ ತಕ್ಕಡಿಗೆ ಹಾಕಿದಂಗ ಆಗುತ್ತೆ 70 ಜನ ಅಂದ್ರೆ.
ಹಾಗೆ ಆಗೋದು.
Then my lord, all of them will not, they're all branches of the family, therefore perhaps one or two will be the decision makers from that, but
I
The
believe.
presence is required alwa.
of course, madam.
ನೋಡಿ ನಿಮ್ಮ
That when your lordship is referring to mediation,
They have to give one power of attorney at least to some.
that will not, if once the settlement, if there is settlement happening, then my lord, that will be ensured at that stage.
You give us one compilation.
My lord,
Yes, my lord, we'll prepare it. We'll sit together and give you a lot.
Not
Yeah,
will.
tomorrow.
Please.
In the meantime, if the parties agree, let
Right,
them
no.
indicate so that we can refer it to.
But from our side, my lord, as lordship, my lord said, we should be ready, my lord, we should be ready for mediation. There's no difficulty.
ಯಾಕಂದ್ರೆ ಅದು FDP ಒಳಗಿರೋ parties ಎಲ್ರು ಇಲ್ಲಿ ಇದ್ದ ಹಾಗೆ.
ಇಲ್ಲ 70 ಜನ ಇದ್ದಾರೆ. And everybody ಅಲ್ಲಿ ಬೆಳಿಗ್ಗೆ ಅಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು. It's like a ಜಂಬೂರಿ ಇದೆ.
Everybody's, the other day we settled one matter. ಎಷ್ಟು 29 members ಇದ್ರಲ್ಲ, ಬೇರೆ ಬೇರೆ ಕಡೆ ಇದ್ದವ್ರನ್ನೆಲ್ಲ ಮಕ್ಕಳನ್ನ ಎಲ್ಲಾರು ಕರ್ಕೊಂಡು ಬಂದು ಸೆಟ್ಲ್ ಮಾಡಿದ್ರು ಅವರು.
ಓ.
Because sometimes parties will be fed up with the litigation. Joint family court ಅಲ್ಲೇ ಇಲ್ಲೇ ಮಾಡಿದ್ವಿ.
Oh. It's really
That also,
heartening.
my lord, we are, as a lordship, my lord, whatever your lordship, my lord, feels is the appropriate way, we will.
ಇಲ್ಲ. So it has to be.
ಅಲ್ಲೇ
Very good, my lord, your lordship could,
ಆಯ್ತು ನೋಡಿ.
however, my lord, your lordship feels. From our side, my lord, we have to.
Or even if we dispose this application, we can say that parties shall go for me. ಅದೇ mediation ಹೋಗೋದಕ್ಕೆ ಅವ್ರ consent ಇಲ್ಲದೆ ನಾವು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಸರಿ. ಆಮೇಲೆ
Mediation
ಸುಮ್ನೆ.
Whether here there are only few parties.
Understood.
Please.
Only 2 parties here, my lord. The other 68 are not there.
My lord, some of them here are actually, my lord, notices not gone.
ಹೌದಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನೋ ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಮೇಲೆ ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ತಿದ್ರಿ, ಅದ್ರ ಮೇಲೆ ಬಂದಿದೆ. That was
That
an
application
ಎಷ್ಟು serial number?
47.
47. ಇಲ್ಲಿ respond number 1 ಇದು ಯಾಕೆ why we started hearing is because
But
you are
2 and 3 may not be,
Give up
they may not be there. Are they
insistence
contest?
for R3.
I think, my lord, they will just watch it from this side like this.
Metro.
They land acquisition officer.
That also may not be required, my lord, they may not have anything.
Land
to
acquisition
say.
officer ಅವರೇನೆ.
Land acquisition
government.
officer ಅವರು HCP ಅಲ್ವಾ?
They may not have anything to say on merits.
ಅಲ್ಲ, ಇನ್ನು ಒಂದು ಮೆಮೋನರ್
No, maybe we will not, your lordship may dispense with notice, but not we'll file it.
ಇಲ್ಲ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲೇ ಒಂದು ನೋಟಿಸ್
That is also not.
ಅಷ್ಟೇ ಅಷ್ಟೇ.
That is also, yes.
ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಅಷ್ಟೇ ವಿಶ್ವೇಶ್ವರ
ADB ಅಲ್ಲ. ADB ಅಲ್ಲ. Land
ಟ್ರಯಲ್
acquisition.
ಕೋರ್ಟ್ ಅಲ್ಲಿ
Government advocate ಗೆ ಹೋಗುತ್ತೆ, my lord.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೂ ಹ್ಯಾಡ್ ಅಪಿಯರ್.
ಇಲ್ಲ,
I'm not saying that. Lordship sees page 24, my lord. The cost
Okay,
at least.
ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಈಗ ಇಷ್ಟೆಲ್ಲ
Very well, my lord, your lordship, page 24, my lord, they are the only 2, my lord.
ಅಬ್ಸೆಂಟ್. JDR ನಂಬರ್ 1 ಹೂ JDR ನಂಬರ್ ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಅವರೆಲ್ಲ ಅಬ್ಸೆಂಟ್ ಆಗಿದ್ರೆ ಇಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕ್ಬಡಿ
Please,
ಆಗಿದೆ.
not we'll file a memo, my
He
lord.
is made JDR number 2 here. I'm sorry,
Yes.
respond number 2 here.
Yes.
Anyhow, respond number 3 is appearing. ಅವರೆಲ್ಲ ಅಬ್ಸೆಂಟ್ ಇದ್ರೆ ಇಲ್ಲೊಂದು ಮೆಮೊ ಹಾಕಿ
Very.
ಅಂತ ಬರ್ಕೊಳ್ಳೋಣ.
Please,
ಈಗ
please,
ನನಗೆ ಇವತ್ತೇ
we'll not will.
Yes.
Hello, counsel for the appellant submits memo for dispensation of notice to respond number 2. The records show that respond number 2 had not contested the matter before the executing court. Considering the same, notice to respond number 2 is dispensed with as prayed for. Memo file ಮಾಡಕ್ ಹೇಳಿ ಅವ್ರಿಗೆ.
Not we'll be doing it now. It's
Hard further ಈಗ ಮತ್ತೆ no further hearing.
ಏನಿಲ್ಲ.
Only
ನಮ್ಗೆ ಬಿಟ್ರೆ
only the compilation, not which will.
counsel seeks time.
ಕಂಪೈಲೇಷನ್ ಹಾಕ್ತೀವಿ. ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಒಂದ್ ಕಂಪೈಲೇಷನ್.
Consolidated compilation.
Yes, yes.
Their documents,
ಎಲ್ಲ ಒಂದು
petitions. Plus.
ಸಬ್ಮಿಷನ್ಸ್ 2 ಬೇಕಾಗುತ್ತೆ.
ತಗೊಂಡಿದ್ದಾರೆ. ಅಲ್ಲ ನೀವು ಒಂದು ಕನ್ಸಾಲಿಡೇಟೆಡ್ ಕೊಡಿ, ಅವರೊಂದು ಕನ್ಸಾಲಿಡೇಷನ್
ಆಗ್ಬೋದು. ನಮ್ದೊಂದು
ನೀವು ಒಂದು ಕನ್ಸಾಲಿಡೇಟೆಡ್ ಕೊಟ್ರೆ he can refer to that page number, those page numbers
Very
only. Either of you.
Please.
ಹೇಗ್ ಮಾಡ್ತೀರಾ?
My lords, if I can
Our
make
lords,
one submission, my lords. Our documents are all part of the statement of objections, and we have only filed one additional document, my lords, and one separate case law compilation. And 90% of the documents which they refer are part of our document. Few additional documents, my lords, they may file it by an additional, whatever is missing in our thing, they may file.
Make it as a we'll give it to you.
Illa, sir, the problem will be, my lords has marked it. Then
ನೀವು ಕೂಡ
every marking will have to be done afresh.
ರೆಫರ್ ಮಾಡುವಾಗ ಆಯ್ತು ನಿಮ್ಮದ್ರಲ್ಲಿ, because we have to see once here, but still it's okay. You do one thing, you make one compilation of your documents, written submissions and dates,
do
events, whatever you have
Please.
given.
I'll do
To
that.
make your one,
Very.
Together, all they
Yes,
should be.
Yes, my lord. There's a
My lords, can you
confusion
keep the
confirmed.
judgment separate, my lords?
No, no, no. Consolidated compilation of their antavaka. Consolidated.
Respective
consolidated-
parties.
The documents, copies of the documents, actually the copies of documents, the written submissions and list.
My
of,
lords,
citations.
submissions and judgments may be in volume 2, documents may be volume 1. Hange ಹೇಳ್ಬೋದು, my lords.
Now we have given with this, now we have produced only one document extra, you say. This, that.
No, 7
That
documents.
order of the court accepting the
That's
interim
part of the
award is
statement.
part of this. Or
Yes, yes, statement
is
of
there?
objections.
What is that additional document you gave?
My lords, that what senior relied on today, my lords, those are the other correlated suits, my lords, parallel suits that are
Filed by
unplain.
Grandmother.
Judgments. They are undisputed,
Undisputed.
documents. No. Judgments in the other suits are all undisputed documents. You can make one compilation of that. One consolidated, consolidated compilation of the documents, written submissions and citations respective.
Citations ಅದ್ರೊಳಗಡೆನೆ ಹಾಕ್ಬೇಕಾ? Citations ಬೇರೆ ಬೇರೆ.
Written sub, ಇದ್ರಲ್ಲಿ ಈಗ ಇದು ಕೊಟ್ಟಿದ್ದೀರಾ?
Hmm.
This, you are
Yes.
going to now give another compilation of document, written submission and this.
Okay, ಅದನ್ನ
You make the written submission first,
yes,
citation written, below that keep that document.
document. Yes,
You can also do like.
very well. You want
When should we list
You
it?
ಗೊತ್ತಾಯ್ತು ಸಾಹೇಬ್ ಹೇಳಿ.
Tomorrow
Tomorrow?
we'll file it.
ಆಯ್ತು, ಡೇ ಆಫ್ಟರ್ ತಗೊಳ್ಳಿ ಮತ್ತೆ ಸುಮ್ಮನೆ ಆಮೇಲೆ ನಾಳೆ ಆಗಿದೆ
Day after, no, you have it.
Day after.
ಡೇ ಆಫ್ಟರ್.
My lords, could I request one thing, my lords? What is in the statement of objections, I will not duplicate. Only,
Duplicate.
I will not
means
duplicate what is in the
again
state.
it causes
Yes,
conflict
madam.
for us.
So only the judgments, written submission, additional I will keep in one separate, my lord.
First your written submission,
Judgment.
next to that citation, next to
Yeah.
that your document.
Yes,
Yes.
one compilation. Correct.
Yes.
But we had one request, my lord. There was an interim order which was in force before it was referred to your lordships. No? We only were not requesting that let them not change the status in between.
ಆಯ್ತು,
Not
ನೀವು
till your
ಅದನ್ನ ಸುಮ್ನೆ ಏನ್ ಮಾಡ್ಬಿಡಿ.
lordships.
ಏನದು? Not withdrawing the amount.
Yes, madam. Matter before the executing court is pending.
Extend your, this thing?
My lord,
The
the
interim order
interim
not
order
till-
was not extended, my lords, on the last date.
No, no.
That was because it was placed before your lordship.
That case is fixed now.
28/10, my lord, is the date, next date.
28 and then how do they?
Let them not add, because
We would
earlier there was an advancement
My
which was
lord,
made.
on our
Therefore,
older
that's the
undertaking, we won't advance.
Please.
My lord, he can take my word on that. On our older undertaking.
My lord,
we won't
an
advance it.
assurance from them is sufficient, my lord, for, so that, my lord.
Not, recording is not necessary.
After 60.
My lord, I don't think, my lord, we'll
Yes.
go by their assurance, my lord.
Yes. ಅಲ್ಲ ಇಲ್ಲಿ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಯಾರು ಇರ್ತಾರೆ ನೋಡ್ಕೊಳ್ಳಿ ಮತ್ತೆ.
No, my lord, we have, my lord, we are.
In the trial court.
That's important, my lord. Trial court, tell them not.
ಆಯ್ತು, my lord, I've instructed, the party is here, we have told him.
Okay.
And we'll tell the lawyers also.
In some of these things we have marked.
Please.
For our reference.
Please.
ಆ ಮಾರ್ಕಿಂಗ್ ಇರೋದನ್ನೇ ಹಾಕ್ಬಿಡಿ, ಬೇರೆದ್ ಹಾಕ್ಬಿಡ್ಬೇಡಿ
ಆಗ
ಯಾಕಂದ್ರೆ.
ಆಯ್ತು.
Very well, then we will take that and, very.
My lord, then we'll do it in court itself, my lord.
ಇದು ಬೇಡ, ಅವ್ರು ಫಸ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೇನ್ ಕೊಡೋದು ಬೇಡ. ನಾವು ಬೇರೆ ಹೇಳಿದ್ವಿ.
My lords, if I can, from my side, my lords, I'll just, statement of objections adirodana, if my lords can mark it as volume 1. Volume 1, then my lords, today we filed some I'll just clarify it, man.
We said whatever is given is okay, you now, when.
My lords, then there won't be need to file anything, and I'll just explain, my lords, ಅದನ್ನ volume 1 ಅಂತ mark ಮಾಡ್ಕೊಂಡ್ರೆ, today there was one. I'll do that, my lords, I'll just do that.
Don't put the heart. Yes.
Not grateful, my lord, we have.
Please, my lord.
Take it in lordship's time.
Bill number 48, ಇದು half dictation ಆಗಿದೆ.
ಓ, ಇದು ಹಾಫ್ ಡಿಕ್ಟೇಷನ್ ಆಗಿತ್ತು, 458 ಆಗಿದೆ ಅಲ್ಲಿ. ನಾಳೆ ಹಾಕೊಳ್ಳೋಣ, ಅವರಿಬ್ರು ಇದ್ದಾರೆ.
ಆಯ್ತು.
ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಟುಮಾರೋ. ಟುಮಾರೋ. ಫೈನಲ್ ಡಿಸ್ಪೋಸ್ ಅಲ್ಲ, ಇಲ್ಲ ಡಿಕ್ಟೇಟೆಡ್ ಪಾರ್ಟ್ಲಿ ಅಂತ ಮಾಡೋಣವಾ? ಇಲ್ಲಾಂದ್ರೆ ಹಾರ್ಡ್ ಫರ್ದರ್ ಅಂತ ಮಾಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಇದನ್ನ ಹಾರ್ಡ್ ಬೋತ್ ಸೈಡ್ ಇದ್ರಲ್ಲಿ IML ಆರ್ಡರ್ ಆಗೋಗಿತ್ತಲ್ವಾ? ವಿ ಆರ್ ಡಿಕ್ಟೇಟೆಡ್ ಡಿಲೇ ಕಂಡೋನೇಷನ್.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಓನ್ಲಿ ಫ್ಯಾಕ್ಟ್ಸ್ ವರ್.
ಇದು ಹಾರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಮಾಡು. ಮೇಲ್ ಹಾಕಿಸ್ಬಿಡಿ ಅದನ್ನ.
ಆಯ್ತು.
There are 3 matters. Yes. Next ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ.
Your lordship, serial number 69, your lordship had listed it for serial number 49.
49.
ಏನು ಹೇಳಿಲ್ಲ ಮೇಡಮ್.
ಇದ್ರಲ್ಲಿ ಏನು ಹೇಳಿಲ್ವಲ್ಲ? ಏನದು 49. Due to paucity of time, adjourned ಎಡ್ಜೆಂಟ್ ಅಷ್ಟೇ ಬರ್ಕೊಂಬಿಡಿ ಆಮೇಲೆ
51
51
ಯಾರು ಏನು
ಆಲ್ಸೋ ಅದು ಸೇಮ್
53 21 10 ಕೇಳಿದಾರೆ
53
21 10
as requested list on 2110
21 10 54 22 10 ಕೇಳಿದಾರೆ
ಆಯ್ತು as requested list on 2410 2210
22 10 56 25 10 ಕೇಳಿದಾರೆ
56 as requested list on ಎಷ್ಟು
25 10
2510
Short accommodation.
ಮತ್ತೆ ಯಾರು 2510 ಗೆ ಅಂತ ಕೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಬಿಫೋರ್ ವೆಕೇಶನ್ ಅಂತೂ ಆಗೋದಿಲ್ಲ ನೋಡ್ತಾ ಇದ್ದೀನಿ
56 ಅಪಲೆಂಟ್ ಕೇಳಿದಾರೆ
ಅಪೆಲ್ ಅಂತ 2510
58 16 10
see now we are told date given matters in 2 weeks after vacation 60 matters already ಆಗಿದೆ ಅಂತ yes yes 57
58 ಮೇಡಮ್ 58 16 10
1610 as requested list on 1610
59 ಏನು
I appear
ಹೇಳಿದಾರೆ
for the appellant, my lord, 59. It may be fixed on 21st or 22nd, my lord.
list on
2210
21 or 22, my lord.
22 10
2210
Obliged.
60 29
60 2910
16.
29 10 ಅಂತ ಬರ್ತಾರೆ
2910 ಅಂತ ಹೇಳಿ ಹೋಗಿದ್ದೀರಂತೆ ಮೊದಲು
ಇಬ್ರು ಹೇಳಿದಾರೆ
ಅಲ್ಲ, ಅದಕ್ಕೆ-
ಇಬ್ರು
I am appearing for appellant.
2910 ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಅಲ್ಲ 2021
61 ಏನು ಹೇಳಿದಾರೆ
And they have it on 29th or 30th.
61
61. October 29th or
list on 2910 29
Obliged.
62
62 ಏನು ಹೇಳಿದಾರೆ
ಏನು ಹೇಳಿಲ್ಲ ಎಡ್ಜೆಂಟ್ ಅಂತ ಅಷ್ಟೇ ಇದು ಟು ಫಸ್ಟ್
63
ಫಸ್ಟ್ 10
21 10 ಅಂತ ಹೇಳಿದಾರೆ
2110
64 24 10 ಕೇಳಿದಾರೆ
64 as requested list on 2410
65 ಏನು ಹೇಳಿದಾರೆ
ಎಡ್ಜೆಂಟ್ ಟು ಫಸ್ಟ್ 10
66 ಏನು ಹೇಳಿಲ್ಲ ಮೇಡಮ್
ಅದು ಅಷ್ಟೇ ಇಬ್ರು ಇಲ್ಲ
67 16 10 ಕೇಳಿದಾರೆ
1610 as requested list on 1610 67 ಅದೇ ಜಾಸ್ತಿ ಇದೆ ಅಲ್ಲ
230 matter
Will also be in 230 matter, I am appearing for the appellants. We are ready to make submission.
we
Monday,
are not ready to hear you now
Monday, if it may be taken up, your lordship.
2410 yes
Or 17th, your lordship, 17th.
17th is a holiday
17th or 18th.
18th is a holiday 19th is not
18th ಹಾಲಿಡೇ ಇದೆ ಅಲ್ಲ
ಮೇಡಮ್ ಅದು
18th 19th is Saturday okay
22nd, your lordship.
22nd on 22nd ಯಾವುದು ಶೀಟ್ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ ಹಳೇದು ಬೇರೆ ಇನ್ನೂ ಇದೆ ಎಲ್ಲ ವರ್ಷದಲ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ಬೋದು ಮೊದಲು ಅಷ್ಟೆಲ್ಲ ಲಿಸ್ಟ್ ಆಫ್ ಕಂಪೈಲೇಷನ್ ಅವನು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಅವರು ಕೋರ್ಟಲ್ಲಿ ಕೊಟ್ರಲ್ಲ ಇಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ಕೊಟ್ಟಿರೋದೆಲ್ಲ ತಿರುಗಿ ಕೊಡಿ ಅದು ಮಾಡ್ಕೊಡಿ ಎಲ್ಲ ಇನ್ಹೆರಿಟ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಎಲ್ಲಾನು ಬರೀ ಲಿಟಿಗೇಷನ್ ಫೈಟ್ ಮಾಡೋದಕ್ಕೆ ಖರ್ಚು ಮಾಡೋದ ಆಸ್ಕ್ ದೆಮ್ ಟು ಗೋ ಫಾರ್ ಮೀಡಿಯೇಷನ್ ಆಯ್ತು